Honorable Chief Guests, distinguished dignitaries, esteemed colleagues, and my dear friends. Good morning and a very warm welcome to all present here today. My name is Adya, and I'm a practicing advocate and a member of the Indian National Bar Association. I'm extremely grateful for the opportunity to welcome you all today to celebrate the 75th Constitution Day. honorable chief guests, distinguished dignitaries, esteemed colleagues, and my dear friends. Once again, a very good morning and a warm welcome to all present here today. My name is Adya, and I'm a practicing advocate and a member of the Indian National Bar Association. And I am so grateful for the opportunity to welcome you all today to celebrate this special occasion of the 75th Constitution Day. On this special occasion of Constitution Day or Law Day, we come together to celebrate and reflect on the importance of law in our lives and the cornerstone it provides for justice, fairness, and equality in our society. This day marks the adoption of the Constitution of India, which came into effect on 26 November 1949 and was later enacted on 26 January 1950. It is therefore a day of immense significance in the legal and constitutional history of our lives. Today, we must all remind ourselves that as citizens of this nation, not only do we enjoy a lot of fundamental rights, but we also owe a responsibility to this nation, and we have fundamental duties towards it. We must remind ourselves of the profound responsibility that law holds in shaping our democratic fabric and the role that each one of us plays as legal professions, citizens, or lawmakers. The Constitution of India, which provides the framework for the country's legal system, guarantees fundamental rights, equality before law, and the protection of personal liberties, ensuring that no one is above the law. Lawyers, judges, legal experts are the custodians of the Constitution, and every day they interpret it, uphold the principles enshrined in it, and ensure that justice is not just a theoretical idea, but a practical reality for every citizen of our country. But the responsibility doesn't end at the courtroom. Law is a living, breathing entity that requires constant nurturing and evolution to keep in pace with societal changes. So today, as we celebrate Law Day, it is also an opportunity to remind ourselves that the fight for injustice is ongoing, and we must continue to strive for a society where human rights are respected, where discrimination is eradicated, and where the rule of law prevails over all forms of injustice. With that being said, I'd like to share a few words about the Indian National Bar Association and the reason that we are all gathered here today. The Indian National Bar Association, or INBA, is a non-governmental association endeavoring to act as a premier body representing the interests of the Indian legal community and to strive to provide several economic and social benefits that should accrue to them. INBA also aims at reforming the Indian legal system, leading to effective and quick justice for everybody, and reforming the Indian governmental bureaucratic rules and regulations, and leading to the nation's economic and business growth. INBA has a global reach and membership, as it was constituted by leading advocates, attorneys, eminent judges, multinational corporate and business law firms, legal fraternity, professionals, and senior government officials, as well as law students, NGOs, litigants, and law publishers. INBA achieves its goal by providing opportunities for legal education, seminars, and networking, as well as does a lot of pro bono work and public interest litigations. INBA also enjoys a strong and productive relationship with the Indian government and the Indian judiciary. I am extremely grateful to have been collaborating with INBA over the past few years, and I'm thankful for the support and guidance offered by Kaviraj sir and Vinakshi ma'am. Without further ado, I would like to welcome our guests of honor for today. First, I'd like to welcome our honorable chief guest, Justice K.G. Balakrishnan. Justice K.G. Balakrishnan is a prominent former Chief Justice of India and a distinguished jurist who plays a significant role in the Indian judiciary. Sir started his legal career as a practicing advocate in the Kerala High Court in 1968, specializing in civil, constitution, and labor law. Justice Balakrishnan was appointed as a judge of the Kerala High Court in 1985. His tenure as a judge was marked by his integrity, commitment to justice, and insightful judgments. He was later elevated to the Supreme Court of India in 2000. During his tenure as a Supreme Court judge, he handled several significant cases and was known for his focus on human rights and social justice. Justice K.G. Balakrishnan served as the 38th Chief Justice of India from January 2007 to May 2010. And as Chief Justice, he presided over several landmark judgments, and he was particularly noted for his progressive judgments related to human rights, social justice, and women's rights. He was instrumental in promoting judicial transparency and accountability and advocated for the reforms in the Indian legal system to make justice more accessible to the common people. And after he retired as the Chief Justice in 2010, he served as the chairperson of the National Human Rights Commission. He continued to be active in public life, contributing to the developments of legal principles and engaging in various academic activities. Now I would like to welcome P.K. Malhotra, sir, who is a respected figure in India's legal community. His long and distinguished career, particularly his tenure as Additional Solicitor General of India, left a significant mark on the field of constitution and administrative law. His contributions continue to be valued by legal profession, and he remains an influential figure in discussions regarding the future of India's legal and judicial system. Sir is a prominent Indian jurist who has held significant positions within the Indian legal system. He began his legal practice in Delhi, where he specialized in constitutional law, commercial law, and corporate law. He was designated as a senior by the Supreme Court of India in 2005, post which he served as the Additional Solicitor General. In this capacity, he served and represented the Government of India in various important cases before the Supreme Court and the High Courts. Throughout his career, he was involved in several landmark cases, particularly those concerning constitutional law, governance, and civil rights. His legal acumen has made him one of the most key figures in the field, particularly when it came to defending the interests of the government. Sir also served as the Secretary of Department of Legal Affairs in the Ministry of Law and Justice. In this role, he was responsible for overseeing legal affairs in the central government, including representation of the government in courts, handling legislative matters, and advising on legal issues. He played a pivotal role in India's constitutional framework and was regularly involved in advising the government on several important policy matters. Kaviraj sir, who will be joining us shortly, I'd also like to quickly welcome him, as he is the founder and Secretary General of the Indian National Bar Association. This organization is his brainchild, and his vision has always been to provide the highest quality services to his clients and cater diversified legal requirements. Along with providing top-notch legal assistance, he is also a philanthropist and a supporter of pro bono work, as well as a mentor to many young budding lawyers of this country, such as myself. His passion is to mark a presence in the Indian legal fraternity around the world, and it's reflected by his various professional affiliations, as well as numerous global publications. I would also like to welcome Mr. Prateek Gandhi, ex-member Parliament, who has also graciously accepted to grace us with his presence today. Now, before we all light the lamp, I would like to invite us all to stand as I recite the preamble of the Constitution of India. The preamble is the cornerstone of the Constitution, and it reads as follows. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them fraternity, assuring the dignity of individual and the unity and the integrity of the nation. In our Constituent Assembly, This 26th day of November 1949, we hereby adopt, enact and give to ourselves this Constitution. Thank you very much. I would now like to invite our chief guest and guests of honor to kindly light the lamp and commemorate this special occasion. I would now like to invite Justice Balakrishnan to kindly share a few words with all of us.
Mr. P.K. Malhotra, Mr. Pradeep Gandhi, Meenakshi Singh, and other distinguished guests. You are the young lawyers, I believe. You are all young lawyers practicing in the Delhi courts. Delhi is a good place to have legal profession. So that is, I'm happy that you are here. This Constitution Day we are celebrating. For us, it is very, very important day for the Indian citizens. We have adopted the Constitution that created a new scenario for this country. You just, the importance of the Constitution, I'm not dealing with the going into the various provisions, which is very, very important. But you see our neighboring countries. You just, I don't want to name them. All these neighboring countries withered away. Their Prime Minister resigned, the President went away, he was driven out. All this happened. They don't have a good constitution. But whereas India, every year we had a perfect electoral system. We changed the ministry by after a profound way of election. And nobody could point out anything about our electoral system, about our judiciary, about our Public Service Commission. All these, our constitutional authorities, their contours of powers are very delineated in the Constitution. So, it is working well. So it withstood not simply the Constitution was there for 70 years. It controlled the human various, not only the legal system, but the every activities of the human being, of the citizens of this country were controlled properly by the Constitution. It's a wonderful document. No other country has got such a system where it is fully controlled. Our rights, our duties, our various constitutional machineries, all functioning well just because of this document. Is carefully drafted. But of course it is continuous, not simply a document, it's a dynamic document. It would be interpreted by the court every now and then, giving various forms of giving life and energy to each provisions of the Constitution. That is important. That is, it is growing. It is dynamic. The provisions are dynamic in that sense, not a dead letter, the spirit. The Constitution is a living document. It grows. It determines the rights of our valuable rights. It protects our valuable rights, our duties and all. And we should be proud. And while presenting the Constitution, Dr. Ambedkar made a very historic speech. So he said, we have reached a political democracy, equality in democracy, but social equality is still we have to achieve. That is, we are working for that social equality. Every citizen should be equal in all respect. That is the message of the Constitution while presenting the Constitution to the Constituent Assembly. So as we are Indians, we don't I understand the importance and significance of this Constitution, but it is a wonderful document. Controls the humanity, the citizens of this country. Well, take care of our rights, duties, everything. That we are celebrating the Constitution Day. Is continues today. Earlier it was not the practice of this much of function, but today the Parliament, the judiciary, all various organizations are celebrating the Constitution Day. That is very, very important for Indian citizen. And I congratulate this organization also for having such a meeting, inviting all the guests. And I wish all especially the law students or the young lawyers a bright future. You can, without any hesitation, you can thrive well in in our legal system. It's one of the best legal system, one of the best. Indian judiciary also is respected throughout the world. That is one thing which I visited almost all the important the courts. They have all great respect for the Indian judiciary because we are dealing with the large number of cases daily. Judges are doing very, very hard work to protect the rights of the people. That is the importance. That is respected throughout the world. Thank you once again for having invited and to present on this occasion. Thank you very much.
I would now like to humbly invite Mr. P.K. Malhotra to speak a few words on this special occasion.
My Lord, Honorable Mr. Justice K.G. Balakrishnan ji, former Chief Justice of India and former Chairman former Chairman of the National Human Rights Commission, Pradeep ji, former Member of Parliament, dignitaries of the dais, delegates, participants and dear students. आप सबको 75 वर्ष संविधान के पूरे होने की बहुत बहुत शुभकामनाएं। 75 years in the life of an individual is too long a period. He is called a senior citizen and he should go to Vanprasth at that time. But 75 years in the life of a country or in the life of a constitution is too small a period, because during these 75 years, he has matured enough from the beginning to that day to say that, okay, today I am a matured person, and that is why today we call India as mother of democracy. And we have a constitution which is, as Honorable Justice Balakrishnan ji has also said, is a living document. The biggest constitution any country has in the world, India has it, and it has tried to incorporate all the important elements which are required for running a country, because all organs of the government, they derive their authority from this constitution. Neither the legislature is supreme, nor judiciary is supreme, nor executive is supreme. It is the constitution which has given power to all these three organs which is created by the constitution. And who is supreme? We, the people of India. We read the preamble right now. And the preamble says, we the people of India are giving this constitution to ourselves and creating a government and organs of the government, and how these organs of the government will discharge their function, we are defining in this constitution. And if a government is not discharging its function in accordance with the provision of the constitution, we retain to ourselves the power to have another government after 5 years. 5 years is the tenure given to the government. So I think we have a very good constitution. But since we are today celebrating the 75th year, 75 years of the constitution, may I tell you that it was only in 2015, that is 10 years back, that the government came out with a notification, formal notification, saying that 26th November every year will be celebrated as a Constitution Day. Prior to that, it is only the legal fraternity people, maybe the advocates, maybe the courts, or some educational institution, they were celebrating it as a law day, not as a Constitution Day. And Constitution becomes very important because every citizen of the country who is governed by the provision of this Constitution must know what it is. And more particularly, the students of law, not only the practitioners of law, but the students of law also read it as their Bible, Quran, or Gita. As they recite Bible, Quran, or Gita, similarly, they should remember the provision of the Constitution as they remember their religious books. For the simple reason, because this country is run as per the provisions laid down in it, and all the three organs, they function, they discharge their functions in accordance with the provision of this Constitution. The theory of checks and balances which have been incorporated in this Constitution, because it gives power to the executive to implement the law, legislature to make a law, and the judiciary to interpret the law, and if any law is not made in accordance with the provision of the Constitution, then obviously the judiciary can change it. Therefore, sometimes there is a misconception among the people who are not aware about the jurisprudence of the Constitution that judiciary is supreme. I may make it again clear that as a student of law, what I feel, all organs of the government, there is a check and balances on their power. If the judiciary has also done something which is not in accordance with the spirit of the Constitution or in accordance with the wishes of the common man, then the elected representative sitting in the Lok Sabha or Rajya Sabha, they can change that law and bring a new legislation. So I think this theory of checks and balances in our country is working very well. And more particularly, I generally say on all public platform, and I repeat it here, the fundamental rights which are given to the individuals and the directive principles of state policy which are direction to the state to carry out the objectives which are shrined in the preamble of the Constitution, I think they are the basic structure of the Constitution. Of course, the basic structure theory laid down in the Keshwanand Bharati case is much larger. It deals with other aspects also. If fundamental rights and directive principles are the heart of the Constitution. The preamble is the soul of the Constitution. And I think combined together, we carry out the objective in accordance with the principles which are laid down in the Constitution. I think the framers of the Constitution, 295 in number, of course the original number was much larger, but after the partition, those who were representing the territory which went to the Pakistan, they shifted to that side. The rest of them, they drafted this Constitution after deliberation for almost 3 years, to be precise, 2 years, 11 months and 70 days. And during this period, let me share with you, those who are doing still law may not be familiar with all this background. India is called Mother of Democracy because of its ancient tradition of democratic governance, deeply rooted in the Vedic period and reflected in various societal structure that emphasized participation, consultation, and collective decision making, which is reflected in the Constitution. And sometime it is said, the Constitutional Assembly, it mainly relied on the provision of the Government of India Act 1935 and certain practices which were prevalent in the developed world, that is US Constitution, Australia's Constitution. No, yes, we have taken the best practices available in those constitutions. But if you look at the scheme of the Constitution, all our earlier ancient principle, and if you look at the debate which took place in the Constituent Assembly, that makes it very clear that the practices which were prevalent in the ancient India have got place in the Constitution itself, and that is why the Constitution emphasizes on participation, consultation, and collective decision making. And as I said, originally it had 395 articles and 8 schedules. But vibrancy of our democracy and the activeness of our judiciary is seen, as well as the legislature is seen, that during the last 75 years, we have amended our Constitution 106 times. And why we have amended it 106 times? Because the directive principle of state policy, which was said to be a direction to the state and not enforceable by the court of law, if you look at the 106 amendments, most of the important amendments were to give effect to the directive principles of state policy because they contain social and economic rights of the individual. You are voting right, reducing it from 21 to 18. Panchayati Raj, municipal representation of women in the Panchayati Raj and municipality to 1/3. And the latest amendment passed in the new House of Parliament 106, giving 1/3 seats, reserving 1/3 seats for the women. I think all these are progressive steps taken by the legislature and upheld by the judiciary from time to time by interpreting the Constitution in such a way that while protecting your fundamental rights, the state implements the directive principle of state policy in such a way that 80% of the population which is said to be living below poverty line or almost on the verge of poverty line, their rights are protected. And on this Constitution Day, I would like to remind all of you, and I would like to make a request to all of you, that please see that amendments, major amendments which have been made in the Constitution are to ensure that the society grow, and if we really have to become a developed Viksit Bharat by 2047, as the Prime Minister has been saying from various platforms, I think what is needed is we have had enough of rights. We know the Supreme Court is there to protect our rights. Please concentrate on Chapter 4A of the Constitution, which was added by 42nd Amendment, laying down that fundamental duties which every citizen is supposed to follow. All of us are vigilant about our rights, but how many of us are really vigilant about the duties which we are supposed to carry out towards our nation, towards this society? As a practitioner, how many of us are really taking care of those who are not able to take care of their own rights? I was reading Justice Chagla's book, very famous book, Roses in December, his autobiography, where he has said the job of an advocate is to earn from a person who can pay and to serve the society at large. He has to balance between the two. I think the time has come when we are saying that our Constitution has completed 75 years. A time has come when we should see that there is a empowerment to the downtrodden people as well as to those sections of the society who cannot protect their own interest. And we must ensure that as we are vigilant about our fundamental rights, we should also be vigilant about the fundamental duties. Of course, they are not directly enforceable, but indirectly they are. Take, for example, you have a right to strike, but how to exercise that right? Are we vigilant about that? Should we stop the essential services also? Should we block the roads also? Should we destroy the public property or the public places also in exercising our right? There has to be a balance between the two. And I think that time has come. If we really want to see Viksit Bharat in 2047, when we complete 100 years of independence, I think we have to begin right now to take care of our fundamental duties also in the same way as we talk about our fundamental rights. I can go on and on. I can discuss about various parts of the provision of the Constitution also, but I think you are going to have a whole day deliberation on various aspects or developments which have taken place during the last 75 years of the Constitution. I wish you all the best. Hope you will be having good deliberation. And thank you very much for giving attention. And thanks to the INBA for inviting me in this important function and sharing my thoughts from this public platform. Thank you very much.
Finally, I would like to invite Mr. Pradeep Gandhi to please share a few words with us.
संविधान दिवस के इस अवसर पर मंच पर विराजमान श्रद्धेय मुख्य अतिथि के.जी. बालाकृष्णन जी, पी.के. मल्होत्रा साहब और विभिन्न क्षेत्रों से आए हुए यंग लोग, यंग लीडर्स। देखिए, आज़ादी का अमृत महोत्सव हमने मनाया पिछले वर्ष और अब संविधान का अमृत महोत्सव है। और आदरणीय दोनों अतिथियों ने जो विषय रखा, मैं इसका एक पक्ष रखता हूँ। आज़ादी के बाद हमने अधिकारों की बात बहुत की, कर्तव्य की बात थोड़ी छुप गई। कर्तव्य पथ का निर्माण हुआ और कर्तव्य के लिए ही आज पूरे हिंदुस्तान के प्रत्येक पंचायतों पे संविधान दिवस का कार्यक्रम हो रहा है। विशेष ग्राम सभा का आयोजन है कि संविधान क्या है, जिसको 2 साल 11 महीना 70 दिन तक के भिन्न भिन्न विचारधाराओं के लोगों ने मंथन किया और उस मंथन से एक नवनीत निकला। वो नवनीत है संविधान के रूप में हमारे देश को कैसे चलाना है। क्योंकि एक परिवार में 4 भाइयों के विचारों में समानता नहीं होती, चौके में जो खाना बनता है उसकी सब्जी में समानता नहीं होती, किसी को कोई पसंद है, किसी को कोई चीज़ पसंद है। तो इतने विराट भारतवर्ष को जहाँ पर भिन्न भिन्न जाति, पंथ, वेशभूषा के लोग हैं, आखिर उनको किस तरह से आप चलाएंगे। तो संविधान ने मंथन किया और मंथन के बाद जो नवनीत निकला, उस नवनीत को तात्कालीन परिस्थितियों के अनुसार उन्होंने दिया। उसके बाद संविधान में कई संशोधन हुए, परिस्थितियां बदली, अंतर्राष्ट्रीय स्तर पर परिस्थितियां बदली, देश के अंदर परिस्थितियां बदली, एजुकेशन बढ़ा, लोगों को सोचने और समझने की क्षमता बढ़ी। तो आखिरकार बाबा साहब अम्बेडकर ने जिस परिस्थितियों में जीवन को जिया, जितने घात और प्रतिघात उन्होंने सहा, उसी से तो अनुभूतियां निकली कि आने वाली पीढ़ी को ये घात और प्रतिघात सहने का अवसर ना मिले। सामाजिक समानता हो, आर्थिक समानता हो। एक और सिमिलरिटी है, कल ही भारत मंडपम में सहकार से समृद्धि अंतर्राष्ट्रीय स्तर का 5 दिवसीय कार्यक्रम हो रहा है। पूरे विश्व से 3000 लोग बुलाए गए हैं। आगे चल करके ये जो गरीबी की खाई पट रही है, किसी एक पर्टिकुलर व्यक्ति तक अगर संसाधनों का केंद्रीकरण होगा तो सामाजिक विद्रोह पैदा होता है। मैं जिस क्षेत्र को बिलोंग करता हूँ वो नक्सल क्षेत्र है। हमने एक ही दिन में 80 लाशों को इंक्लूडिंग एसपी सहित 80 लाशों को कंधा दिया था एज ए जिला परिषद चेयरमैन। तो कहीं ना कहीं उस प्रकार की जो गैप होता है उसको भड़काने का प्रयास भी होता है। ऐसी परिस्थितियों में सामाजिक समानता के साथ आर्थिक समानता के लिए सहकार से समृद्धि का रास्ता जो सरकार ने तय किया है, इससे आने वाले समय में कमजोर वर्ग के व्यक्तियों को संगठित करेंगे, फिंगर टू फिस्ट, उंगलियों की मुट्ठी बनाई जाएगी, तो ताकत क्रिएट होता है और उस ताकत से ही व्यक्ति आगे बढ़ने का काम करता है। तो हमारा संविधान हमको उन चीज़ों को लिए, अब ये आने वाला 25 वर्ष, जब हम 2047 में विकसित भारत की जो कल्पना किए हैं, उस कल्पना में हमको अपने ज्ञान, प्रभाव, पुरुषार्थ और धन और सामर्थ्य का विसर्जन करना है। मैं इसको एक वाक्य में कहता हूं, विसर्जन से सृजन की ओर चले। हमने अपने जो भी चीज का विसर्जन करेंगे, एक नई चीज का सृजन होगा। किसान एक मुट्ठी अनाज खेत में डालता है, 120 दिन के बाद वो एक बोरे में कन्वर्ट हो जाता है, 120 दिन के अंदर असंख्य गुना बढ़ जाता है। तो इसी तरह से ये सृष्टि विसर्जन से सृजन के सिद्धांत पर चलती है और हमको भी उसी सिद्धांत पर आगे बढ़ना है। अब ये दोनों महानुभाव 40-40 साल, बालाकृष्णन साहब तो आज़ादी के पूर्व का जन्म है, आप सब, हम सब लोग आज़ादी के बाद के लोग हैं। अब आज़ादी के पूर्व का जन्म है और 50 साल इन्होंने अपने जीवन का 50 वर्ष इस प्रोफेशन में दिया, यानी अनुभव का खजाना इनके पास है। अब मैं कहता हूं जीवेत शारदा शतम, 100 वर्ष जिए, मगर एक दिन तो ये पंच तत्वों का शरीर जाने वाला है। पंच तत्वों का खिलौना कब न जाने टूट जाए, प्राण का संबंध तन से कब न जाने छूट जाए। तो क्या हम ये प्रयास कर सकते हैं क्या कि ये भी तो सोसाइटी को कुछ देना चाहते हैं? पीके मल्होत्रा भी तो अपने अनुभव का विसर्जन करना चाहते हैं। अब कोई इनको धन नहीं चाहिए, अब इनको कोई पद और प्रतिष्ठा नहीं चाहिए। अब ये इन्होंने कहा वानप्रस्थ, 75 वर्ष के बाद हमारे यहाँ तो सन्यास की परंपरा है, गृहस्थ से मोह छोड़ो और सन्यासी बन करके इस भारतीय संस्कृति को, इस भारत देश को मजबूती के तरफ आगे ले जाओ। मैं आप संग सब यंग वकीलों से आग्रह करता हूँ कि मैंने कई ऐसे जस्टिस लोगों से बातचीत की, उन्होंने कहा यार अब जीवन के इस मोड़ पर समाज को कुछ देने की इच्छा है, लेकिन लेने वाले पात्र व्यक्ति भी तो आए। क्योंकि मैंने ये अनुभव किया कि जो न्यायाधीश हैं उनका जीवन थोड़ा सा सामाजिक रूप से उनकी एक अपनी मर्यादा है, इसलिए उनको थोड़ा समाज में समरस होना। ये तो बालाकृष्णन साहब हैं जो रिटायरमेंट के बाद भी अपने आप को जीवंत, प्रामाणिक और अनेक समारोह में उपस्थित रहते हैं। ये इनकी मौलिकता है और ये इनके लाइफ को बढ़ाता है। अन्यथा एक बंद कमरे में व्यक्ति जीवन भर सामाजिक नहीं रहा तो रिटायरमेंट के बाद तो ऐसे भी समाज और परिवार दूर हो जाता है। यार जब पद में था तब तो कीमत नहीं की, अब बुढ़ापे में हम उनके पास क्यों जाए? तो ऐसी परिस्थितियों में आप लोगों को क्या करना चाहिए? ऐसे लोगों को 4 महीना 6 महीने में किसी एक टॉपिक पर डिस्कशन करने के लिए बुलाना चाहिए। इसको मैं कहता हूं हनुमान और जामवंत का मिलन। देखिए हनुमान जी समुद्र के किनारे चुप बैठे थे, उनके अंदर असीम शक्ति थी, मगर उनको अपनी शक्ति का ज्ञान नहीं था। जामवंत जी आए और उन्होंने कहा का चुपी साधी रहे बलवाना। अरे हनुमान, आपके अंदर असीम शक्ति है, अपनी शक्ति को पहचानो और उस शक्ति को पहचान करके उसका रूपांतरण करो। और ऐसे जामवंत जिन्होंने जीवन के अनुभव से अपने आप को सिंचित किया है, जब वो अपने ज्ञान का, प्रभाव का, पुरुषार्थ का विसर्जन करेंगे तो उनकी आंखों के सामने एक नई चीज का सृजन होगा। और यही सृष्टि का सिद्धांत है, विसर्जन से सृजन की ओर हमें चलना है। और आने वाले विकसित भारत के निर्माण में हम सबको अपना भाव भरा योगदान प्रदान करना है, ताकि विकसित भारत के निर्माण में हम सब अपना महत्वपूर्ण रोल अदा करते हुए कर्तव्य पथ को थोड़ा सा गति देते हुए, आगे बढ़ाते हुए हम प्रयत्न करेंगे तो हमें सफलता प्राप्त होगी। आज आपने आमंत्रित किया, इसके लिए मैं आपके प्रति अपना धन्यवाद ज्ञापित करते हुए अपनी वाणी को विराम प्रदान करता हूँ। धन्यवाद।
Respected and honorable members on the dais, Honorable the Chief Justice Balakrishnan ji, former P.K. Malhotra ji, and Mr. Gandhi, thank you so much once again for being here with us today. Though it's a morning hour and there's a lot of rush, today is working, so let's all cheer up for the day. We have a long day to go on with all the smiling faces here. So may I request Ms. Meena Rally to kindly come on the stage and please felicitate the Honorable Justice P.K. Malhotra ji and Gandhi ji. One of you help.
बहुत अच्छा संचालन किया।
Thank you so much, sir. Thank you so much. Thank you, sir. We shall now commence with the program for the day, starting with the first panel discussion. I would like to invite back on stage Ms. Veena Ralli. Mrs. Veena Ralli shall be the moderator today on the topic of mediation in international commercial disputes, a path to amicable dispute resolution. Ma'am is a mediator of the Delhi High Court Mediation and Conciliation Center. She has around 4 decades of experience as a lawyer, and she is also the organizing secretary and senior mediator at the Samadhan, Delhi High Court. I would like to now invite the speakers for this panel, Mr. Suman Doval. Sir has 25 years of progressive experience in active litigation across all jurisdictions besides arbitration. He has joined illustrious chambers of a former judge of Supreme Court of India, now chairman of National Green Tribunal in Delhi High Court since the year 1991 and remained till his elevation. He has since then been associated with the chambers of Sri Venkataramani, senior advocate. I would now like to call Ms. Soumya Singh, Associate Vice President of Legal Cube Highways and Transportation Assets Advisor. Ma'am is an in-house legal counsel at an infrastructure fund company specializing in in-road and highway projects. She has extensive experience in risk management, tender documentation, mergers and acquisition, contract negotiation, and litigation management. Prior to her in-house role, ma'am had gained valuable experience in dispute resolution. Ma'am, you may commence.
Good morning, everyone. No, I otherwise also, I think I'm on.
Yes, ma'am.
First of all, I would like to thank INBA for calling us here and being on panel with Suman. I call him Suman and Soumya. So 2S where we talk about our rights, and as rightly said by Mr. P.K. Malhotra, that every right has a corresponding duty. As lawyers, as I see most of the participants sitting here are from the legal field, we work for the rights of the litigant. But we also have a duty as a lawyer towards our client, of course, we are paid by them, but also towards our nation. Due to the awareness in the last 15-20 years, the burden on the docket of the judicial system had increased to such an extent that it became difficult for the system to provide justice to the litigant. Because we all hear justice delayed is justice denied. But we are a part of the system, and we as lawyers contributed a lot to see that the justice is delayed, keeping in mind the individual interest of my client. My means me as a lawyer. But the system could not overlook this burden. So mediation was introduced as an alternative dispute redressal mechanism. Though at the initial stage, it was introduced as alternative to the existing system, but I must tell you that over the last 17 years journey of mediation has made me to say that this is the most appropriate redressal mechanism and not alternative. Why is it so? Because the existing legal system only looks at past without keeping in mind the present and the future of the parties. When we put in practice our mediation process, we realized that this is the only system which, of course, refers to the past, but creates present and focuses on future. So though some of the people understood this ADR as lawyers' alarming drop in revenue, but now the things have changed. People are opting it as an appropriate mechanism. And in the multi-door courtrooms available to us, particularly in Delhi, where if you enter from gate 1, you can go to the arbitration center, you can go for mediation center, or you can go for the litigation or adjudication by a third neutral person, that is judge. I'm very happy that this organization has thought of having this panel discussion with the esteemed panelists on the dais with me. I'll start with Soumya, because Soumya, I would like you to comment as a receiver of this process, as a consumer of this process. How do you see mediation is working from your perspective?
Before we proceed further into this session, I would also like to please felicitate and welcome on stage Mr. Per Oberg, who will also be a panelist and a speaker for today's session. He is a Welcome, sir. He is a Sweden-based business development specialist with a strong focus on India-EU trade. With over 45 years of experience, he has lived and worked extensively in India, including running his own factory. He possesses an extensive network in India, encompassing politicians, bureaucrats, business leaders, and legal professionals.
Yes, over to you, Soumya.
So I think from the perspective of companies, and I would specifically focus on companies with international shareholders, with shareholders who have from outside India, who have invested money in India. From their perspective, mediation has worked wonderfully because they come from a thought process where they don't want to litigate, they don't want to dispute. They see time as money, and they see that litigation just sort of involving too much of effort and resource and time in dispute is a waste of money and resource. And not only money, but also waste of human resource, which they could otherwise sort of invest somewhere else. So to them, at least, mediation has worked wonderfully. What I have observed is that in all these international agreements, they have a med-arb clause.
Yes.
Very, very important for us to have that, right? They would, and in fact, in some of the agreements, there are 3 tiers. There's first conciliation between the higher management, then they shift to mediation, and then they go to arbitration, which is again an adversarial sort of
Yes.
form. So they try to resolve the dispute without getting into litigation as much as possible, and mediation has played a great role in it, because at so many times it happens that at conciliation level, which is usually happening at higher management, the dispute doesn't get resolved. Because they don't have a neutral party perspective. They are coming from their point of view, and sometimes they are blinded by their views, and if I may say, their egos as well. But when the second step of dispute resolution kicks in, which is mediation, they are guided by a neutral party, which is a lot of times acts, if I would say, as psychologists. They give them a different perspective of dispute. They help them understand the dispute better, being neutral to the dispute and giving control to the parties at the same time. So it sort of helps the parties in the dispute to understand the dispute better and resolve it.
Thank you, Soumya, and particularly calling time valuable, considering that I'm sure everybody looks forward to have first try mediation, and you use the word, I really appreciate coming from you, as med-arb. I would like to point out that there is a process which is also called med-arb-med or arb-med. Everything is happening these days because everyone is looking forward to save time, money and energy, and if possible also the existing relationships. So even sole arbitrators or even arbitral tribunals are referring matter for mediation. Even at a point of time when they have written their award, they keep it pending, because if award comes, it will cement certain disputes, because arbitrator, as you rightly said, as an adjudicator, cannot decide in favor of both. It has to be win-lose position. So for making it even at the last minute as win-win position, they still try mediation. Wonderful answer, Soumya. I'm very happy to hear that it must have enlightened the participants. Yes, Mr. Per Auberg, I would like you to share your views on mediation, particularly from commercial background. If you can just point out how does it help the commercials, you know, because everybody wants to have results at the earliest.
Thank you for the word. And I can mention also, wasn't said, that yeah, I'm dealing in business, but I'm also a lay judge in the Stockholm
Wow.
administrative court. So I'm dealing with some juridical there also aspects. But when it comes to the situation when there arises a conflict between companies, or sometimes between companies and maybe some authority or in between countries and so on, it is very important to find the optimal way to solve the issues. I think that's what the purpose is there. And there are many situations where the arbitration can step in and give a chance to solve something that it can go faster many times, and which you correctly says is money. And the second thing is that it can also is more secret than in a court. You can keep certain secrets much better in an arbitration than you can do when you are going to the court. And I think that arbitration is very good for many cases big corporate organizations and so on to use when there are agreements here and there. I, however, want to put in that for small companies doing certain things, maybe it's not the best way always, because you need to have a certain strength when you go into arbitration, juridical strengths to put up your side on the matter. And cost-wise, it's more expensive for a small company to pay these fees compared to, I mean, if you look at the Stockholm Arbitration Institute, which is world famous there, who grew a lot in the 1940s when Soviet Union and USA decided they should solve their conflicts at the Stockholm Arbitration Institute. They don't accept less than $50,000 cases, for instance. It has to be minimum $50,000. Otherwise, they don't do anything. So I think these kind of things is important to see how does it work for small companies also. But for the big ones, I think this is a very good solution to make it for them faster and easier and clearer than and having more influence compared to the court case, and especially in India, when I have seen court cases can be taken eternity sometimes.
Yes. Generations to generations. Lawyers from one side to fight and generations to suffer the outcome of that litigations. Thank you, Mr. Oberg, particularly pointing out that mediation is confidential. In mediation, whatever is talked by the parties remains there and no record is created. In litigation, there is nothing which is without record. So certain things which you do not want to put on papers for whatever reasons, or we exaggerate things while putting pleadings before the court, or we walk away from the reality while creating pleadings, we can talk all those emotional aspects, valuable aspects in mediation, and we can navigate the conflicting parties towards resolution. That's possible only in mediation and in no other way. And second, I must tell you that so far as you said, small industries, in our Indian system, we have MSME Act that talks about conciliation. In India, there is a lot of confusion between conciliation and mediation, but with minor differences here and there, they are more or less, the process is similar. Though it has been mentioned as conciliation, and many matters in MSME Act, under the MSME Act, can be resolved even through conciliation. If they are not resolved, then they are referred for mediation. And if we look at the results, they are very satisfying. Because of the programs being conducted like this, awareness is coming up, because in India, people never thought mediation can get them what they really want. It took us 17 years to reach up to this level. Yes, Suman, I would like you particularly to share your views. You have been a hardcore litigant. How do you find being a mediator now? And how do you see yourself as a transformed lawyer?
Thank you very much, Vinadi. She is my teacher in my mediation, so I first of all thank her to be with me on the dais. Yes, she is absolutely right. The journey from litigator to mediator is really very transformative journey. From taking one side of the client view and taking it to the judges forcefully with the help of the case law, precedent, judgments here and there, and the position, you come to a point where you hear both the parties, come to a middle path, and say this is the best path for win-win situation. So from lose-win to win-win is a transformation. And I'm very happy that it has transformed me as a litigator also. When I look upon the point of the other side too, and come to a resolution or a solution, which may not be liked by the court or may not be the other party, but after some time, it percolates down to the party. There's no point litigating on the issue further. That's one. Second, we have now a Mediation Act 2023, which is very specifically laid down. Variety of things, including timelines, which is only 4 months. Thirdly, at Samadhan, which she is the secretary now, she is head of the Samadhan now, we have a free mediation. So client has to pay nothing. The court sends the mediation process to us in Samadhan, mediator. It's a free process. and we spend a lot of time. If the 4 months are there, I don't think any mediation is fruitful or done in 4 months time. It's always take more than that. And then we have the sittings over there. But I am very lucky to have almost 80% success rate in my mediations, which I feel only because of change of perspective, nothing else. And we all know that disputes are going to happen. There are conflicts are there in all societies, everywhere, whether it's a union, whether it's a home, whether it's a college, whether it's a school, or we have the law faculty or a law bar association. But there is a resolution mechanism called mediation, and therefore I feel today that next 25 years and on, maybe next 10 years, it will become a main appropriate dispute resolution mechanism rather than the litigation and other things. So I leave this now the question for the audience and you to comment.
We'll go for questions.
Question please.
No, I'll just point out one thing since you referred to Mediation Act. Mediation Act has been passed, but it has yet to be notified. We are already waiting for 1 year. Now let's see how much more time does it take. Any questions, please? No questions?
Knowing about it.
Please.
So, when you do the mediation and there is a settlement, it seems the parties who have been part of this mediation, when the mediation report is sent to the court back and the court, I do not know how do they impose this mediation agreement or mediation settlement, but the litigants sometimes they always tend to go back, they do not want to follow the settlement which has been done. So how is that solved by the court or by the mediation center?
First of all, I would like to point out and share with all the participants here, the system is like this under the mediation rules which are prevalent in all over India with little variations, but more or less the same. If a settlement is arrived at between the parties, the settlement is sent back to court and the court passes an order or a judgment or decree in terms of that settlement. So the settlement written by the parties or due to the self-determination of the parties with the help of their respective counsel, that becomes a decree in court. Very rarely this happens what you are asking me, because if the process has been followed fairly and parties have signed the settlement with their informed consent, generally people do not back out. Unless or until there is something either as a strategy or because of lack of informed consent, parties go back and they say that we were under some different impression or something was not made clear to me and I had put my signatures. But if I talk about the ratio, that is 1 out of 1,000 cases. There also the system helps us. The courts generally do not believe such type of messages being received from the parties unless they are sure that the informed consent was missing. Because in India, we have a very good support system coming from the judiciary. Mediation was brought into our country to help and assist the judicial system. In so far, I would like to say that even if mediation is very much prevalent in the court system, it is more prevalent in the court annexed mediation centers than the private mediation picking up to that extent. So courts, mediation starts from the referral court, it completes with the referral court. They are performing their duties to encourage mediation and do not get into such type of traps where they feel that it might be a strategy of someone to gain time. And very rarely such things happen here. Of course, when private mediation will pick up faster, of course it has already started since 2009, and my center at Samadhan, we are doing even pre-litigation mediation. We don't find this happening much. So it's a very rare occasion. I hope I've answered the answer. Thank you. Any other question? My co-panelist says,
Sorry, I have one more question.
please, that will give me a chance to speak also, because otherwise everybody is silent. I don't know. I think they need some cup of tea. Huh? Yes, please, ma'am.
It was said that there is now mediation regulations 2023, and before 2023 there was another mediation regulation. So the decisions which were made in under the law of 2022, are they still valid for 2023?
They will be valid even under the Act. That continuity has been maintained.
Yeah. So the agreements which were made in 2022, they were like binding, or they were not binding?
No, they were also binding once they were referred back to the Honorable Court.
Yeah.
They become binding only when an order has been passed by the Honorable Court. Under the Act, that in itself will be a decree. The agreement in itself will be a decree. That's the difference now. But Act has yet to be notified, so we are waiting. Whenever it comes, we'll get that benefit. Yes, yes, please.
A very general question, but I'm sure young audience is also here. In all of your opinion, what are the skills which are required to become a good mediator? So maybe focus. Yeah.
He was also pointing out that only. See, we all feel by human nature that we are mediators in one way or the other. Do you agree with me or not? Yes. But once you go through this training which is specific, so far I don't know from where did come here, but 40 hours training is must so far. And that 40-hour trainings gives you the skills with regard to communication and negotiation. Any negotiator who has done any negotiation skill course would be knowing that. But this has a specific skill set. How to communicate, how to make the conflicting parties to communicate and navigate from that acrimonious position to harmonious position. By using your communication skills, that is what is shared with you whenever you decide to have a training. So when we undergo this training, then we realize that what we had been claiming so far, कि एक को अंदर बुलाओ, दूसरे को अंदर बुलाओ, जहां एग्रीमेंट हो गया वो सेटलमेंट हो गया. No. It is more like a surgeon. When we are on a stretcher, we do not know what is happening. The only surgeon knows which nerve is to be cut, what is to be removed, what is to be put in, what is to be stitched, and how it is to be stitched. So the conflicting parties are more like patients in front of us. The patient doesn't know what treatment is being given to me when I am unconscious. So my skill set will guide me. If this skill is not working, I should use another skill. And there are a good number of skill sets. And I must tell everybody sitting here, they must undergo that training, even if they do not opt to be a mediator. Because that will make you a good negotiator for your clients. And you will be able to get what your clients are looking for. And these are just 5 days of your career, nothing else. And that will make you not only a good negotiator in your profession, but also in your day-to-day life, even at your home. Because we negotiate at every moment with our family members too, with our neighbors, with our friends sometimes. And we also come to know how to say no at times. Because abrupt no can create a lot of problems. But a skillful no can get you good results. Thank you. Anybody else?
I have a small observation. As of now, we do a lot of mediation, especially in matters of IPR agreements and software piracy. There are a couple of observations which I have mainly while I'm training the mediation. One is the proper training which the mediators have had, especially in the Samadhan. It totally demonstrates the professionalism of the mediators in terms of getting the merits of the matter, but at the same time maintaining neutrality when it comes to the outcome and the process of mediation. That's one. Secondly, general observation basically for the audience here as well. The Delhi High Court has now a commercial court, and as a mandatory practice in the process, one has to undergo mediation, especially in matters when you're not pointing some sort of an urgency. And therefore, it has become a very predominant process, and it has literally shaped the psyche of the plaintiffs who are predominant litigators in High Court to specifically undergo the process of pre-litigation mediation, so as to ensure that the outcome, more or less what we figured out, frankly, is that the outcome which you achieve in the pre-litigation mediation typically is the same outcome which you are achieved in the court-directed mediation.
Correct.
So, and it saves a lot of time, energy, money, and you multiply the number of cases here. Therefore, the volume of settlements overall has increased, while at the same time the cost has substantially come down. So that's a very good,
Thanks to her.
we have.
No, but at the same time, I would still like to add what you are saying. Two things still needed. One is professionalism in our skills, in the sense, if I am a family matters expert, I should not take up IPR matter. So domain knowledge, I'm not talking about domain expertise. Domain knowledge should be there. Of course, the results will be little higher. And second part, as you said, under Section 12A of the Commercial Courts Act, now you have to first come to pre-litigation mediation. The mindset of the lawyers, the mindset of the litigant also has to change. Though some of us know the benefits of mediation, it is too nascent a stage, despite 2018 rules having been passed. There are very minimal orders where cost has been imposed on a plaintiff who has not participated willingly in the mediation process. But I think very soon we will have such type of judgments to further foster that mediation is a real way of trying first as a resolution mechanism, then for going for litigation.
Mindset needs to be.
Yes, it will take some time. We always start no. Every written statement, first sentence is incorrect and denied. And we still sit in the system by saying no. That is why I said we must learn how to say appropriately even no, and that mediation teaches you.
One more observation, ma'am, while it is not that relevant per se, but normally as litigators we tend to finish work at 4. Initially we used to do physical mediation, and initially it was testing on us, and for 2 hours and getting the court and then go back to the office and prepare for the next day matter. But during COVID and after that, since all the mediations in most of this are taking it online, it took a lot of time also, and it was a lot of efficient in terms of the process. It really helps us to multiply the number of mediations, advise our clients to proceed for mediation in a very large extent.
I would still like to add something more. COVID has given us both plus and minus, both pros and cons. This online mediation was thrust upon us during COVID, but we were the first ones to start in June 2020 itself. And today also we are continuing with this. The best part in Samadhan is that we do not close our center at 5 o'clock. We continue working, and particularly since you are referring to IPR matters, we have multinational participants also. That further helps us to reach to those people through online system. We also encourage our staff members to fix meetings at late hours or early morning hours, depending upon the availability of the participants. We are trying our level best to do that. Let's hope to go further. With people like you supporting us, definitely we will also be extending our hands to you.
And last word, madam, please tell the young lawyers the future of a mediator in this country.
Someone just wants you people to know what is the future of mediation. I will say that future is bright, not only as a mediator, because so far the beginning of the mediation was in a different way because we were focusing on the docket. And it was given as a free facility to the litigant. So in terms of money, right now, people might not be too much open to the idea of being a mediator. But I can assure you all, gaining knowledge about mediation advocacy, like he is speaking up on behalf of his client, IPR matters, you can always guide your clients. Go for mediation, you will get it today. Whatever you want, because that is a process which is a self-determination process. That is a process which focuses on your future, which focuses on your relationship. And I think in Samadhan, we get reference of pre-litigation mediation only because of the lawyers and only because of the cooperation extended by lawyers. People take that view that they are hurdles. I am deadly against that view at all, because whatever is the existence of mediation today in our country, that is all because of the lawyers. And always there can be some part who are not in favor of it, but we should not focus on that. Future is bright, more particularly focusing right now on mediation advocacy. And as and when the act is notified, I'm sure private mediation will pick up very fast. And people will opt for it, because under the act, the agreement itself is a decree. People don't have to go to court to get a decree passed. That will encourage. So future is bright. Do your best, get some training, and be a mediator too. And that will give you even human skills to work upon yourself, how to communicate, how to negotiate at every level of your life.
Time is over.
You should tell us time is over.
No, ma'am, it's fine, please. I did not want to interrupt this session as it was extremely informative, especially for young lawyers such as myself. And I think we have all learned from this that mediation is definitely the way forward. Dispute resolution is definitely the way forward, and mediation is definitely one of the facilitative ways to achieve that.
I'll still take 1 minute.
Yes, please, ma'am, please.
I still take 1 minute. You use the word dispute resolution. There is a lot of difference, young lawyers here, which you have not been taught, I have not been taught, that there is something called conflict, and that is different from the dispute. Mediation is a process of conflict resolution which is much deeper. बरगद का पेड़ होता है ना, iceberg होता है ना, deep तक जाता है. Only mediation takes you to the depth of the cause of dispute, which basically helps you to resolve your conflict. So we talk about conflict resolution.
Conflict resolution.
Thank you very much.
Noted. Thank you so much, ma'am, and thank you so much to our esteemed speakers.
Thank you very much. Thank you. Thank you very much.
Yes, sir. Photo सुमन जी ऐसे बन जाएगी.
अच्छा, एक picture.
Yes. Close, sir. Yes. Ready? Okay. Wait 1 minute. Yes.
Thank you very much.
Thank you, sir. Without further ado, I'd like to invite upon stage the second panel. I'd like to invite upon stage Dr. Sumitra Singh, the moderator for the panel. Dr. Sumitra Singh is an associate professor at Amity University. She has had over 14 years of experience in the field of education and 35 publications in national and international journals of high reputation. The topic for this panel is data privacy, cybersecurity in litigation, e-discovery, and arbitration. I'd like to please invite on stage Mr. Arnav Guha Roy, the first speaker for this panel. Sir is a disputes partner at TTNA. As a dispute resolution lawyer specializing in infrastructure, environment, and commercial matters, he has had over a decade of experience handling complex disputes arising out of infrastructural projects, including those involving project owners, lenders, consultants, contractors, and regulators. He also has experience in international arbitration and has represented FMCG, media, and technology companies in various institutional and ad hoc arbitrations. He has been featured among the top 40 under 40 lawyers in 2023 by Business World India and has been named as a future star in the commercial and transactions category by Benchmark Litigation in its 2024 rankings. I would now like to invite upon stage Mr. Alakshendra Singh, Senior Associate at TMT Law Practice. During Sir's stints with firms, he has worked on various border mandates and was engaged for strategically crucial roles such as secondment with a leading audio entertainment platform, where he looked after the entire operations in India, and on a full-time secondment with a leading regional music label as their head of legal operations. I would now like to invite upon stage Mr. Shantanu Sahai. Mr. Sahai is a partner with Anand & Anand and in charge of its IT and e-commerce law practice group. As a part of this practice, he has been acting for various software companies such as Microsoft, Business Software Alliance, and Siemens towards their anti-piracy campaigns in India, which include initiating civil lawsuits in courts on behalf of these companies, as well as carrying out criminal enforcement tasks across India. Please. As long as you'd like to take, no problem. We're anyway running beyond the script.
Good morning everyone. Am I audible? Audible, okay. It is always very, significant being at so many places, even including the parliament. So I recently took a session in the parliament for the officers of Rajya Sabha and Lok Sabha, and that lecture actually was on legislative drafting. So how a bill becomes an act and how an amended act should be known to the officers of the Lok Sabha and Rajya Sabha. In that, why I'm giving you that context is, one very senior official in that particular assembly, he stood up and said, "Ma'am, ये सब छोड़िए, हमें तो ये बताइए कि जो बहुत ज़्यादा पैसों का ट्रांजैक्शन होता है, अगर उसमें अगर धोखेबाजी हो जाती है, धांधला हो जाता है, उसमें धांधली हो जाती है, तो उसका ओनस किस पर आएगा?" So that lecture took a totally different turn. So this is one context. Another context is a very short story between two friends studying in a law college, and good friends, a girl and a boy, so sharing a very good camaraderie. They've been childhood friends. And so there comes a time in their life when even their parents decide that after your law degree, we will get you married, and they also decided that yes, we should get married. So on a fine evening when they go to a restaurant to have a dinner, so the girl and the boy, they look at each other's chats in the phone. And then all the secrets are opened because we do not know, they do not know who they are chatting with when they are not together, because the marriage was fixed. And they didn't know how to own their privacy. They had shared so many secrets, and after those secrets, there came a time when they were seeing all kind of a different chat together in the phones. So, Puttaswamy's Aadhaar judgment says about right to privacy as a fundamental right. So there was a big tiff between both of them. तुमने मेरे phone में क्यों देखा ये वो this that, everything got distorted. Marriage is halted. Third thing. There is a story about this woman in a village, which I will not like to quote. So there, it's a very suburban village, and digital India is ruling the roost. Everybody has a smartphone. Everybody has a smartphone. Even the farmers are given an opportunity कि बीज कैसे बोया जाएगा, हम आपको digital India की website पर दिखाएंगे. Site चल रही है, लेकिन अपने आप कोई लाइव सेशन चल रहा है, लेकिन किसी ने उसका आईपी एड्रेस हैक करके कुछ और मूवी चला दी. तो क्वेश्चन ये है जो कि हमारे इस पैनल डिस्कशन का टॉपिक भी है. द टॉपिक इज अबाउट राइट टू प्राइवेसी, इट इज़ अबाउट डाटा प्रोटेक्शन, इट इज़ अबाउट ई डिस्कवरी, एंड ऑल्सो इट इज़ अबाउट हाउ ई डिस्कवरी इज यूजफुल इन लिटिगेशन, इन आर्बिट्रेशन, सॉरी. सो लेट अस बिगिन विद द बैकग्राउंड दैट Still in India, cyber laws are governed by the IT Act of the year 2000. Section 43A, Section 72A, and Section 65, 66, D, E, F, and Section 67, 69, they all talk about different kinds of crimes that are being done and what can be the penalties. Having said so, there are opportunities still very open for the criminals to hack your laptop, to hack your websites, to hack your blog, and we are rendered clueless. So, amongst that backdrop, and also to begin with, stating that if we have a path to go towards Viksit Bharat, what will be our road ahead when we talk about the IT laws in India? What will be that privacy corner that I have? Because when we link our PAN card with Aadhaar and all the data, there is no privacy remaining with me. All you just type my name on Google, you have my entire profile is very public. Even when you build your website, if you log on to Facebook, Instagram, or Threads, in fact, your entire profile no longer remains private, it is public. So how much is your own life very private? So this is the background set for this panel discussion. Very eminent lawyers are here, and I'll request students also to participate in this panel discussion, taking up your own questions which are very, very important to you. Article 51A, talking about fundamental duties, में ये भी आता है, आपको अपने आप को अपग्रेड करते रहना है, ठीक है. राइट टू एजुकेशन एक्ट 2009 भी तभी आया. ये हम सबकी मौलिक अधिकार ही नहीं, हमारी ये ड्यूटी है कि हम अपने राष्ट्र को ऊपर बढ़ाएं, आगे बढ़ाएं. विकसित राष्ट्र ऐसे नहीं बनेगा. So right to privacy, Data Protection Act, e-discovery, arbitration, and IT laws, it's all summed together. So we will begin with Arnav, you go first. So Arnav is here. Arnav is a dispute resolution lawyer who's specializing in infrastructure, environment, and commercial matters. So we've got three backgrounds all together for an esteemed lawyer to talk to us regarding infrastructure, environment, and commercial matters, and having a decade of experience. He handles complex disputes arising from infrastructure projects involving those which have project owners, leaders, consultants, contractors, and regulators. So, Arnav, when you talk about e-discovery and arbitration, also please reflect some light upon who would be the data owner, who would be the data processor, and who would be the data fiduciary when we talk about infrastructure. Arnav.
Thanks, Sumitra, for the kind introduction. So, when you talk about e-discovery and arbitration, discovery itself is very much provided in our CPC. Order 11, Rule 1 says that if a plaint is being filed, all your documents has to be annexed with the plaint. Similarly, with your counterclaim or your written statement, your documents have to be filed along with the written statement or counterclaim. That is your entire case, which is also in sort of aligned with our common law principles that you need to bring your best case forward and not conceal any document. But arbitrations, as we all know, it's a bit different. The CPC principles don't really apply to arbitrations. Many of the arbitral rules also, if you see the MCIA rules, for instance, they don't insist that you file all your documents in the first go. And generally, what we've experienced with ad hoc as well is that you have a round of pleadings first, and then the parties will file their applications for discovery of documents. When it comes to e-discovery, that is electronic data, ESI, electronically stored information, there the challenge that really comes that we've seen is that a lot of the tribunals are not really well versed with the nature and the quantum of the problem, especially if it's a complicated construction arbitration and the documentation has been flowing since the past 5 years, right from the stage of the tender to the point of the first dispute has started. It's a lot of mail traffic that is being talked about. In such a scenario, when you have to file an application for e-discovery, what you're essentially asking is access to emails of the other side from a particular relevant period. So if you were to do this in a physical format, it would invariably be considered to be a fishing and a roving inquiry. But the nature of emails are such that if you're looking at a particular time period of the arbitration of the dispute, it will result in a lot of email correspondence, a lot of documentation, and it's also the mode of the correspondence that you're talking about. Most emails will have certain metadata with it. Most documents cannot have the same form as it's in an e-form as it's in a printed form. So recently we had a matter where it was a simple breach of contract arbitration, and one party had put in an application for discovery for documents spanning various email correspondence periods, as well as certain documents that were exchanged by way of WhatsApp and other communications. So while we provided these documents, the accusation came from the other side that you have not provided all the documents, you have in fact deleted some of these documents from your server. So then the question came before the tribunal as to how to arrive at a resolution for this. And from what we've noticed is that it really helps that if tribunals appoint a certain digital expert or some sort of a forensic analyst in this situation, and if it is a tribunal appointed expert or an analyst, it really helps, because what really assists us in such an arbitration is that the tribunal is well informed of what is the practicality of how data is processed, how data is stored, and how data is owned. Because a lot of the times the arbitrators are legacy judges. They have not seen such problems in courts. So for that to arrive, it really helps. Another problem that we've seen is that in ad hoc arbitrations, for instance, you don't have any specific procedures that would govern the way evidence is collected or the way I am required to produce evidence. We always propose that a certain standard rules are adopted, like the IBA rules on taking evidence, or maybe if you can push certain institutional arbitrations to be adopted. But because if it's an ad hoc clause right at the outset, these things are a little difficult to push. So what eventually happens is you would need to explain to the tribunal the difficulties in deriving that data, which is decades old, which may have been archived, for which you may not have any data backup, for which the email may have been decommissioned as well. In that situation, it really boils down to how the tribunal understands the situation.
So thank you, Arnav, for those initial remarks. So there are many things coming up. One that what I know is that there is a rule in which even the government or the court can block the websites. They have the rule. Fine. So we would now take this discussion further after the introductory remarks of Arnav. We'll go directly to Shantanu. I've known Shantanu since many years. We've met at different forums. So sometimes he is the moderator, sometimes I am the moderator. So times have gone. So Shantanu is a very young partner, litigation, IT and e-commercial law expert. He's a partner with Anand and Anand and in charge of IT and e-commerce law practice group. As part of this practice, he has been acting for various software companies such as Microsoft Corporation, Business Software, Lancers, and Siemens, and many others. So Shantanu, I'll come directly for your introductory remarks, taking a pick from Arnav only. The data process, the data owner, and the data fiduciary, and the IT Act 2000. How would you link Data Protection Act and the IT Act together? Over to you. Can we get another mic, ma'am? Another mic here.
Thank you, Dr. Sumitra. It's always a pleasure to interact with you. Now, as a litigator, if I may answer, there is a general conception in the minds of normal students of law, including us lawyers, that being an IT lawyer, the only few legislation one has to look into is the IT Act and not the DPDP Act per se. But I think largely what needs to look into is the procedural laws. Right? And our previous speaker has spoken about discovery. When we look at discovery, especially in matters of litigation, there are two types of discovery we are looking at. One is insofar as forensic data is concerned, the data which is there prevalent with you at the time you file the lawsuit. And the second is what exact data you require from the counterparty. Now, most of the law students must have by now heard of Anton Pillar orders and Norwich Pharmacal orders. Now, I'll just take a minute to explain what these orders basically mean. Once you litigate, there is a threshold evidence which you already have with you in the forensic form. Now, there is a particular process which is guaranteed in terms of the Evidence Act now, that you have to file those evidence in a particular format. Now, you let those evidence and you've passed the threshold orders, and the court has sanctioned some sort of a direction against the counterparty. One important direction which the court passes is an Anton Pillar order, which means the court appoints a local commissioner to go with the experts of the plaintiff and to seek some sort of forensic investigation in order to cull out the data which you fear that it is there, which basically, supports your case tomorrow in a court of law. Now, why we're talking about this here? Because, as you rightly mentioned about the relevance of privacy laws. Now, privacy, as we all mean, which means personal data in a digital format. Now, what the court necessarily believes that the process of investigation, including in matters of local commission, one has to be absolutely careful about the process and what exactly is the data you're looking at. And therefore, the line of directions now which are being passed by the Honorable Court is that you proceed for the forensic analysis with the help of technical expert. The entire process needs to be videographed so that there is no ambiguity in terms of the investigation. And the report which is prepared by the local commissioner is subject to analysis, is also evidence by the local commissioner themselves. So tomorrow one cannot, supposing the defendant counsel has an objection to the report, it can basically call not only the representatives of the plaintiffs, but also the local commissioner has gone and visited and done the forensic themselves, along with the technical expert themselves. So that is the sanctity of the personal data one is looking at. Cybersecurity, in my humble submission, has an overarching, predominance over, the personal data in a way. When we look at cybersecurity and largely cybersecurity breach, it is not only the personal data which is being violated, it is also the proprietary data of the plaintiff which is being violated. It can be a corporate data, it can be data of, let's say, an organization or a college, which also include personal data, but may also include a proprietary data. It may include some sort of a trade secret, information. It might have information in relations to your customer in a database format. So automatically it becomes a matter of copyright, it becomes a matter of trademark, trade secret violation, and therefore you shift your jurisdiction not only from the violation of IT to a general violation, of IPR and other forms of legislations. And therefore what you do is you approach the High Court. Why I'm saying this is because we've understood that DPDP Act talks about certain forums, it talks about Data Protection Board, it has the power to investigate, it has the power to sanction penalty. But then we do not know what teeth do they have, whether they have that teeth stringent enough to pass some interim directions, whether to freeze the bank accounts, whether to pass orders for appointment of court commissioner, whether to instruct further forensics by cert, so on and so forth. So that one needs to look into. Another angle which I'm looking at here is, and as obviously the rule is supposed to be out shortly, we'll have to see what exactly the specifics of it. But then, the section in the Act itself talks about the penalty and not the fine or damages, which means the money which is recoverable after the violation has succeeded, your claim, the money literally goes to the Consolidated Fund of India. So therefore, I as a victim, if my personal data is being violated, I have no business to do even litigate under this particular act if I see in the end I'm not getting the money out of it. So therefore, these are the critical issues. Obviously there has been a lot of increase in the cybercrime and cybersecurity breaches. We are talking about, recently the spate in digital arrest, cases have arisen. We have tech support fraud cases, which is very, very predominant from a region such as South Asia and largely in India. There have been a lot of crackdowns here, and automatically what we tend to believe that it is not only a matter of violation of a personal data, but it has to be clubbed with a cybersecurity issue as well. Thank you.
Yeah, that's great. Thank you, Shantanu. So here comes the point regarding penalty. So, there is some fixed kind of amount of data that has to be hacked, and the penalties are like them ranging more than 5 crores or so. All right, thank you. So we will come back again to you with more detailed discussion. In the meanwhile, I'll come back to Alakshendra Singh, a young and dynamic lawyer handling different kinds of cases. So Alakshendra, what do you think as a lawyer? When previously Ralli ma'am also talked about the importance of mediation, and Shantanu had given the point of online mediation also. So that mediation thing, is it protected? Is that online mediation stuff protected under the Data Protection Act or not? Also, I would like to highlight one point. When in the year 2018, the Data Protection Bill was being formed, there were so many remarks from across the country as to what is personal information and what is not personal information. So many things for you. Alakshendra. Yeah.
Thank you so much, Sumitra. So, before I get into the specific question that you asked, I want to inform the room for the uninitiated and my non-lawyer friends. How did we get here, right? It's an age-old discussion on whether you have a right to be forgotten, and that was set in concrete through the Puttaswamy judgment, where the Honorable Supreme Court read into Article 21, your right to life and personal liberty, and expanded upon it to essentially enshrine your right to privacy, and that set the ball rolling. That initiated the discussion, led to the formation of the B.N. Sri Krishna Committee. There were multiple iterations of the bill. Skip to 2023, we finally have a central legislation in place, which is the Digital Personal Data Protection Act. Now, what is personally identifiable information? There are, of course, multiple sources, but under the Act itself, it's essentially any data which can be used to infer your identity, right? And as for how mediation is to develop, typically, and we can obviously look at the SPDI rules, the focus has been on highly regulated sectors like healthcare, financial services. And if we look at how things are as of today, right, the way we consume entertainment and content has changed. Our access to public infrastructure is digitized as well. There is always an underlying layer of technology in whatever we do today. And invariably, whether it's body corporates or the state, they have access to our personal data. And that essentially requires us to move from privacy by default to privacy by design. What privacy by design means is essentially embedding your robust data protection practices into your product or service itself, right? Understanding what is the data being used, what data is being touched upon, how is it processed, what is the purpose of processing this data? Is there a need to limit the purpose? Is there a need to minimize the data touch points? And through these practices, once you really deep dive and get really granular, is when you will be able to understand whether data protection practices can be implemented in mediation, litigation, arbitration, or e-discovery, right? There are multiple touch points that I would want to dive into about data sovereignty, data localization especially because, you know, we've always looked to the West to understand what practices to implement. There are a lot of borrowed ideas when big tech came into India. So we are still on a privacy by default structure, and we need to steadily and meaningfully move on to a privacy by design structure.
Thanks. Arnav, I'll come back to you. As a lawyer, are you also doing arbitration matters? Yeah, so how does e-discovery facilitate arbitration more than litigation? Is it so? In the cases that you've done, can you reflect some of them to all of us?
So essentially, I would say arbitration is a lot more tailor-made for e-discovery than litigation can ever be. Primarily because judicial resources being so limited, you will simply not be able to have a situation where you are able to file such a voluminous data with the court and expect the court to be able to traverse through that. Like we recently, not recently, a few years back, we had a case. It was a commercial dispute where we ended up filing some 15,000 documents with the Delhi High Court, and the marking of those documents took more than a year. So it's just from that experience, it doesn't make sense for your especially if this is more true for construction arbitrations than your typical JV disputes and M&A disputes, where there's a lot of documentary evidence to be seen and parsed through. It makes sense for not only for an arbitral tribunal to be there, but also to have the correct rules. For instance, the IBA rules make it really evident that you would have to not only provide the data you are seeking, but also explain the materiality and the relevance of that data to the arbitration and to your claim. Something may be relevant to an arbitration, but not necessarily material to your claim. So to establish that before the tribunal, it really funnels the kind of data that you are seeking and avoids the fishing and roving exercise being engaged before the tribunal. The entire purpose behind e-discovery, or the most important point one must keep in mind for while looking at any discovery, is that the discovery should make sense. It should not result in the arbitration getting too prolonged and the costs being just too high. Then, because after a point you lose focus from the arbitration and you are too focused on getting data or admitting and denying that data, and simply for the arbitral tribunal to pay so much attention to that data. It brings in a lot of issues which are extraneous to the arbitrations, and for one party at least it always makes sense to insert or introduce those controversies which are not germane to your arbitration. So it is really incumbent on an arbitral tribunal to ensure, to almost have a watchdog like oversight on the sort of data being introduced, on the sort of witnesses being examined and being called upon to testify. So from that perspective, arbitrations definitely can give you a lot more tailor-made resolutions than in litigation.
Well, that's fine. We got an idea. So, do you have to file an application for e-discovery to be considered in a court of law? Yes, I come directly to Shantanu. Shantanu, in the matters that you've done since so long, more than a decade now, so have you come across matters which directly deal with the breach of data? And then that too at a higher level wherein the government is involved, and then you do not know, maybe there is an international attachment addendum to it. So how is that finalized between the Indian government and the countries abroad? Is there a law substituting something like that?
So we normally take it up at the ministry level in the first instance. That's the normal route you'll have to take, because there's a Hague Convention angle which is also involved, and it also talks about the sanitization of the data and the documents which are required to be done. But I think let me first answer to what Sir has explained here. The way we advise our clients that which is the best route when it comes to arbitration or litigation in matters of data privacy breaches. Now, the way we look into it is from the perspective of one time that we have identified that there have been certain breaches which have taken place, but still the entire episode is not clear to us. So in that instance, I think court would be the better forum to approach. Right. Number two is the fact that you are looking at certain interim relief. Now, when you talk about data breaches in the corporate data and all, we had one case wherein, few ex-employees of a very big IT corporate, they were moving out, and there were massive indications and also some technical evidence in place that there have been breaches, and the process is already on. They have been transferred into their private laptops and private servers, so on and so forth. But still the entire process was not visible to all of us. So therefore, and for that instance, the court was the best forum for us. And just to substantiate what basically came out, the concerned judge, and Justice Hari Shankar, I may say so, he went to the extent of saying that an exiting employee has absolutely no business of transferring any data which belongs to the company, even though that particular data may have certain elements of his own personal data. Because the fact that the data belongs to a corporate, which means it's a proprietary data of that corporate. And for that instant, even if it has to be transferred, it has to be done through due process, right? We talk about copyright breaches and technology protection breaches and so on and so forth. The important element in Section 65A of the Copyrights Act states that the moment you try to initiate certain activity which would essentially breach the technical measures which are deployed to protect your copyright, the process itself is a criminal violation. And that amounts to certain amount of penalty, so to say. But for the purposes of investigations, still that is something which is there, an exemption which is provided to you. So these are the aspects by which, in the earlier panels talked about checks and balances. The Act itself, have all the enactments, so to say, have certain checks and balances in place so as to ensure that the proprietary and the personal rights is in tandem with the rights of the corporate, so to say.
Yeah, thanks. I would come directly to Alakshendra now. So after COVID struck all of us, e-courts were there in motion in India, but before that, I've been to Australia and I've seen that only e-courts work there majority of the times. So coming back to India, and that too after the COVID times, Alakshendra, what do you think? The scenario of e-courts in India, protection of data in the e-courts, who owns that data? Is it the government, or it's the judiciary per se, or it is some internal committee mechanism that protects that data? And would that also, I mean, all three of you, would also that be covered under data protection? Because that is also data. Yeah, please.
So, for a little more context, Sumitra, unfortunately I don't litigate, so Arnav and Shantanu would be best placed to answer that question. But what I do is I advise on transactions, advisory and policy, right? It would be essential to determine who is the data fiduciary in this case, or for our European counterparts, who's the data controller, right? In this case, it would be the person who administers the E-code as the data processor. Zoom, WebEx, whatever tool is being used would qualify as the data processor.
I would like to interrupt here.
Yeah.
So when you frame policies also, right? So when you frame a policy, what do you think? Are you going to integrate all of these things?
So we try to educate our business counterparts, our clients, on what are the best practices, right? What are some of the prevalent norms that they have to follow. And like I said, we get very, very picky with our clients. We want them to map everything, each data touch point. We want them to list out the processing activities. It's popularly called a ROPA, record of processing activities in Europe. And then around that, once we have all of this information, we not only draft their customer-facing policies, but we also ensure that there is sufficient internal governance. There is an access policy in place, there's an information security policy in place, and the list goes on depending on what their operations are. But we get very, very granular, and this is the need of the hour, because while, like my colleague said, the act is in place, it's yet to be notified. The rules will shortly be out for public consultation. We don't know when, it's been a year, just like the Mediation Act. But we have to have a forward-looking approach as opposed to a reactive approach, where we understand the contours of the Data Protection Act, right? For example, if there has to be informed consent, it cannot be simply an opt-out, right? The Act mandates that there is an affirmative opt-in, that you take informed consent from the data subject. So these are some of the things that you have to be mindful of while drafting the policies, not just the customer-facing policy or the user-facing policy, but your internal governance policies as well.
Yeah, thanks, Alakshant. With this, we would come toward the end of the segment of this panel discussion. I would like to know from Arnav. Arnav, as a lawyer, what do you think? See, law is there, act is there at place, and technology. Now, technology is driving the law, and similarly, law and technology, they are working together. So do you see any challenge in this as a lawyer or as the citizen of our country? Do you think by using technology as has been instructed and coded in the Data Protection Act or the IT Act of the year 2000, as a lawyer, what do you think? Are there challenges with law and technology? Is there a conflict?
So, essentially, if you look at the Data Protection Act, even today, obviously the rules have not been notified, or they have not even been out for public consultation. A lot will depend on how it shapes up. But if you think about it, like who is owning the data is still out for question in any of these complex disputes. So the fact of the matter remains that if I have a complex arbitration, at the end of the day, if the data is not accessible by me, but the data is supposed to be belonging to me, then where does the liability lie? And secondly, every data, especially e-data, you have to look at it with a context. If there's some metadata along with the e-data, and that is not able to be brought forth simply because of the passage of time, because of decommissioning of servers, what is the liability on the party not bringing this data? Traditionally, it would be a case of this lack of data not being brought to be assumed against you. It would be a presumption against the person failing to bring forth that evidence. But should that apply in all cases? So I think the rules, to a great extent, should highlight these aspects. It needs to be very technically thought. It should not simply be a rudimentary exercise where you're just using the traditional thoughts of evidence in the data protection rules, because what will eventually happen is you would be facing with a lot of complications like you're seeing with the BNSS today. And there's a lot of procedural hurdles that is coming up. So yeah, from that perspective, it definitely, it's an uncertain time, but a more scientific approach would definitely go a long way.
Very nice thoughts. So Shantanu, finally, we would like to wrap up with your words. I'll come back to Alakshendra also. So as a lawyer, do you find a conflict in technology and law and in the matters that you've done? Are there any examples where you've seen there is a conflict?
No, I think there's no conflict as such. Law has always tried to catch up with the pace the technology catches itself. But the fact remains that there is ample powers within the legal framework available to an aggrieved person that the reliefs are properly met. Now, DPDP, as we rightly say that the rules have not been notified. It does not mean that there were not issues of any personal data violation in the past. There is a guarantee within the Constitution now after Puttaswamy. There have been contractual arrangements available inter se parties. There are arbitration clauses in certain cases which is available. There are IPR, enactments which deal with these, types of violations. So I think, in our experience, there have always been situations wherein the aggrieved party has been able to get appropriate relief. Now, I'll give you a very basic example. We had a client, a group of shopkeepers based out of South India. They had their data which they have provided to some sort of a vendor, and all the personal data, including bank account details, were given. And that basically demonstrated the entire, regional taste of a particular product in a way. And massive information was available, which also included certain personal data. Well, those data were violated 5 years ago. There was not even within the horizon we had something like DPDP Act, but then they got relief. They got interim injunctions, they got, the direction were passed for the court-appointed officers to go and do the forensics of their laptops. The discovery was taken out, the reports were filed in court, and the court adjudicated on that. So I think in my humble submission, obviously it is a good law which is coming in place. What they have identified is that it has led the focus into the individual as the proprietary owner of his personal data in a digital format. But the fact remains that the legal framework itself was pretty much, existing all the way. For example, a very basic example of Section 79, IT Act. Now, we see most of the litigation under IT Act in Section 79 in high courts. So even though the IT Act itself provided for a tribunal, we all knew that, with our experience, the tribunal were not that functional. The adjudicating officer was hardly available because he was involved in his administrative affairs. But we had the High Court to go to in a way. So we always had these situations available.
Thank you, Shantanu. I finally come back to Alakshendra. So all of you here, we all know what is digital divide, right? So Alakshendra, this question would be a wrap-up question for this segment also. So provided there is a digital divide in our country, and also the rural and the urban infrastructures are different, rate of literacy 57%, and also rural areas turning into suburbs, and urban areas turning more into, for example, Bangalore and now Noida also becoming an IT hub. So there is a segment of population who knows about cybersecurity, who knows about the laws. There is also a segment who doesn't know anything, all right? So this is for all of us, but Alakshendra, I would like to know from you, what should we as lawyers, as educators, as students of law do to overcome this digital divide and lead our country towards Viksit Bharat?
So I just want to rewind to how access to information and access to technology has changed over the years. Without naming any corporate entity, availability of internet became very, very easy, right? It was far more cheaper than what it used to be. Everybody had access to fast internet on their handheld devices. And this is a topic very close to my heart, which is satellite comms, right? Our telecommunication legislation has also changed. There's a new act in place. It's being enforced in notified and tranched manners, and there will soon be a more regulated regime for satellite telecommunications. Satellite telecommunications, as we've seen in other countries, made internet accessible, made the broadband accessible to far-reaching parts of the country. Places which are not serviceable today in India, it's highly likely that as and when SATCOM infrastructure develops, these folks will have access to technology and consequently access to information as well. As for the digital divide, I feel like that's the short answer among other teething issues which will come up and larger issues which we don't have the liberty to discuss. But once you have access to information and access to technology, that digital divide is bridged. Now, to that end, lawyers too need to evolve. There is a dire need to embrace technology, embrace new practices, look at our colleagues overseas and understand how are they evolving, what have they done in the past. And we need to, like any other services, we mentioned that, you know, access to public sector, public infrastructure, the various things that we do today, there is an inherent underlying layer of technology. We need to understand what is it that we can incorporate in our practices, whether we are working on contentious issues or non-contentious issues, whether we are a litigator or a transactional lawyer. We need to understand what is it that we can do to not only make the lives of our clients better, but also be able to serve the general public at large. Thanks.
Thank you. So before we open the floor for questions, a one-liner message from all the esteemed panelists. 75th Constitution Day, और हम सुबह से शाम तक आज यहाँ रहेंगे. हमारे लाइफ का एक ऐसा दिन जो हम लोग साथ में थे. आप ऐसा क्या मैसेज सबको देना चाहेंगे या अपने लिए भी ऐसा क्या संकल्प लेना चाहेंगे जो विकसित भारत की तरफ ले जाए? Your one-liner message for everyone.
One-liner तो नहीं, it will be more than a liner, but essentially, I think one aspect we can focus on is that the laws that come out henceforth should be, as I said earlier, should be a little more scientific, should be something which is a little more technically informed. Then what will happen is unprecedented situations or situations which are very novel can also be tackled, and we don't have to wait for years for some judicial pronouncement to come around and you know, sort of reconcile that situation.
Nice. Shantanu, your message on the 75th Constitution Day.
I think, see, I will not be, I'm not generous enough to pass on, these type of information. People are very smart, and just general message to young lawyers and budding law students and all. Now, the way I experience my professional growth in a way is that one has to be absolutely true to oneself, in a way. Now, I see a lot of empty chairs as an observation. It does not mean that the students who are sitting at the back do not have a point of view. They certainly have. So it is not always important to be on the front row, but the fact that you are inside the room itself demonstrates a lot. That's it.
Alakshendra.
Thank you. I think I'm the youngest lawyer on the panel, so again, to add on to what Shantanu said, I think it's very critical to understand why we are here and where we are going to be. We need to understand how the jurisprudence of data protection and privacy as a concept has developed. And, like I said, the rules are soon going to be out for stakeholder consultation. This is not limited to actual stakeholders. You can interpret the law, you can read into the law, you can understand what the past was, where we are at today, and what the future is going to be, and you can indulge in these consultations too. So maybe that's an exercise everybody can pick up in the room and see where we go from here.
Thank you. We now open the floor for questions. Do we have questions for the esteemed panel here? Feel free to ask. No questions? Okay, so before we end up, one thing, I would like to certainly give a message. This morning when I had to come here and not to the university where I'm teaching, I was just thinking one thing which stemmed up from the very thought that how India became independent and how are we celebrating the 75th Constitution Day. सिर्फ एक ही सवाल था, क्या ये ज़रूरी है? क्या आज़ादी ज़रूरी थी? क्या संविधान बनाना ज़रूरी था? क्या उसको निभाना ज़रूरी था? तो अपने आप से प्रश्न पूछिए, क्या ये ज़रूरी है? Also for the lawyers, when you prepare the matters like we teach also in the classrooms, is it important? And that sets the entire context. So thank you everybody for the patient listening. It was a great panel. Many thanks Shantanu, Alakshendra and Arnav. Let's have a round of applause for the panelists. Great deliberations. I'm sure we all will remember 75th Constitution Day. Thank you so much, INBA, also. Doing a great job, and knowing INBA for 10 years around has been a great journey. Congratulations also for this day. Thank you.
Thank you so much, ma'am, for moderating this extremely informative panel, and thank you so much to all the speakers. So this was an extremely relevant panel discussion, considering as lawyers, most of our jobs have anyway become extremely dependent on technology. Instead of carrying physical files, we now all store everything on our digital devices. Most of the filings in court is e-filing. We even attend most of the hearings through video conferencing, so definitely our jobs have become more and more dependent on technology. Quickly moving into the second panel, the third panel, sorry, which will be the last panel before we break for lunch. I would like to invite upon stage the moderator for this panel, Mr. Sanjay Tandon. The topic for this panel discussion is intellectual property protection and enforcement. Mr. Sanjay Tandon formed and set up the Indian Singers' Rights Association, which was the first copyright society to be registered in India. He was instrumental in strengthening the Indian Performing Rights Society Limited, which is the Music Royalty Collecting Society of India. And he has also pioneered the movement for copyright administration in India. I would now like to call upon the panelists for this panel, starting with Dr. Sajid Sheikh. Sir is the founding faculty member and assistant professor in Maharashtra National Law University. He is dedicated to legal education, and he founded the NGO LawLex to advance legal education in India. He has expertise in intellectual property rights, as is evident through his immense contributions to law journals and informative lectures at prestigious institutions. I would now like to call upon Mr. Aditya Narendra Shah. Sir is a seasoned legal professional with over 10 years of experience across FMCG, automotive, insurance, and manufacturing industries. As the lead legal at Endurance Technologies Limited, he oversees legal, secretarial, and financial functions. His expertise includes contract negotiations, regulatory compliance, and risk management. I would now like to call upon Mr. Ajay S. Rao. Mr. Ajay S. Rao is the managing partner at Rao & Rao Attorneys at Law. He is a seasoned attorney with over 16 years of experience in intellectual property, corporate commercial laws, and dispute resolution, and he specializes in trademarks, copyrights, domain names, designs, IP litigation, and transactions. So you make a
Thank you for the lovely introduction of all of us. And it's really a great pleasure to moderate a session with so heavyweight people with me here on stage. When I talk about heavyweight, it really means a lot of experience, a lot of knowledge. And yes, I heard some earlier speakers say about the attendance. But for me, I've always, it's been 40 years that I've been in the enforcement of copyright and intellectual property. But yes, I understand that even 2 or 3 people sitting on the chairs opposite us is more than enough, because that's how knowledge grows. There's just one seed, but then when the seed sprouts, the entire tree comes up. So you all are seeds. We are giving you the information, the experience that we all have, and then it's for you to really get it into a tree by discussing things with your colleagues, your friends. So thank you for taking out time, all of you students here. Thank you so much for coming and attending these sessions. And without further ado, this panel is about enforcement. So we all have decided that all of you are anyways very gyani. All of you are students. And more than that, you are in an age where you can always check out with Google Auntie sitting there when we are talking. So we don't really need to have any gyan giving exercise. But yes, we will definitely share our experiences on enforcement, which really is the practical things rather than everything. And then you search for yourself how you want to do it for your future in your careers. So starting with the academia entire thing, I would definitely love Dr. Sheikh to really take the microphone first and give share his experiences as to the challenges, etc., or what is there in the academia part of it, and then we'll move on to the business and to the other parts of it.
Thank you, Sanjay sir. Very good afternoon to all of you. So many of you, I feel more students are here. So educational institutions, they foster research, they create research, and a lot of opportunities also. They impart education. So IP becomes a very, very important point when we talk about academic institutions. IP, as you all know, it's creation of human intellect. Multiple types of IPR exist: patents, copyright, trademarks, trade secrets, industrial designs, geographical indication, plant varieties, so on and so forth. But when we talk about academia and intellectual property, there are a lot of challenges which the academic institutions face in IP creation, IP enforcement. And some of the challenges and some way forward I'll try to bring in today in my points. Firstly, the first point is about the copyright infringement, which happens sometimes by the way of plagiarism also. A lot of various types of plagiarism exists. Whenever we use somebody else's work and show it as our own work, it is plagiarism. Sometimes ghost plagiarism is there, self-plagiarism is also there. Even UGC has created certain guidelines regarding academic honesty and integrity, wherein there are certain penalties for students also, for faculty also, if they engage into plagiarism. Second is the challenge which has come up because of generative AI. Recently, it happened in one of the schools at Sonipat, and at international, global level, ChatGPT and other generative AI have become a challenge. Challenges with respect to the authorship, challenges with respect to the ownership, who owns the rights to the work. Next challenge we find is that we do not have a clarity on photocopying. How much photocopying is allowed, how much it is not allowed. Though some guidance generated from Delhi itself, the Rameshwari photocopy case, wherein the course module, etc., they were allowed that yes, they were considered to be within the course of instructions of pupils, which falls within the exceptions under section 52 of the Copyright Act. But of course, the other part of it was that there were certain books which were totally photocopied. Of course, the court could not determine about it because the case was withdrawn, because of a lot of public pressure from students and academic institutions. Next challenge which we face is that academic institutions, they are not fully using the power of branding. Many, even the institutions' names, etc., they are not trademarked. There are a lot of programs and events like Mood Indigo, and many more are there which are not trademarked. So a lot of scope is there by using this very power of branding. So there's a need for revising curriculum design, wherein IP is, because we see that sometimes IP is an optional subject, okay? So I think at that point also there is a thought which should be put in. Problem also arises with respect to the research quality, be it with respect to the engineering colleges wherein they are creating some invention and all. So, the benchmarks are not so clear about that very quality, and research incentivization is also missing with respect to the institutions. There are problems regarding, technology transfer as well as, funding opportunities. But there is a way forward. Now, I lay down some challenges in 2 minutes. I'll cover up some way forward which are there. So institutions should take up some responsibility. Now some changes are happening wherein with respect to the PhD research, even the supervisor has to submit an undertaking that this is a new topic which has been taken up, and the work has been done by the student itself. So some responsibilities on the supervisor also. With respect to the ethical use of AI, of course, see, we cannot ignore generative AI. We all use it, but ethically we have to use it. And many institutions, including mine, MNLU Mumbai, we have come up with ethical use of AI policy because we cannot get away with that. Second is that orientations should happen with respect to the library staff. So Indian Reprographic Rights Society has given up a limit that it's 15% of photocopying is allowed. Okay, but again, at education level, institutions level, we are not so clear. So a lot of awareness needs and training of library staff needs to be done. Curriculum should be revised because there was a saying, let us catch them young. So at the school level, at the primary level, some recognition of IP, some modules should be added so everyone can recognize IP. All institutions must have their own IPR policies, because what happens in the beginning, they do not have any policy, and when someone conducts a research or invents something, then they plan up makeshift policies. So the researchers are also not incentivized, and it creates a lot of problems with respect to the revenue sharing and all. Also, so lastly, lot of focus, more focus is on the patent aspect. So I think there is a need to focus on all IPs by the academic institutions, be it copyright-based, be it design, trademarks and all. A lot of awareness with respect to intellectual property is needed. And lastly, I also feel, because I was talking at an AICT event, so there is a need for an IP marketplace for academic institutions, wherein the prospective clients, if they find some benefit in IP, they can get hold of that very IP, and it will help in licensing and all. So those are some of my suggestions with respect to the challenges and way forward for academic institutions. Thank you.
Thank you, Dr. Sajid. In fact, you have very aptly put the points across. One is the challenges that are there, but I'm so happy that you then also offered solutions. Because challenges are mostly spoken, but how to overcome those challenges is also very important. And it's very, very important, as you rightly said, that the academia should be there and should be tapped at that source itself. And we all have to work on that aspect. You mentioned IRRO. I am the one who made the IRRO in India. So I'm the culprit there. But yes, we all need to respect copyright, whatever it is. And because in the Indian culture, we all think IP is free. That's the mindset. And that is the mindset that has to change. Unless the mindset changes, there is going to be litigation, and there's going to be a long-drawn litigation, everything. And litigation is not the correct way to proceed, because that is a property. It belongs to a person. Like a physical property, there has to be clarity about intellectual property also. And that clarity can only happen when we tap people at the youngest of the ages. So as you rightly said, at the education level, at the lower education level also, there has to be something done. And I'm sure the till that meantime, I would now request Mr. Aditya Shah to take the floor. He has an experience in being an in-house counsel. So after you heard the academia point of view, there are challenges even while implementing it through the in-house councils. So Aditya ji, I will request you to now to share with us that experiences so that the audience really knows, as an in-house counsel, what are the challenges, what are the way forwards there.
First and foremost, thank you, Mr. Tandon, for all the insightful. And as the panelist right now mentioned the basic insights of the academical purposes, I would first like to set a basic context on the IP perspective of it. IP in itself, I feel it is a subject which is now becoming critically important and more relevant in this fast-paced world and interconnected world. So this particular aspect needs to be taken care of at a broader level. So this tool, I personally put this tool into three basic buckets. That is, it is a backbone of innovation, a cornerstone of creativity, and a tool for an economic development. Having said that, IP, as Mr. Tandon rightly said, we have a basic mindset that IP is free. I mean, ye sab chalta hai types. This particular scenario does not work in the very long run, because IP, being an intangible asset, it has certain effects which are profound in a real life world. The effects may be on individuals, it may be on businesses, it may be on industries. It has a wide impact in itself. Having said that, right now at the moment, India basically has strived up to improve the IP framework through its reform. Basically, we had introduced an national IPR policy, and there were certain updates from design, patents, copyright, trademarks, which per se improved the IP framework at a broader level. This particular scenario has encompassed the basic needs of an IP for it to make it into a particular tool. Basically, all of them make sure that this IP is promoting for one particular angle, that is for promoting innovation, creating jobs, and ensuring the fair market play. Having put them into one place, there still remains an arena of challenges which are yet to be cornered. At a broader level, I would say it is a proliferation of counterfeit goods and infringement. Right now, in the present scenario, the counterfeit goods and infringed goods are sold at a very multi-channel level. For an example, at an e-commerce website, you type in per any different product, the 10 different aspects of it would be there. And like just for the academic purpose of it, I would put right now the term of an apple. You search any Apple AirPods out there on an Amazon website, you'll find it ranging from say 100 to the actual price of it. So there are different counterfeits in the market which needs to be carved in. So which basically is a broader thing that we need to take care of it. And if per se that particular device has any aspect, it would basically affect a brand in itself. The question of whether these goods are counterfeit or not, that would be a secondary question. But the first thing that you'll hear in the news is that because of this particular brand, this particular activity happened. Whether it is being done by them, whether it is an original good, whether it is used in the proper manner, that are all secondary aspects. That generally news or media do not per se profitly say that this is the aspect. They do not put it on this forefront. So at a broader level, this messaging has been done. So this kind of demeans the brand value in itself. Coming to the second point, it is more specifically to a legal and procedural delays. In India, the Indian judiciary has its own profound ways of efficiently managing the litigations, I would put it in this fashion. But the IP in itself requires a timely approach which needs to be catered to. If the IP, if we do not get a remedy within the due timeline, what it will impact is it will impact the businesses in the very long run. It would kind of bring a business to a standstill if that particular business has core business which is related to that particular IP. Then I would put into a new technology, the role of a technology. As everybody, the talk of the town right now is in AI. Everybody is aware of what AI is, what it does. So basically, it has kind of disrupted the traditional way of doing any business. So for me, at a personal level, I feel that there is a different question kind of scenario, whether the patent, whether the innovation in AI or a blockchain, can it be patented in first place? And how can it be monetized? So this has its impact in itself, that whether patenting any innovation in AI or a blockchain, whether it would create a monopoly, would it be dangerous for the existing business? That brings up to a different ballpark discussion in itself, because that is not a very small topic. It needs a deliberated discussion, which right now many of the court cases are being going on. Yesterday in itself, there was one committee which was been set up for this AI perspective. So there are different aspects which are being catered into. And then having said that, these are the basic challenges. Also the globalization of and the counterfeit, how you have your global strategy in place to ensure that the infringement or counterfeit goods are captured and enforced in a manner which you have a multifaceted strategy in place. Having said that, there would obviously be challenges in each and every scenario, like this particular IP enforcement has. As an in-house counsel, what I feel, there are certain basic principles, basic hygiene checks that one can have in place, which would enable you to have an proactive measures, which would put you into a safe corner zone, not a safe corner, but in a stable corner zone where in this ever-changing landscape. First and foremost is if you're building an IP portfolio, if you're into a technology company, we have to make sure that we work with our R&D team or an innovation team and build a portfolio, IP portfolio, where the documentation, we have the most important aspect is the documentation. We have a well-drafted and robust documentation in place, which would kind of curtail the future risk that can be happening. Then comes the point, which is the most recent, which I personally have used, is using of a technology in case of an enforcement. Right now, there are different companies which offer different tools for monitoring your IP at a broader level. If there is any issue or any violation which they observe, they can immediately notify it to you. So once you have been notified, you can take a swift action. That is a bigger point and a very, what I should say, it is at a very nascent stage, you can take the actions. It would hamper the huge impact that it can have in a very long run. So utilizing this particular services, utilizing the technology, like the AI can be using for monitoring, the blockchain can be used for monitoring, for taking out the source of that particular infringed or copyrighted good. So that particular things could be in place. Having said that, there is also a thing of having a global strategy in place. So if per se, say your company has an aspect of which has its offices across various locations, in that aspect, what I would suggest is that we can have a mechanism in place which basically counters that each and every IP which you have, it's been registered, it's been monitored, it's been upgraded from time to time, and it has been used in the right manner and fashion. So once you have that in place, you kind of have a basic frontier in place which would enable you to enforce that particular rights in the very long run. Then there comes my favorite for me is more of a collaboration. So collaboration is the one thing, as an in-house counsel, I per se in isolation cannot do anything. Even if I have that kind of legal knowledge, I can pick up the books, I can do things. For me, as an in-house counsel in isolation, it is of no use. I can just speak up. It would be more of a barking dog kind of scenario. But for me to enforce that particular aspect, I would need the help of the stakeholders. For the case, maybe it might be a different scenario for each and every one of them. It would be police, it would be DIPP, it would be customs, whatever the case may be. But you need to ensure that you have a collaborative approach with all of your stakeholders, depending on the case that you have. So having summed up into all of this, I would kind of be bullish on the IP. How it would be going forward is, for me, it would be two aspects that IP would be drafted and IP would be moving on into, which would be more of fueled kind of scenario with the changing business global dynamics at place and the technological upgradation. So these two aspects would add on to the dynamics of IP at a greater scale. And then to sum it all up, if you ask me what would be the key to success for enforcing an IP, if you ask me on a two-word basis, for me, it would be first as in collaboration, secondly is a technological absorption. So these are two bit pieces from my side. I'd like to hand over the mic to. Thank you.
Great, thank you, Aditya-ji. In fact, yes, whatever is the future way ahead and everything, what remains the basic core, as you rightly said, is documentation and monitoring. And as you mentioned about the protection and enforcement of the brand, we on stage have Ajay Rao-ji here also, Mr. Rao, who has a great experience as an attorney, and he has been doing he was working with a lot of brand adoption, as we call it, and the enforcement aspect of it. So now I would like to invite Mr. Rao to take the microphone and share with us about the enforcement aspect of it from a point of view of criminal and civil aspects.
Thank you, Sanjay ji. Like Sajid and my friend Aditya mentioned, I have been a practicing attorney in IP for more than 12 years and have been in-house as well. And I totally agree with what Aditya was saying, the challenges which they face being an in-house counsel. So like he mentioned about enforcement. So enforcement typically is civil and criminal. So I don't want to get into the legal aspects, but I just want to share my experience. So as an attorney, we file suits before Delhi High Court. We get a local commissioner appointed. We do a search and seizure. And then, depending on the outcome of the matter, it gets settled. But what is important here is, we also, like he said, alone we cannot work. In enforcement as well, you need to depend on the investigating agencies who normally find out about the counterfeit or lookalikes or, such products. And these investigating agencies play a pivotal role. Apart from, yes, client input and stuff, they are the ones on the ground who will help execute the commission, liaise with the police, and also help in a seizure of the goods. And if court orders destruction, then they are also there to destruct the goods. Now, this is civil. You file a suit for infringement, you get an LC appointed and stuff. Now, being in-house, I have done extensive enforcement actions for over 6.5 years for a international oil and gas company. And there was a lot of counterfeit which happens, especially in North India, regarding oil, automotive oil. And it is to identify the counterfeit, even for the investigating agencies. So we would conduct training programs. Because first, like he said, we need documentation. So globally, we would have a documentation which says what is the product, what are the identifying features, and if something changes, then how much change is acceptable in a packaging. So this training, this documentation is very important in enforcement, because without which, I don't think it will be possible to identify a counterfeit product or a lookalike. So to sensitize third-party agencies, conduct training for them, work with them, and be a part of whenever we conduct raids. So the criminal side is, normally it's easier to go under Copyright Act for conducting criminal raids, because if you go under the trademark, though you have a trademarks registration, if you want to file a police complaint on the basis of trademark, then the police will seek opinion from the trademark office. And that opinion will take its own sweet time to come. Here, time is of essence. Because all these counterfeiters are fly-by-night operators. They will operate for 2 months, 1 month. They will shift places. So time is of essence. So that is why easier option is to go in under Copyright Act and get a police complaint filed. Then investigating agencies, we go with them, we conduct raid, and in criminal action, the counterfeiter is arrested. Whereas in civil, there is no arrest done. He is only informed, he is given a superdari nama and said, boss, appear in the court next date. But in criminal action, he is arrested then and there, put behind bars. And then FIR is lodged, and then it becomes state versus so-and-so, the counterfeiter matter. In criminal action, I think, is much more effective. And effective in sense of the presence in the market, the deterrence it causes, and also cost effective. Because in civil matters, yes, you have to file a suit, you have to pay the law firm to draft and file, appear, you have to pay the LC. So cost-wise, if, for example, I say doing a civil enforcement would cost today anything between 5 and 7 lakh rupees in Delhi NCR. The same thing under copyright in criminal might, whatever you pay the agency, that is, it will be much, much, much less. And the market deterrence it has. So if there is one counterfeiter identified, arrested, there might be 5 more, which me as a lawyer doesn't know. But then the deterrence it causes that those 5 also will stop operating for the next month, 2 months. So that is very effective. And the arrest, then police also sometimes, if it is food product, then under Food and Adulteration Act, police suo moto can arrest. Though we have gone to execute a LC commission for a food product, if they find that, it is adulterated food or ghee or paneer or oil or whatever, police can also suo moto arrest the culprit. So enforcement at grassroots level is very important. Now there'll be big players also, running factories. Because as a practicing attorney in law firms, I was dealing with a big FMCG company, and this party had a full-fledged manufacturing unit, like a factory running in Uttarakhand, with huge amount of output of a food product. So they'll be to the extreme where they're making lakhs of rupees, and there'll be counterfeiters who are like fly-by-night operators, who just for one season operate and do. So enforcement, I think, is very, very critical when it comes to protection of IP rights. Yes, you might be, having IP protection in trademarks, copyright, design, patents, whatever. And you have documentation, you're aware of everything, all the remedies which is available in law and stuff. But unless enforcement is done, then there is no solution to end of counterfeits, end of lookalikes, end of similar packaging, design, etc. So enforcement plays a very critical role when it comes to protection of IP rights. So I would like to just end on that.
Yeah, I do agree, and we all, I think, know it, and we have to agree to the fact that IP is a very, very important property, and it's a non-physical property. It really, I have, now it's my turn to share my experience. So I have always, for the past 40 years, been dealing with copyright infringement. And copyright infringement is akin to trademark, patents, etc., because there at least there is something which is physical. In case of, and even in copyright, I have been doing it for music. So I'll just share with you the music copyright and its infringement. So as all of you know, music in India is consumed every 100 meters. You will never find a place where there is no music. Even if we are in the bathroom having a shower, we tend to hum or sing. So we are actually singing. Not that that comes within copyright, by the way. But what I'm trying to say is music is right from childhood, right from birth. But that music that has been conceived or created, that has got an investment. And therefore it is important that we all, or rather every citizen of the country, views music not as a birthright to use it free, but as a right to use it, make money out of it, but at the same time compensate that creator. It also becomes important, एक तो law होता है, law बोलता है चोरी करना भी जुर्म है, मगर चोरी होती है ना. So copyright law भी कहता है कि ये होगा तो copyright infringement माना जाएगा. That's different. Let the courts etc. That's the झगड़ा वाला part of it. But the mindset, unless we become a more copyright aware country morally, this particular aspect of copyright infringement can never be tackled. One cannot go to courts every time, and that's why everything in music is always treated as, oh, take lenge. वो नहीं होना चाहिए, and that's responsibility, I always feel, rests on two important people. One is the academia, because at that juncture itself you should make them. जैसे हम बच्चे को ABCD सिखाते हैं, वैसे ये भी सिखाना चाहिए कि म्यूज़िक जो है वो किसी ने क्रिएट किया है. और म्यूज़िक में भी ऐसा होता है, हम सब जो हैं वो एक ही म्यूज़िक नहीं सुनते हैं. Everybody wants to listen to चोली के पीछे क्या है, हाँ, या वो फेविकॉल से चिपका दे, or whatever that song is. Nobody wants to listen to a thumri. Okay, nobody wants to listen to a rag. But I'm not saying that you should, because that's a personal choice. But you have to realize that out of 100 compositions or 100 songs made or invested into, only one gets to see the light, gets to see the hit day. ये देखिए, ये भी जो लगा है कितना मधुर संगीत है. तो जिसने लगाया है उसने उसका चार्ज दिया है कि नहीं, you should know. Is it use free? Is it has been downloaded and taken? Is it on subscription? You know, all these things, unless we become aware of it, copyright infringement is just a word. And the courts will be loaded with. Courts don't have time for all this. They have still more serious things to attend to. So that's why I always appeal, let's treat music as music. Let's respect music. We all keep on saying, and most of the big associations और जहाँ भी हम लोग program करते हैं, stage shows करते हैं, वहाँ organizers artists को invite करते हैं और हमारी शोभा बढ़ा रहे हैं. शोभा मत बढ़ाओ भैया, पैसा बढ़ाओ. Okay, that उसका घर जो है शोभा से नहीं बढ़ता. Okay, शोभा से उसका घर नहीं चलता है. So, and I keep on saying, people call the artists on stage, they give them that nariyal, coconut, give them the shawl, that's a respect, okay. But वो नारियल से क्या होने वाला है? उसका घर एक दिन भी नहीं चलने वाला है. जो पानी भी निकलेगा उसका भी पेट नहीं भरने वाला है. So, the point is, instead of this, respect his copyright. Respect that he needs to be paid, not as a matter of being, दान, या okay, ठीक है, दे देते हैं. No. As a right. And I have done this. Of course, again, that was a physical property. Again, I'm giving you an example of, I was fortunate enough to start off the era of John Doe orders in the country for films. I started it with Singham and Three Idiots, and Anand was with me on that. So we got John Doe orders on that aspect, and we actually dealt with piracy issues there at that time, and within 3 days, both the films did what they wanted to do. So for 3 days, there was no print available, there was nothing available, and those 3 days are Friday, Saturday, Sunday for a film. And that's all it needs to recover back their money. The other is, of course, a bonus. So these are the various measures, of course, the law has given to this thing, but I agree, and I agree with the panelists here, that enforcement forms the knowledge, and then the enforcement aspect of it is very important. But the only thing I'm saying, enforcement together with knowledge and sharing of that knowledge is very important, rather than do that at the court level. Everything should not go at the court level. Even as a counsel, even as attorney, even as lawyers, you need to also advise the clients correctly that this doesn't make sense. Arouse that moral feeling. That's also one of your duties, rather than just look at, okay, court chalte hain, judge ye dega and judge wo dega. Arey wo bad mein aata hai bhai. Leave that alone. At that point itself, when the lawsuit is being initiated, that is the time when the clients should be counseled, should be this thing, provided you are aware of it, provided you feel for copyright, provided you feel that copyright should be respected. So that is very important. Rather than give any further gyan session there, I would now like the youngsters here, the students here, to ask some questions to the panelists, and there should be some questions. I know you all sometimes feel that, maybe I'll look like a fool if I ask a foolish question. Don't worry. Studentship is to ask foolish questions. Don't worry. That is knowledge gaining. Yes, please. Thank you. Thank you for asking. Thank you. Sorry, which rights would come? Yeah, AI, let me tell you, AI is a beast. But we need not fear the beast. The beast is here to stay. All that the government and we as stakeholders are working on right now is to build a fence, just to contain it. Okay? We cannot kill it. As I said, it is there to stay. So it is going to evolve. AI also has its own advantages. It's also very helpful, but it needs to be dealt with maturely. So जैसे कहते हैं ना कि बंदर के हाथ में उस्तरा दे दिया तो वो तो कैसे भी मार देगा. So AI is that way. It can be worked constructively, it can be worked destructively. So we are trying to build a fence. The ministry is also taking views, etc., from a lot of quarters, from a lot of stakeholders, and we are working on that. So as you rightly put it, yes, it will evolve. There is no answer right now that I can give on that this is what it is in law. But yes, there are sufficient laws which can take into account all these infringements. But instead of doing that and taking a wire turn through gullies and everything, of course, there should be a simple, straightforward law or clarity, and that is what will evolve through the period of time. Anyone, you want to, any answer to that questions? Okay. Any other question? Yeah. I think you can give the mic so you can record it. So, yeah. No, yeah.
There's an instrument player and a producer. So who does the IP actually belong to, and who can claim the right over it? Okay. Because at every aspect of it, there is money involved. The producer pays money to the composer pays money to the singers, and so who gets it back? Does it the producer own it, or?
So if you see section 14 of the Act, it makes it very clear that section 13 and then of course the 14. So Copyright Act makes it very clear that copyright exists in different things. So coming to music, there's a person who makes the tune. He is called composer, or music director, which we talk on layman's language. Then there's a person who writes the lyrics. He's the author of that words. Then these two people gathered together, a businessman comes and asks them to come to a studio and record that song. So that guy actually puts in the money to make a sound recording, the master as we call it. Composer has made the tune, writer has written the lyrics. But you also require artists to express them. So there is a singer who expresses it in vocal terms. There is the musicians who play the music. So there is a piano and there's a violin and there is drums and so on and so forth. So there's the musicians. And then finally, these all put together, somebody likes it and he wants to put it in a film. So he is the film producer. Now each one of them has got the rights as enumerated in section 14, 1A, B, C, D, E. So each one of them is entitled to their set of rights and therefore their set of money. So there it's a bundle of copyrights. Copyright is a bundle of rights. So each one of them gets that. So for example, the composer and the writer who are the creators, जिसको हम कहते हैं माँ बाप हैं, अब उसमें माँ कौन है बाप कौन है वो झगड़ते रहेंगे, but they are the mother and father of the child. So they get a set of rights. Right of reproduction, right of adaptation, right to publicly perform it in public, to broadcast it, to telecast it, okay, to reproduce it in a material form. Similarly, when the artist gets involved to express it, they get what is known as a neighboring right or a special right, which is under section 37. Under that section, they also get a right to publicly perform their part of it. Okay? Publicly perform their recordings as a part of it. And then the sound recording producer who has put in the money also has a right that anybody who uses that sound recording has to also pay royalties. So what in the end comes in this, if a composer or a songwriter's song is being played in public, he is entitled to get royalties under Section 18. Similarly, where a singer's song or a musician's played performance is being commercially exploited in public, he or she is also entitled to receive royalties. Then, the sound recording producer who has put in the money, if you are using the sound recording, you need to pay him also the royalty. So therefore, if you are performing live, suppose I am singing live here, there is no sound recording, you are not playing anything from Savan or Ghana, etc. I am singing and there is a band. In that case, you are not using sound recording. So you need not have to pay the royalty for the sound to the sound recording person. You need to ask yourself a question, which copyright am I using? So if I am singing, obviously I am singing a tune. Obviously I am singing the words. And therefore I need, or the organizer here needs, to take permission and pay the royalty to the composer and to the songwriter. But I'm not singing, I'm singing Arijit's song, but it's not Arijit's voice. So अरिजीत की परमिशन लेने की ज़रूरत ही नहीं है. गाना अरिजीत का नहीं है. आप भी गा सकते हो अरिजीत का गाया हुआ गाना. गाना जो है वो कंपोजर राइटर का है, तो आपको केवल उनसे परमिशन लेनी है. मगर अगर आप सावन और गाना या इस तरीके से आप यहाँ से चला दो गाना from your laptop or the DJ who does it, then you're using the sound recording also. And you're using the voice of Arijit Singh also. So therefore you need to take permissions and pay royalties to all of them. So that's how it happens, that everybody is entitled to their share of royalty. And each one of them determines the amount. That is the law there is, this chapter 6 which determines all details, etc. And therefore each one of them is entitled to say, भैया हमारा गाना बजाएंगे आप, तो आपको इतना देना है. मेरा गाना बजाएंगे आपको इतना देना है. And there are different set of tariffs. Gada Goda barabar nahi. If it is playing in a restaurant, what the restaurant needs to pay. Like for example, the Isamra, that is the singers and musicians. I represent the singers and musicians of the country, right from Lata Mangeshkar, Arijit Singh, down to the order, and right from people who have played 50 years or 60 years back in Mughal-e-Azam to the newest of the recordings. So I represent that. And therefore for a restaurant, all I ask them to pay me is a cup of tea, value of cup of tea every day. So whatever is the least price drink on the menu card is what you need to pay. That's very beggarly indeed. So that's how the rates are decided and they pay it. That's the answer. I hope I've answered the question. Yep. The lady and then you.
These are very, very old texts, so they would not be copyrighted, protected as of now. So life of the author plus 60 years have already gone. Now comes the question of moral rights. Now, who will enforce those rights is a question. So, again, that is the only question, because no legal heirs are there to actually enforce it or question it. So whenever something is in public domain, people are free to exploit it. Of course, they cannot distort it, all those things are there.
Yeah, so it falls under out of copyright because of course it's 60 years death plus 60 years, and but yes, internationally it's being discussed. This is what is we call as a traditional knowledge, and therefore the TK is being discussed from because like how we have the Ramcharitamanas, even African countries have a lot of aboriginal stuff there. So which we feel that the community should be responsible, royalties should be paid to the community for the community's welfare, etc. But at present, under the copyright regime that we have, yes, everything that you talk about Ramcharitamanas falls under non-copyright and it is traditional. Just one more question, because I've been told that we need to wind up the session. So one more question and then we wind up.
Why does the intellectual property like copyright have defined time period like 60 years, a lifetime of the particular author, and after that 60 years? Why it's so? Because like the property which our ancestors hold, we are also getting benefit out of it. Why it can't be in the term of the IP sector?
See, physical property in India, I think your lawyers will know better than me. I'm not too expert at that. But also it's about 90 years or 99 years. So everything has got a term. And in copyright, since it's felt, it has been felt earlier, not by us, we just followers in India, but yes, of course, in the European context, it was said that, the copyright of creativity, the creative aspect of it, the intellectual property aspect of it, is more or less 60. People are now changing it to 75 also, so that all is going to happen. We were earlier 50, but we changed it to 60 because of Rabindranath Tagore ji to extend his copyright. So these things are, over a period of time, are going to be felt in the new scenario of the world. And as you're rightly saying, because you are young, and therefore time, you're more sensitive to that. The earlier people felt that, 50 years is enough. And that's the reason why that was there. So yes, so before I end, we, as you must have seen, the panelists have been saying this repeatedly, that it's more important that everybody in the operational aspect needs to work together, whether it's the academia, whether it's the in-house guys who are really enforcing it for the owner of it, and of course the enforcement guys who really put the ground things up for respect. So it really happens to be, and as I said, it's more of the mindset. So before I end, I always want to end it on a very musical note because I come from music industry, and ये सब इतना serious होता है ना, तो मुझे बड़ा अजीब लगता है. और lawyers हमेशा serious होते हैं, बाद में बहुत मस्ती करते हैं बाहर जाके. I know that because I'm a lawyer too. So हम बाहर जाके गेट के बाहर मस्ती करते हैं. So I say, किसी की मुस्कुराहटों पे हो निसार, किसी का दर्द. Now clap it, यार. At least you can do the clapping. किसी की मुस्कुराहटों पे हो निसार, किसी का दर्द मिल सके तो ले उधार, किसी के वास्ते हो तेरे दिल में प्यार, जीना इसी का नाम है. I sang the song, जीना इसी का नाम है, कि किसी के मुस्कुराहटों में हो निसार, किसी का दर्द मिल सके तो ले उधार. हम सबको ये करना चाहिए अपने प्रोफेशनल लाइफ में भी, तभी कॉपीराइट रिस्पेक्ट होगा, तभी चीज़ें आगे बढ़ेंगी, तभी आर्टिस्ट का भला होगा. थैंक यू सो मच, एंड थैंक यू सो मच फॉर हैविंग दिस टाइम. थैंक यू.
Beautifully sung. I was anyway, sir, going to ask you to sing for us, and you made my job easier. So on this note, a very heartfelt gratitude to all our distinguished panelists for their insightful discussion on intellectual property protection and enforcement, shedding light upon the challenges and opportunities that lie ahead, quoting recent trends in the industry. Your expertise, experience, and passion for intellectual property law has enlightened and inspired all of us. Sir, thank you once again for all the participation. I wish you all the very best in future endeavors. Thank you. Now we are going to take break for lunch and we'll gather here again. Okay, sir. Esteemed guests and fellow participants, I, Shivani Pandey, welcome you all to the second half of today's event. I hope you had a wonderful lunch break and were able to recharge yourself for the rest of the day. So without further ado, let's start again refreshed and rejuvenated and move on to the fourth panel discussion of today's event. The topic for the fourth panel discussion is Digital Personal Data Protection Act 2023, a comparative study, which is to be moderated by Mr. Love Tanwani. I welcome you, sir, to the stage. Love Tanwani is a legal professional with more than 16 years of work experience in Fortune 100 and 500 companies. As a senior general manager legal at Cummins India, he provides strategic oversight and serves as compliance officer for Cummins Generator Technologies India. Love also holds key position in industry forum, including honorary chairman at Indo-American Chambers of Commerce and memberships of Confederation of Indian Industry and International Chamber of Commerce. So welcome you to the stage, and the stage is yours.
Thank you. So I hope we'll try to make this session more interactive as possible because it's post-lunch, so I don't want to keep you waiting. I would request to call upon Nazneen Ichaporia. She's currently the partner and head corporate commercial practice at INBA Legal. Welcome on the stage, please. She has 15 years of experience. Nazneen leads the private equity, M&A, and general corporate practice at the firm. Her expertise lies in commercial contract, IP rights, data protection, PE venture capital, investments, startup funding, acquisition, and many more. Welcome, Nazneen. I would request Srinit Mishra to come on stage. He's currently serving as an executive director, general counsel, regional senior counsel. Srinit Mishra serves as an executive director and general counsel and regional senior counsel Asia at Ball Corporation. He's currently leading the legal and compliance for the beverage business across Asia. His expertise spans over contract drafting, transaction negotiation, litigation management, compliance, and policy advisory. Welcome, Srinit. I would request Mr. Prashant Sivadas to come on stage. He is founder of Sivadas and Sivadas Law Chambers. He's a lawyer specializing in commercial litigation, arbitration, competition law, and corporate law. He has advised and represented clients across various sectors before top Indian courts and tribunals. So welcome, Prashant. And our last panelist is Ms. Renuka Chaudhary. I would request her to come on stage. She's a senior director at Automation Anywhere Incorporation. She is an experienced legal professional with over 18 years of experience across diverse industries, and she excels in cross-border contracting, particularly in high-value IT outsourcing deals. So welcome, Renuka. I think this topic has been talked quite a lot, but nowadays, because of the new DPDP Act coming into force and the rules have not still framed yet, we have experts on the panel who's going to talk about how it really going to concern them or their clients and how things will really turn up when this act is applicable. But just even if this act is not applicable, I think many people work for a multinational companies who either deal with European companies or US companies, wherein anyways the US law and the EU law is anyways applicable to them. So I'm going to, talk with the experts on how they, implement these laws and what are the concerns which they face on a day-to-day basis. And we have a mix of corporate as well as private practice. So my question to Nazneen is, what challenges you see specifically in comparing the Indian law, the European law, and the US law? Your bit, please. Thank you.
Sure. Thank you. Thank you for that, and a very good afternoon to everybody. So, kicking off with what sort of expectations or challenges that Indian businesses are going to face once the DPDP Act is implemented. So the Act has been notified till date. However, the implementation is going to happen soon once the rules are notified. And like I was just mentioning, that this gives us half the picture of what the regulatory landscape is going to be looking like. But the actual implementation side, the other half which is there, is going to become clearer once the rules or the guiding principles are at least released in a draft discussion form for people to get an idea. But it would be fairly accurate to say that the Indian DPDP Act has to a large extent been modeled on the principles of data protection under the GDPR regulations. So a lot of similarities in terms of concepts of data principle, the level of consent and other control that the data principle would have as to what happens to their data is similar to what would be the case under the GDPR regulations as well. There are certain aspects different which we'll touch upon as the discussion processes ahead in terms of course, the compliance requirements are more stringent in certain cases under the GDPR regulations. For instance, in terms of cross-border data transfer aspects, which we can maybe delve into a little deeper later on. Other than that, certain requirements for localization of data, which is also a similar concept recognized under the various global regulations for data privacy protection. So all in all, it's a good, and I would, in my opinion, it is a good attempt by the Indian regulators to finally have a statute in place which can compare and allay the fears of players worldwide that their data is is going to be safe and monitored even in India as well. Otherwise, the global outlook earlier in terms of lot of aspects was that foreign companies were hesitant to transfer or store their data or process their data, with Indian companies citing that, oh, we are not sure whether what is the level of compliance and regulatory protection aspect that India's regulatory landscape offers, though it has always been there in bits and parts, but there has never been a codified central statute which is looking after it, like how we had when the GDPR was rolled out in the EU.
Thank you. And I think the data localization has become a very costly affair and a very concerning for many organizations and even as a country. But I will come back to you on that.
Sure.
So before, we'll just hold on to that thought. I would request Srinit to talk about that, as your organization is based out of EU. And then how challenging you feel that this DPDP India law would be challenging, or whether it will be a concerning affair for you to kind of implement as General Counsel?
Thank you, Love, for that question. If the DPDA would have been a replica of GDPR, then it would have been a completely different ball game. But the way we witness it right now, there are a lot of granular differences that we see in the DPDPA compared to the GDPR. Just to name a few, if you're talking about from a data retention or from a perspective of on what grounds data can be processed, GDPR provides you with a wider ambit compared to DPDPA. Similarly, something like a significant data fiduciary, that's unheard of as a concept under GDPR, but it's there in the DPDPA. And the kind of obligations that have been put on the shoulders of data fiduciaries, that is something which would definitely be of concern to almost all companies, because most of them would qualify under the definition of a data fiduciary. Another thing which I think would be of significant concern to every company which is operating in India would be the kind of penalties that we witness. It's not just about the quantum of penalties, which are in multiple 100 crores, it's also about the ambiguities which are prevalent based on which penalties would be levied. Just to give you context, there has to be significant data measures or protective measures which have to be implemented by companies. Now, what would qualify under the definition of these significant measures is unknown as of this moment. And the penalty of that is 250 crores. It's a gigantic penalty that we are looking at. So if we are talking from a company's perspective, we would be really wary about the fact that if I'm getting penalized
on what basis is that penalty getting evaluated, and what is basically forbidden by the law, which I'm not supposed to do. So from that perspective, I think it's a great statute which has come into the picture, but the granular differences between the other global statutes and the Indian law will have to be scrutinized further, and as an industry representative, I am most definitely looking out for more clarity when the rules get implemented so that these kind of lacuna can be bridged.
Absolutely. Thank you for that. I have a question, just follow-up question, and
Sure.
this may be really hilarious. So, you know, as even I work for a US MNC and you also work for an MNC, the moment somebody gets into our office, you know, they have a visitor management register wherein, you know, they talk about their name and number, and there's a visitor management system. And then, you know, after 2 days, we actually get a call from a real estate agent talking about that, you know, whether you're interested in a flat, how your organization is actually implementing this. Because I'm actually asking you, because that's the first door of you know, the compliance, and many organizations are really currently really horrible specifically on that. And I would not even be very doubtful in saying that even the big Facebooks and Googles have been reprimanded for you know, such kind of non-compliance, because it's a right you know, to privacy which is guaranteed by the Constitution. So how your organization is typically working on that?
So, Love, if I have to answer that question in a nutshell, at this point of time, the entire protective practices that can be adopted are being worked upon. So at this point of time, what everybody is keenly looking towards is what kind of clarifications would be provided when the rules get implemented. It's not just about, as you rightly said, we all are surprised when we get a call from a real estate agent without even knowledge that how on earth did they get our number. But it's not just from that perspective. Even if we implement these particular provisions in the statute, let's assume for a moment their data processor makes a mistake. If you look at this particular statute, the entire onus is on the shoulders of a data fiduciary. Okay. So one of the biggest concerns for me, connecting it to the question that you asked, is that even if I have a back-to-back contract with my data processor, I'll have to think about myriad things to be covered in that back-to-back arrangement. It has to be back-to-back indemnities, it's going to be maybe escrow amounts need to be deposited and stuff like that. But we can have everything, and we can try and have everything under the sun. The biggest problem becomes that what kind of a contract you would sign with your data processor would also depend on the stature that data processor occupies in the industry. If you're going with a very big name, they may not agree to a lot of obligations, and then where does it leave a data fiduciary, irrespective of their stature? And God forbid, if you do get qualified under the definition of a significant data fiduciary, then you have additional obligations like appointing a DPO, having data mapping again, having all the data audits again. And unfortunately, the penalty suggests that if any of the additional obligation of a significant data fiduciary is not adhered to, then you have to a penalty to a tune of 150 crores. So we are talking about one entire quarter getting screwed for a big company, and apart from the reputational damage that you have. And that's exactly what I'm really looking forward to, a certain more clarity, because I'm finding it very difficult to convince my board as to what is going to be my risk exposure, because mostly the boards would be concerned about the risk exposure and the mitigation. At this point of time, that risk exposure cannot be gauged in monetary terms, because the statute talks about penalties up to 250, up to 100. So am I supposed to tell my MD, oh, if you make a single breach or you fail to notify a data breach, it can be 1 lakh, it can be 50 lakhs as well. Second question is going to be, what's the upper cap? I'm going to say, oh, it's not much, it's just 200 crores. So that's not an answer.
That's not assuring at all.
Absolutely not. Trust me, I'm on the board. When you look at those seasoned faces, True. The North says it all.
They're more scared, rather.
Oh, absolutely, absolutely.
Absolutely. Thank you, Srinit, for your insights. Prashant, I'm coming to you. As you're a practicing lawyer, if you have clients who are working in EU, US, and India, what's your advice and how you compare, you know, all the laws and how you give them the best advice?
Thanks, Love. First of all, I should correct you. It's been over a year since DPDP came. And we've had this conversation of DPDP since 2017. right after the Sri Krishna Committee report came in 2017 onwards, we've had what, 4 renditions of the bill so far, right? If you go on Google today and type DPDP India, you will get over 1,000 articles on how you can comply, right? The problem is, for India especially, I think we have to balance fundamental right under Article 21 versus a statutory right provided under the DPDP, right? Not everything is a violation of fundamental right, and not everything is a breach of statutory right as well. So that is going to be a problem for India, and only the courts can solve that out. I do not see the data protection board stepping in to harness that situation and say, hey, listen, we'll stop here and let the courts decide that under 226. That's going to be one. The other big issue that, and I don't know how far the rules are going to solve that problem, is going to be children's both consent, verifiable parental consent from children, as well as children's data especially. All 3 legislations, if you look at GDPR, CCPA and India, all of them say very clearly that no, don't have to, you should not market to children at all. You can't track, you can't monitor, you can't do behavioral activities insofar as children are concerned. But how do you get consent from children? That's the biggest challenge. All kids these days, you give them an iPad at the age of 10, and they're able to log on to anything and everything on an iPad, whether it be a social media platform or whether it be, or for that matter, I can very easily go and say, listen, I'm over 18, and always click a check mark and say, yes, I want access.
Because they're not qualified to enter into a contract.
Right? Now, one of the propositions as part of the rules is that you're going to make it Aadhaar mandatory on the parent to be able to give consent on behalf of a child, which is to say that if a child needs to log on to Netflix, for instance, the parent has to give consent that the child is above 16 or below 16 or whatever be the situation, and the parents will have to then give their consent saying that yes, I am actually the father or the mother, this is my child, and this is the double authentication that I have to do. The whole purpose behind data protection is then lost, because you're adding collection of data an extra layer of collection of data, which is more Aadhaar. Right now, you can say there are 100 cases of the Supreme Court to say Aadhaar is not a valid document, it is not a national identity and all of that, but at the end of the day, you have your address, you have your phone number, right? How many of us realize when we go to a hotel, when we simply hand them over with our Aadhaar card or a driver's license, just for them to say, sir, I want a copy of it for our records. What happens to that record? We don't know. How many of us look at a privacy policy when we download an application? Right? I don't think I've ever read a privacy policy when I download an application.
We only look at it when we draft it for the company.
Exactly.
But still, I would just like to add that. But can you take it as an excuse that if you don't read it?
No, I can't. I can't, because see, the aspect of a privacy policy is always tied to the fact that usability of the app is dependent on you accepting the privacy policy. So if I don't accept the privacy policy, which is what CCI has just done in the WhatsApp privacy case, right? They said you can't tie a privacy policy to the usability of the application, right? And that's what Consumer Protection Act in 2019 also did, right? They said you can't tie a product to the privacy policy or to your terms and conditions as well. So those are some of the aspects that we have to figure and wiggle around and try to see how the situation persists. And the other thing that both of them mentioned was also on cross-border data transfer. Everybody is trying to figure out cross-border data transfer. We are not new. US is still trying to figure out. US doesn't even have a codified law. You have separate states having various laws. They don't even have a codified law, right? EU has a codified law in the form of GDPR. And the fulcrum of our entire DPDP is GDPR. Whether you look at Sri Krishna Committee's report or thereafter, everything has been borrowed from GDPR. The only things that have changed more or less are maybe the terminologies a little bit, and perhaps the penalties, which like he pointed out, are huge penalties, and we don't have criminalization. But if you have to look at criminalization as well, the entirety of the IT Act is not going to be repealed. There are certain provisions of the IT Act which are going to be that are going to be released, that are going to be repealed. But you can always tie up IT Act breaches along with DPDP breaches to make it a criminal intent under the IPC, under the new IPC, right? That is still a possibility that you can do, right? On your question of how do you manage data when you're collecting ad hoc data, etc., two things that I tell most of the companies that come to us is if you are EU or US, follow EU or US to the hilt, right? procedural niceties in India, whether in the form of your privacy policy to be given in 27 different languages, or whether you want to have little bit tweaks here and there, that you wait it out till the rules come to figure out those procedural niceties, right? But as long as you're largely US or EU compliant, I don't see a problem with you having anything in India. The only issue that you will have at some point of time is data localization, which if you are already part of your fintech industry or your health industry and all of that, there are already rules in place to keep that in India. RBI mandates that you can't remove your card details outside of India, that has to be stored in India and all of that. SEBI mandates that you need to have data stored in India, you can't take it out of India. In fact, earlier rendition of the 2022 or the 2019 bill, one of the two, and your SPDI rules, the current SPDI rules, also state that you need to have sensitive personal data to be located only in India, right? Your problem lies with the non-personal data which the government collects. How many times have you gone on a traffic signal and the police cop comes and takes a photo of you? True. Right? It's on an application. There are cameras.
Nowadays, every society is doing that.
Yeah, absolutely.
You have all
My gate
complexes,
pass.
and they will not allow any person, whether it's Ola, Uber, or even your big basket people, they will actually take all the personal data, and then you have an approval process. So it's all the more worst.
Buy a luxury car, and you will have every single hotelier call you and say, we're giving you a free offer.
I know.
Right? How did they get the data? They go to the RTO and get the data.
Correct.
And they come in, right? So not only are hoteliers giving you offers, etc., on your phone numbers, calling you and telling you, etc., your phone number is also attached to your driving license plate, which also has your other information, including your blood group, right? So these are all aspects that need to be churned out at some point of time, but eventually it has to be ironed out by the courts.
Thank you, Prashant. I will come to Renuka now. Renuka, you work for a US company, and how do you see it, EU, US, and India, going forward, and what really you feel that would be challenging with respect to implementation of the Indian law?
Yeah. Thanks, love. Hi, everyone. I hope you guys had a lovely lunch, and please bear with me because I've also had a lovely lunch. Now, there's not much left for me to speak about, but there are a couple of points that were mentioned, and I want to, throw some more light on it. Specifically, in DPDPA being rolled out on the model of GDPR, right? We talked about everything taking from GDPR. We've gone a couple of steps ahead, having special fiduciaries, having more rights to the principal and all. But the main aspect that helps businesses do better business outside is the cross-border data transfer that we haven't adopted. Now that's there we draw a blank as to how the Indian data that we're trying to protect so much stops from going out in the world, right? Because there is incoming data is regulated from EU by your SECs, the special conditions. But when it's about Indian data going out, there is no regulation as such. Now businesses would not want to harm the way they do businesses because of a compliance. They'll do the compliance, but at the end of the day, the bottom line is the business has to happen. So we are going to find out ways of doing things. Here we've given the open to businesses that bar a few industries. We have no regulations of data going out. I'm not sure about the health regulations in India, but of course you have comparative legislations in US. GDPR regulates the health data in EU, and it's pretty strict. I'm not sure about India. I mean, even my insurer knows that I have health problems here, right? So, and they charge me more premium because of that. So I'm not sure where the data sanctity will come in India. The other way that we are going to have challenges is data localization. Like I was just discussing earlier with the panel, that we don't have, so we've got few cloud providers right now in the industry. Not everyone has their backups sitting in India, right? So when the time comes that Indian law is going to mandate that the backup, the BCDR stays in India, we are going to have a little bit of a challenge. The businesses are going to suffer commercially. The compliance is going to cost you more because what you're doing is now AWS charges for BCDR in India versus AWS charges for BCDR in, say, Singapore or UK. Even if those currencies are higher rated, are less than what I can get in India right now, right? So that is another aspect where the businesses will have to think about making it cost effective. India till now was a safe harbor for cost effectiveness. So our businesses grew because people were finding India cost effective to do business from. But if you pile on all these compliances on the way I do business here in India for a US company, then that's going to go up, and we might see some challenges in terms of the data localization as well. Of course, banking, it's already in India, but it's not on cloud. So the banks are also going to come to a conclusion that, hey, you know what, IT company is getting my solution. I'm getting solution from IT company at a higher rate because I'm doing it on my premise. And they are doing my maintenance behind my firewalls versus me getting a cloud tenant, which is cheaper. So everywhere else, I guess, as soon as you load up the compliance for an industry, it's going to come on the nation, of course. I mean, individuals like you and me are going to pay more in taxes. We are going to pay more for services. We are going to pay more for every essential need that we have. So we have to think about that. When the rule comes, they need to give us a greater clarity on how all these things need to be sorted out.
Thank you, Renuka. Yeah, sure,
I have
please.
a question to Renuka.
Yes, please.
Would you think it would be beneficial if India and, for instance, EU had a collaboration, like how EU and US have, where they can share information basis a certain threshold limits that they've identified between themselves, and companies can share information between the EU and the US? Would it help if India does that with the EU and the US?
Yes, so in a way, it's already happening one way, right? So we already have, GDPR already has yes.
Specific measures that it can be shared.
Yeah, there are measures set out by GDPR that if you have 1, 2, 3, 4, data can go there under the SECs. Of course, you have to be contractually bound, where your liability may be limited with you B2B, but your liability, if the company in India, their liability to the individual whose data you're handling is unlimited. So we accept those facts because you can't make any changes in that. Actually, there's no negotiating power. Does India have that kind of power for the Indian data going out? We need to see.
I think just to add on to that, what he said, and it's a very important question which Prashant has raised and Renuka has answered beautifully. I think another concern there is, if you look at the Act right now, we do not have these kind of caveats which are there in GDPR. What we do have is, it's free flow until it's not restricted. So on what basis will these restrictions be levied by the government? We don't know, because the government has wide authority in that. Now, let's assume hypothetically a scenario. I'm a huge MNC. I have got specific territories where I've got huge plants and manufacturing facilities, and there the data is free flowing. And due to the geopolitical tensions, India as a country, the government decides, okay, now let's have these countries in the list of forbidden territories. What happens to MNC's interests? These are certain things we need to ponder over.
That was the problem with the whitelisting to
Absolutely, absolutely.
Yeah.
So Prashant, I would just take your thoughts on cross-border data transfer. That how do you typically tell your clients on the best practices with respect to cross-border data transfer?
So two things that we've told clients.
Like we've already discussed about the EU and the US.
Two things that we've already told the clients is, actually our advice is more sector-oriented. So if it is fintech, health, insurance, all of that, it's taken care of. You don't have to worry about it. But if you're somebody else in India, 90% of the clients who come to us already have associations with AWS and Azus, is it? Azus or Azure and all of them. They already have all of these compliances with them, and all of them are being sent out of India. Without a doubt, all of them are being sent out of India. I don't see a problem in a very government and economic sense or social tension sense or whatever you want to call it. I don't see a problem between India and the US and the India and EU for that matter. I do see a problem when it comes to China. I do see a problem when it comes to maybe a little bit of Southeast Asia as well. But I do not see a problem if it comes to Europe and US. And I also see that a lot of the Europeans and the US entities which want to have bases in India are also expanding their bases in India as well, right? So they're looking for larger areas, they're looking for larger plants, they're looking for larger service bases, all of that. Because at the end of the day, you should realize that the banking activity has been surviving in India for the last 20 odd years, right? So you've been holding data for 20 years, and State Bank of India is the largest bank in the country. And apart from State Bank of India, you have private players like ICICI and HDFC who've been holding data for the last 20 years. And all of that data is in India. So there is capacity for you to have that data in India. Right? Now, how that is going to play out in the future when the rules come out is a different question altogether. But for now, we tell people, as long as you have valid consent and you have a purpose limitation of why you're collecting that data, etc., use that as the bedrock for you to transport material outside India.
Thank you. Just to ask you that how your organization is complying with the cross-border data, because you work for a multinational company and there is a data transfer, and what are the kind of watch outs or best practices you as a general counsel is kind of providing a training, because as a general counsel you have to kind of coach and mentor your employees, because it's not that they are expected to read the law and they are not going to talk to lawyers every now and then. So what framework or what ecosystem you've developed in your company as a general counsel? I would just like your views.
Okay, at this point of time, if I'll be honest, even before the data protection had come into existence, thankfully we have a massive presence in EU. So we were anyways ensuring that everything is, and even if we are talking about from a training perspective, that every country that we have an office in, we used to ensure that the trainings are provided on a regular basis, whether it's GDPR, whether it's the Privacy Act of US, because as Prashant had already mentioned, US basically is an amalgamation of federal laws and state laws. So we ensured that, and more or less, of course, GDPR is way more consolidated, so we ensured that these trainings are imparted even to the Indian stakeholders. Mostly what we are witnessing right now, of course, as I had said at the beginning, the DPDA has granular differences with the GDPR, but there's a lot of compliances. If you're completely compliant with GDPR, then you are well prepared to ensure that you stay compliant with when DPDPA also comes into the picture with the implementation of the rules. So from that training and workshop perspective, I think the organization is, for the lack of a better word, decently prepared when the rules get implemented. Another aspect which we have definitely tried to follow is to sort of have mock exercises. So for instance, if there's a plant head, we also provide these exercises when there's a situation which arises that the data has been leaked, let's say by a data processor. Then what is the immediate action which can be taken by the different stakeholders, which could go up to, from a plant head perspective, they get to understand that, they then immediately let the board know, how do the directors handle that situation. So this is basically sort of preparedness that we are trying our best that the company sort of understands and analyzes. As you very rightly said, business stakeholders are not lawyers. They don't have the luxury of time to go through a legislation. So what we have done is we have tried to impart the must-dos and don'ts as far as the statute goes. But again, I'll be very honest, everybody is looking at a lot of clarifications to come from the government, because apart from the fact that there's way too much discretionary power with the government, there's also a lot of ambiguities present. And if those ambiguities could be cleared, then there's a significant amount of relief that we could give to the senior stakeholders, not just in India, but in US as well. Because even if you're listed in US, if there's a data breach and if there's sort of a damage which has been levied on that particular fully owned subsidiary, then it immediately has to be reported. And we are not just talking about money, we are also talking about reputational damage. So it does have a trickle-down effect that even if it's happening in the developing country, it would have an effect on the developed part of the world, because people would be talking, especially if you are, let's say a Fortune 300 company, which my organization is. So I think more often than not, their reputation is way more important than even the bottom line. And that is exactly why compliance is of paramount importance. And that is exactly why these kind of discussions are very important.
Absolutely, because it's a well-said phrase that if you want to, if you think compliance is expensive, try non-compliance.
Absolutely.
So, thanks for your insight on that. And just to give you one, hilarious stuff that many a times the organization stakeholders confuse data security with data privacy, and then you get into a different discussion. So Nazneen, coming to you, as Srinit and Prashant has already talked about that government has unlimited powers, whether it's any act. What is your thought process and take that when these rules the Indian rules will get implemented. What do you see coming? And when the clients come to you, what is the best advice you're gonna? I know that it'll be a chargeable advice, but I'm still asking you.
Now this is being public domain.
Yes, exactly.
So, no, I think the key answer that everybody is looking forward to, and hopefully we'll get clarity on that aspect soon once the rules are at least, the draft version is published, is how discretionary is the level of discretion going to be for the government? Because that's going to be a very prominent factor for MNC players to decide what level of information data sharing they are going to be doing with their counterparts in India. So on one hand, we have the ease of doing business in India, and we are trying to woo foreign businesses to come and set up in India. But on the other hand, if we are not going to do much to at least set out the parameters to allay their fears as to what is the level of interference or the level of discretion that government is going to have or government authorities are going to have to be able to ask for disclosure of that data, I mean, it's going to be a counterproductive effort. So I think one of the topmost things that needs to come is some sort of framework or guidelines or defining a parameter as to what would be the line or thin line of the discretion and where does that discretion end. So, any clarity or guidelines that the government is going to provide on that aspect is going to make a lot of difference.
But do you really think that the government would would possibly give you an opportunity to draw a line?
Given a choice, definitely not. But if they want the work and the foreign money to come in, they have to figure out something to do that, because you can't have your cake and eat it too. So
that's one of the biggest concerns.
You have to be commercially oriented.
Yeah. Absolutely. And if the government doesn't do it, they're just opening the floodgates for litigation.
Exactly.
And that's also another concern which I have. At this point of time, if you look at the appellate tribunal here, it's the TDSAT which is there. And if you're opening the gates to a lot of litigations, I'm not very sure to what level is TDSAT right now equipped to handle these kind of litigations. And then you always feel, okay, the matter has been appealed, so you're not really exactly at this point of time paying the money. Sometimes the matter or the certain amount of money, the government can dilute the rules and state, oh, 15% you have to pay at this point of time. The biggest concern becomes that when you're discussing this at the board level, they want to understand what is the exposure which can go up to. We are talking about 200, 250 crores, and every MNC or every company which have the right accounts, they will have to make a provision till the time the matter is into litigation. And the moment you make a provision, it hits your bottom line.
But Srinit, it's really embarrassing and it's really heartening to typically sit on the board and talk about non-compliance and its exposure and then provisioning it. Because see, it's not about 1,000 rupees or 250 crores, but a non-compliance is a non-compliance and there are repercussions to it. If you're a listed company, let's say for example in India or a US, it's really a reputational loss. Like we all saw, right? Just a normal indictment cost 30 to 35% of the shareholders. Really, it went so badly down, and it's not only one company. I think all the group companies typically, just for an anti-bribery allegation. It was not even a conviction.
As you rightly said, it's just an indictment. Nothing has been proven as yet.
So, I'm really not sure whether it will be really assuring or convincing to any of the board that whether
absolutely not. And that's exactly
you make a provision of 250 crores and you are out of it. I really don't see it, as commercial viable or possibly an ideal situation at all.
No, absolutely. And that's exactly why I said it's very, very difficult for a company to even make provisions regarding that, because we are talking about huge amounts of money that will affect even the expansion plans. On one side, the government keeps on harping on the fact that we need to do ease of business, come and make the investment in our states. And then you have statutes like this. I'll give you, when she was talking about the clarity, there are certain basic things which needs to be understood. For instance, there's a provision in the statute which says that every consent and notice related document have to be provided in 22 languages. Why on earth would you require that in these many languages? If it is specific to a particular sector, I can still understand and appreciate it. But if it is, let's say, like me, if it's a B2B business, why on earth am I going to spend money in making every notice? And by the way, every single breach, you have to notify, unlike the GDPR. Every notice you have to give. So every time I do, I first have to make it in these many languages and then send it out.
And that
It
also
makes no
has
sense.
penalties if you don't
Absolutely.
comply with that. That also has
Every
penalties.
single data breach, if you have
Yes,
not notified,
yes.
200 crores is the penalty.
Yeah, and what gives me the most problems about, giving the government discretionary powers is every government that comes in power is going to define that discretion in their own way. So how many times are you going to actually change your strategies about compliance? When you have a change in government, whether their discretionary powers are going to change, you need to have a monitor for consent, right?
Yeah.
That's another difficulty. How are you going to inform? Right, you have the data subject, or the principal has a right of erasure. What happens to the consents they have given? How will you manage that through this agent? So all this requires clarity for companies to implement DPDPA.
Just to add on to what Rinku was telling me, at this point of time, if you look at the discretionary word, for significant data fiduciary also, there's certain which you have been mentioned, which talks about the fact that, there are certain factors, and there are factors like sovereignty, integrity of the country. It talks about public policy. Unfortunately, in our country, like most of the other developing nations, the definition of public policy changes with the changing government.
So the exceptions are more and the rule is one.
Absolutely.
Okay.
Has greater power to declare somebody a special fiduciary as well, and then there is that compliance as well. Like you said, audits. You're going to need audits. You're going to need regulators for complying with if you are declared a special data fiduciary. And there is no clarity, and they can declare me a data fiduciary, special data fiduciary tomorrow, because we deal in AI, so it's an upcoming technology. You are responsible for it, and then we are gone.
I see there's a lot of government bashing going on.
Yeah, so
but I'm going to stand up. I'm going to stand up for one institution.
I am going to actually ask you, from the one non-chargeable advice to the another person. That's the best thing to be on the panel, that you get the best legal advice, and that free of cost.
I am going to stand up for the one institution that will bring out all of this clarity.
Sure.
Which is the court. Right? Now, fundamentally, there is a flaw in the enactment because you don't have a definition for personal data. True. You don't, it's called Digital Personal Data Protection Act, and yet you don't have a definition for personal data. What is personal for her is not personal for me, right? What is personal for you is not personal for me, right? Unlike in the earlier edition, or even in the sensitive personal data rules, which has specific segments of sensitive personal information, biometrics go there, then your personal information, etc. There's a little bit of a flow that's attached to SPDI. There is no definition for personal data, right? And there is no amount of clarity that's going to come from the government, because ironically, the Data Protection Board does not have the power to issue extra clarifications. So tomorrow, if a Data Protection Board has a receipt of a complaint and they feel that this is an industry-wide complaint, they can't issue clarification and say, hey, you know what, we are going to try and see if this can be made, or we're going to issue a notice or a notification or a circular or some kind of a feedback to the industry saying that, listen, these are practices that have come to us, and therefore please keep this in abeyance.
Sorry, just to interrupt. Can we just close the door if it's possible? Thank you.
So
please go ahead.
That clarity needs to come only from court. But I also get their problem with the court system in India, right? The court system in India, and I quite agree with what Srinit said about TDSAT. TDSAT has failed drastically in the last 10 years that it's been operational, right? It's not been able to handle even try matters, let alone an extra roster in the form of data protection, right? I feel that there needs to be a separate tribunal. It's a different question whether you need to have a tribunal structure at all in India. That's a different discussion altogether. But if you do intend on having a tribunal, I think you should have a separate tribunal with dedicated personnel and members to be able to appreciate what is going on in terms of data protection, right? You can't have a tri-person sitting there and trying to figure out what is happening in data protection when he doesn't know the difference between a data fiduciary and a data processor. Right? She could be a data fiduciary for one transaction. She could also be a data processor for another transaction. Right? But if that fact is not, and tribunal at the end of the day is a fact-finding authority. Right? So if that fact-finding appreciation is not done by the tribunal, no amount of clarity by Supreme Court is going to solve your problem. Right? So courts will at some point of time need to use that 226 power under Constitution and that Article 21 fundamental right violation and all of that to bring in some kind of a clarity in terms of this law. but there's nothing that you're going to get
And
from
I
the
just
government.
hope that they also take into consideration the impact of the breach and don't make an example out of somebody.
And it's about litigation. Prashant is absolutely right about the courts. We would look at the courts. The only problem becomes when you're getting into litigation, who will be the first one to bail the cat?
Exactly.
So it just becomes...
No, we have a lot of people.
The problem becomes that if there's a company who wants to get into litigation, first they would think about, okay, what is actually happening? Are we going together with somebody? Has it already been challenged? Are we the first one to defy the government? So these are considerations which keep on evolving before you take that active step. And we're talking about these multiple courts. What I'm assuming is when the first penalties are levied till the time the breach is not that severe, it would not go up to 200 crores, but still it's going to be substantial. And at that point of time, if the clarity doesn't come, and she was absolutely right, it's very wishful thinking if you think that the government will provide all the clarification. Then it becomes, how do you travel, under what ambit will you travel that distance between, let's say, 50 lakhs to, let's say, 50 crore, 60 crore? On what basis there's an enhancement of penalty?
That clarity needs to come into the rules actually.
Absolutely.
That what requires what kind of penalty.
And unfortunately, I mean, while we appreciate the intention of the government in coming out with a legislation like this, even though slightly late in time, maybe, but all these practical challenges or ground realities are something that should have, in my view, been thought through before actually notifying the act, instead of creating an industry-wide panic by, not discussed, correct. So you enacted after having addressed this
And they
level
have
of
not even asked for any
concerns and challenges
suggestions,
that
right?
you're going to be facing,
Yeah.
right? And Act hasn't, and then you come out with a legislation like this which raises more questions as of now for businesses, and then you have such a big lull period in giving the clarification under the
I
rules.
think
So
we
it's like,
are setting ourselves,
leaving you on a hanging cliff.
Yeah, we are setting ourselves up to be another China in terms of the discretionary powers of the government, the way they are looking at external data coming in and them having that control over that external data. Maybe it's for national security and integrity, but to whatever extent that is possible, right? But they are having that kind of control over the data. And now we have to look at the business, the way it's evolving. Right now, we are dealing with a lot of MNCs and the data is coming out from external data is coming into India. We need to protect that data from such provisions as well. Otherwise, what we are going to lose is we're going to lose business, we are going to lose jobs, and the economy is going to suffer. I have seen a lot of businesses backing out from China because of this, right? So we don't want...
Just feeling happy that, employment is also getting generated because there will be people as DPOs, there will be companies who will be embodying the role of consent managers, which are not there in the other.
But there'll be one.
It's just that I'm pretty sure the consent managers, it may go out of a company who specialize that we can do it for a lot of MNCs, and they would go there.
I don't think so. They intend for an internal employee to be the consent manager.
No, it has to be external. It has to be external.
A lot of companies has already started pitching themselves at consent managers.
Correct. The irony in all of this is this. If there is a 250 crore penalty that Srinith has to pay, not a single rupee will come as damages to the data principal who's applied.
True.
Because the provision, the act in itself, and the powers of the DP board, it does not give them the power to give damages to a data principal. But there is a penalty if the data principal's complaint happens to be a fraudulent complaint, let us assume, or a frivolous complaint. There is a penalty on that. But if the data principal's rights are completely destroyed, statutory rights are completely destroyed under the act, even if I collect a penalty from Srinith, I cannot give it to the data principal.
Go to Consolidated Funds of India, which is at the discretion.
The act is very well drafted. So, so Nazneen, your final take, because I just want to be mindful of the time. We have just 5 minutes more. So your final take on the best practice, or your thoughts on the topic, and
to conclude, I mean,
just to conclude.
As an Indian business or as an Indian company, the best sort of preparation that I can do is try and be more or less compliant with the European and the
US
legislations that are prevalent, to be like on a first footing or as a first level preparation that I have done till all the mysteries are solved and we get better clarity. I think that's the best step that you can take as of now. And in this sense, people who are already dealing with data of European Union residents are slightly at an advantage because they've already been doing it. So it's mainly the businesses who are dealing with non-EU data that need to spend that extra cost, that extra resources in gearing up this level of preparedness. But I mean, as of now, until the remaining picture unfolds, I think that's the best that as a client you can do, and that's what I would advise them to do.
Thank you, Nazneen. Thank you so much for your insightful comment. Srinit, over to you. Your final thoughts.
Okay, I have been criticizing the statute for quite some time now, most of us, apart from Prashant. But yeah, to be brutally honest, if I have to
Srinit, let the litigated lawyers litigate at least. You can criticize them.
Absolutely. So no, just to be honest, I think the intention is extremely noble. We didn't have a statute specific for data privacy, so it's most welcome. What I would really expect from the government side is a lot of clarities, especially which becomes big apprehensions in the minds of big companies, whether it's penalties, whether it's the provisions based on which penalties would be levied, what would be the grounds based on which significant data fiduciaries will be defined, what are the grounds based on which the additional responsibilities of significant data fiduciaries would be defined, certain clarities about fact which may be very similar to GDPR, where caveats could be given that if it's an honest mistake, then the penalties are not to the tune of 200, 150 crores. So I guess I'm a little hopeful about if we can get some more clarity. And as she rightly said, I think from a compliance perspective, one of the most important things would be that if we're already compliant with the US laws and the GDPR, it is maybe the start point of being compliant with DPDP as well. But whatever clarity if we do not receive, then I think that would be the opportune time for us once the clarity has not been provided, if at all, by the government, then as industry bodies, we go down to the government and ask for them that we would require these clarities, because if that doesn't happen, firstly, it defeats the objective of the adage of ease of doing business. These are just hindrances to the business. Secondly, and most importantly, it'll just open the floodgates to litigation, which will neither serve the requirements of business, and I'm sure the government wouldn't expect or wouldn't want a lot of litigations on a new statute. So I guess that's how I would like to sum up.
Thank you, Srinit. Prashant, your final concluding remarks?
Litigation is inevitable, but we should be prepared for it, one. Two, I think the first and foremost advice that I would give companies, and I have been giving companies, is the tech, HR, legal of the company needs to work together. You cannot work in silos anymore, right? Your tech cannot design something and then give it to the legal and say, approve this, and then we'll float it in the market. That's not how it works. Privacy by design as a concept needs to set into companies, whether you're an Indian-based company or if you're a foreign-based company, no problem. You already have that concept going on for you. But if you're an Indian-based company, if you're an MSME and all of these guys that you have, privacy by design needs to float in as a sanctimonial aspect of your design policy, one. And insofar as the statute is concerned, let's try and see if we not over-regulate. We should try and see if we, like day one, it should not be 250 crores. Like, let's try and see if we can get some data and inputs as to how people are complying. Because I don't think, there's been a lot of talk when Rajiv Chandrasekhar was around that we are going to have a transition period. From 1 year, it came down to 6 months, and then it came down to 2 months, and now suddenly there is no transition period at all. That's the news, right? If you're not going to give transition period to people, that means it's kickoff right from day one. Right? That's a problem again, because 90% of the companies will not be compliant with the law on day one, right? So give time for people to get used to another legislation that's coming in, and as statutory bodies, I don't think you should start levying penalties on day one. That's what EU did, and they got that wrong. They did over-regulation first, they imposed hazardous penalties on people, and then now they're trying to suddenly slow down the situation by saying, okay, we'll issue clarifications, we'll get government, we'll get industry consent, and then we'll implement another notification, etc. That's something that the EU is doing now. We should do the reverse.
Let's not repeat the mistake.
Thank you.
You're right.
They made money, so.
I think the basic thing that we all have to understand is being Indian citizens, our data is as important as data of any EU citizen, right? So my data is important as well. I have rights of privacy as well, right? Which was not there before this DPDPA came into existence. So let's clap for that at least our data has some influence over the industry, that please use my data rightly, otherwise you will pay for it. Right, so I think I'll leave you with that.
Thank you, Renuka. So thank you everyone for being such a great panelist. It has been really thought-provoking, and thanks for sharing your views that over legislation is a concern, penalties are a concern, privacy actually is a myth, but we are trying our level best to overcome that. And I hope that these rules are implemented in a way that it should be commercially viable. Otherwise, absolutely, there would be repercussions. And I really feel that, this panel has addresses very vital thoughts that, in case if you already, working on the EU or US, you're already halfway there, but there would be a lot of organizations or individuals who are currently, would be covered by DPDP. So we currently don't know what's the landscape would be, but I think it will be very similar to what has been already implemented. So thank you. I really enjoyed, interacting with all of you. It was really a great chat, and I wish everyone all the best. Thank you so much. Yeah, sorry, do we have time for Q&A? Oh, perfect. Thank you.
Where actually the company is from Canada, and they are operating certain services, which is primarily, online services. They are operating from Gurgaon, right? There are 70 employees of that company. Now, that company has not done any joint venture with any Indian company. These employees are being paid in, Canadian dollars, right? Supervisor is also there. Now, the case which has come from, it's a company which is, from Canada. They have, and he's also Indian, sir, who's actually settled there, right? Now, what he says that the software which they are utilizing for serving various online services, same software is being replicated by 8 to 10 employees who are serving in that company, and they've opened a parallel company, right? And they are reaching to their ex-clients. So what actually had happened, one of their ex-client was the batchmate of the person in Canada who is owning that company. He came to know that, so this person asked that, have you opened another company in India, right? So then he came to know that this kind of thing is happening, right? So once this case came to us, because they were aware about 8 to 10 people, what we came to know that they had hired people from outside also, from the similar industry, and they've already opened a company, and they're already reaching out to other parallel kind of clientage. But they are using the similar software, and they bought the similar software from the company which was also an Indian company, right? So how do we legally handle this? We've already identified all flaws, right? We have, whatever we could do as a investigator, we have all the, how to handle this case.
So sir, actually this seems like a billable advice to me. So I'm not sure whether Nazdeen and Prashant are going to charge you for that, but I will still leave it up to them. So I think this is more of a data breach than
It's more of an IP infringement issue. Two is you will have consultancy agreements. If the Canadian entity has employees based out of India and is paying them in Canadian dollars or whatever be the case, then they're not Indian employees per se.
Yes.
They are consultants consulting with the Canadian entity. So as part of your consultancy contract, you will have various provisions.
Yes.
You will have your non-compete and non-solicit.
Yes.
You will have your infringements in that. Those are the ways for you to challenge, and it's more of a commercial challenge of contracts that you're looking at. There is no DPDP angle unless unless the software which is being replicated and used by the Indian entities contains data of various vendors or various individuals, etc., which is sensitive personal, which is being stolen and given away to the other people. That, as of now, you don't have a remedy. Let the act come in, then you will have a remedy. But for now, you can still do theft, breach of data, and all of that. You can still do under the old IT Act. You can still do all of those things. You can still do.
So it's legally, I mean, we can challenge legally tenable individuals who are doing it. Within the framework of Indian law, that was the only query which was.
So absolutely it can be done. And just to give you a little more color to this, what you have mentioned about the different jurisdictions involved, without disclosing the names of the companies. So you had mentioned your name as Colonel, right?
Yes.
I'm so sorry. So before
my rank is Colonel. I'm ex-army.
Yeah, that's exactly. So I'm sorry, I should have started. Thank you so much for your service. Really appreciate that.
No, my pleasure.
So to continue with that particular answer, I know as a matter of fact, a specific industry which is into home decor. It's basically, there are 3 or 4 players in the market. It's sort of a just 3-4 player market. It's a very big industry right now, where basically, just to give you modus operandi, very similar to this, there are designers who they hire to basically get into that particular frame and decorate houses and everything. And those designers are sometimes on the payroll of these legal entities. And then these particular companies, their employees, who completely understand how the designers come into the panel, how the clients are reached, they actually, when the negotiations fail, they sometimes go around to these clients and they have parallel companies which have been providing the same services but without a brand value, and they actually are stealing clients like that. And these companies are actually litigating against a number of employees who have now become ex-employees because they are actually stealing clients from their own company to the new company which they have floated. So it's a very much live situation in India as well.
No, sir, in fact, not that they should contemplate taking action, they absolutely must, because at the end of the day, it's also a matter of setting a precedent for the other employees, the other 160 employees who are currently working here. And like Prashant rightly mentioned, there would be ironclad contracts that the company would have entered into. So taking recourse to those contractual provisions and having them enforced is definitely recommended.
Yes, ma'am. We are taking actions. We have in fact confiscated their laptops and phones also, and we've carried out forensics also. We have obtained certain more data from there. Certainly we are doing that, ma'am. Thank you.
Thank you.
Thanks,
I hope the phones didn't have personal data. Those are like official phones, right?
No.
No, just joking.
Since we are talking about the DPDP Act, there is a provision I have come across which talks about voluntary undertaking, where a data fiduciary is, if there is any breach, and giving him the opportunity to rectify it. So it's something like, in the US you have, under securities markets, you have something like a deferment prosecution, where if there is a confirmation of any breach, and if you're remedying it either through some changes internally and through monetary compensation. Now in this case, if a data fiduciary is giving a voluntary undertaking, let's say because of a data leak, because of there being improper security measures not being implemented, and because of that leakage, people's personal data has been misused, wouldn't the giving of a voluntary undertaking by the data fiduciary only protect the data fiduciary, and what about the data principals whose data has been leaked? It may be not even, it may be a genuine mistake on the part of the data fiduciary, but what are the remedies available for the data principal in that case? Because the data fiduciary is having to pay a sizable amount of money, but what safeguards are there for the data principal? How will the data fiduciary remedy the data principal in that aspect?
I'll just try, and then, of course, I'll go to the expert afterward. So, let me put it in one nut. I mean, if I have to answer your question in one line, I don't think there are remedies for data principal as such in the statute itself. What we're talking about, these humongous penalties that are, I mean, for the lack of a better word, to fill in the coffers of the government, because we're talking about consolidated funds of India, which gets mentioned in the Constitution of India. So from a data principal's perspective, I don't think the statute at this point of time provides any remedies as such. The data fiduciary, of course, it would be made a case or maybe set an example, and they would be, in the worst case scenario, would be obligated to pay a huge amount of money. But if it really would help the data principal whose data has breached, and if they have suffered damages, I think as Prashant had mentioned, and he'll answer that question again at this point of time, if the courts actually provide in a particular matter that, the aggrieved party as such is not the government, it's basically we're talking about the aggrieved party's data principle, then maybe the court at some point of time would think about allocating a certain amount of money from the fines so that certain compensation can be given depending on the facts of the case. But unfortunately, the way the law reads right now, data fiduciary has to abide by a lot of obligations which is connected to data principle. But none of these obligations actually help data principle if their personal data has already been breached. Prashant, over to you.
No, I think I'll take that question offhand. I think we've run out of time.
Thank you to all the panelists for enlightening us with their wisdom on Digital Personal and Data Protection Act. Your discussion has not only highlighted the importance of DPDP Act, rather gave a SWOT analysis of it considering all local and global trends. Please join me in thanking our panelists with a round of applause. Going forward, we have another panel discussion on the topic International Trade and Compliance. For this, I would like to first call upon stage the moderator for this panel, Professor James J. Nedumpara. Professor James is an expert in international economic law with over 2 decades of experience. Currently, he heads the Center for Trade and Investment Law at IIFT, advising the Indian government on trade and investment matters. Before his academic journey, he worked with renowned law firms and corporations. He has been a key figure in WTO disputes, including the recent India agricultural products case. He has taught at prestigious institutions like the University of New South Wales, National Law School of India University, and many more. Now, Now I would like to call upon the stage the speakers for this panel, Prateek Rajapadhyay. Prateek Rajapadhyay is a managing partner at Tavish Law Offices LLP with a strong academic background. He is affiliated with the Bar Council of Maharashtra and Goa. Notable representations include cases involving NBFC, debt recovery, investment fraud, and embezzlement. Another speaker for this panel, and I would like to call upon, is Amer Ranade. Leveraging more than 6 years of corporate law and commercial dispute expertise, he advises, strategizes, and represents clients at Tavish Law Offices. Another speaker for this panel is Sumitra Singh. Ms. Sumitra Singh is currently an assistant professor at Amity Law School Amity's Law School. She has a robust skill set that includes lecturing, university teaching, academic writing, and statistics. Please welcome, ma'am. The floor is yours.
Good afternoon, everyone. My name is James Nedumpara. I'm heading the Center for Trade and Investment Law. And I'm deeply honored to partner with the INBA in connection with this Law Day event. As a matter of fact, our center has been supporting this particular event for the last 6-7 years. So I have got a very long association with INBA and also with Mr. Kaviraj Singh and their team. So this particular session that we are going to have is actually on international trade and compliance. And when we think about international trade and compliance, it is actually a very area, it's a vast area. Sometimes it may deal with WTO-related matters. Sometimes it may deal with trade agreements like the free trade agreements. Sometimes it actually deals with unilateral measures. So even in the previous session, we had discussion on data protection, data privacy, etc. Many countries have got their own domestic legal regimes in order to regulate this discipline. So, but at the same time, in a globalized world, we know that if every country comes up with their own regulation, then we have got disparate systems. And disparate systems can actually lead to compliance cost. So the very objective of international trade agreements like the free trade agreements, economic cooperation treaties, is to make sure that the businesses that may operate in multiple jurisdictions can actually align their practices and have certain kind of a harmonization and uniformity in terms of their method of operation. And we also know that companies cannot actually align their practices to suit every jurisdiction. So ultimately, you have got around 198 countries, and if every country is going to come up with a unique system, then private businesses will find it extremely burdensome. So the objective of international trade is to make sure that discussions happen at the governmental level, at the intergovernmental level, in order to bring in certain amount of harmonization, certain kind of a uniformity, and certain kind of a predictability. Predictability is extremely important because when you start a business, you don't want to be undone by a regulatory change that may happen tomorrow. And that is why the trade agreements basically freeze the regulation, or sometimes even if a country wants to regulate, then there will be some kind of a requirement, some filters to make sure that these regulations are done in an extremely cooperative manner. There will be consultation provisions with a view to reducing the barriers to trade. So that is the whole objective of international trade agreements. So when you think about trade, there are two elements to it, and I know some of you must be law students. There is actually a difference between public international law and private international law. And both these areas are actually called as trade. So when I refer to international trade law, sometimes it may be in the context of government-to-government agreements, like the WTO agreement, or the free trade agreements, like the NAFTA agreement, or India, UAE agreement. These are actually done at the government-to-government level. But in addition to that, you have got a large number of private international instruments. And some of these instruments are actually done by, perhaps prepared by international agencies like the UNCITRAL. So even with respect to commercial arbitration, we have got UNCITRAL model treaties. Model agreements are, extremely common these days. And what is actually the objective of these model agreements? The model agreements make sure that there is a harmonization. So even with respect to electronic commerce, there is an UNCITRAL agreement. So there are a large number of norm-setting agencies worldwide. So one I mentioned is UNCITRAL, that is definitely United Nations organization. The United Nations International Trade Commission. Then we have got agencies like the OECD. So when it comes to now, most of you sitting in the room know that environmental social governance has become an extremely important issue, ESG. So that means companies cannot actually do business, especially international business, without complying with social governance or environmental governance for that matter. Sometimes even the footprint, the carbon footprint that is actually embedded within a product can cause certain kind of restrictions on international trade. Sometimes it may be your labor practices, or sometimes it may be your ethical practices for that matter. So these areas are also, in a way, taken up in international trade agreements. So the OECD, for instance, they have got a large number of conventions, for example, on export credit, on bribery. So now bribery has become an extremely important issue. There are international conventions on bribery. Some countries have got their own domestic laws, like the United States have got their Foreign Bribery Corrupt Practices Act. So if you pay certain kind of foreign public officials some kind of a bribery, then it is subject to international action. And it can actually affect the credibility of a business as well. So these are all part of international trade to an extent. Some of you might have heard about the Indo-Pacific Economic Framework Agreement, the IPEF agreement. That is actually, it is not a market access agreement. It is not trying to wear down the tariff or non-tariff barriers. It is trying to create an ecosystem. So the pillar 2 of the IPEF agreement is actually called the supply chain agreement. So if a company has got unfair labor practices, they don't pay their labor properly, or they actually provide for collective bargaining and other things, their services or business can be affected. The second is actually dealing with the clean economy pillar. Now, clean economy has become so important because some of you might have heard about the Baku COP29 conference. So the whole objective of the international business is to cut down on the carbon footprint. And we have to actually move towards a decarbonized economy in a very near future. Sometimes India has said 2070, but my own feeling is that 2070 is actually such a long time, we have to do it immediately. And European Union has got a program called Fit for 55. So they want to reduce their carbon emission compared to the 1990 levels by 2030. No, so that is actually what they call as Fit for 55. And European Union wants to become a completely decarbonized economy by 2045. So then how do you actually reach that particular goal? Through a huge amount of collaboration and cooperation in the clean economy. So that means a huge amount of investment will have to come into the country in different sectors of the economy. In these areas, I think the lawyers play a very important role in providing matchmaking opportunities, in entering into structuring agreements, and also in negotiation. So our center has actually been helping government with respect to the government-to-government engagement. But the government-to-government engagement is not the most important matter. Businesses are not purely done by the government. Businesses are actually, you can say, hardly done by the government. The businesses are done by private people. But the government has a very important role in facilitating business, in creating their ecosystem, and also in terms of facilitation. So in all these areas, the role of lawyers is absolutely, you can say, tremendous. And they actually play a very important role in terms of creating the entire ecosystem for investment and businesses to come together and invest in the opportunities of the future. So we have got an excellent panel here. In fact, I should tell you, I've got a meeting at 3:30 in the Ministry of Commerce. So I may have to leave this meeting. I don't have the privilege of listening to some of the wonderful speakers. It is my loss. But at the same time, I really want to welcome all of you. In fact, I really welcome Professor Sumitra Singh from Amity Law School, right? And you can actually, you can step into my shoes. Then we have Ameya Ranade from Tavish Law Firm. And then we have got Mr. Pradeek Rajopadhyay, right? So I pronounced your name correctly as well. And welcome to three of you. And welcome to this particular gathering. Let me tell you, I have been part of this INBA program for a long period of time and have benefited immensely from it. Since I'm stepping down, I want to have the opportunity to listen to you. But my colleague, Pranav Narang will join the discussions. And thanks again for this opportunity. I hope that this particular, the Law Day, actually, provides an opportunity for lawyers to meet together and make sure that our legal system, our legal environment remains strong and grows from strength to strength. So thank you so much.
Mr. Pranav Narang is from Center for Trade and Investment Law. Welcome to the stage, sir.
So, in place of Dr. James, let me have this opportunity, and I welcome all the panelists of the stage here. I've decided to speak up from this podium because that time I was the moderator here and the panelist co-moderator. So I will take this opportunity to speak from the panel here. So there are many aspects to the international trade law, and Dr. James has highlighted, as my colleague Pranavji might be knowing and all others here, that public international law and private international law practices together form the international trade law practices. Now it is up to what kind of treaties are signed between the two kinds of the countries, the two kinds of the governmental systems in the countries, that determines their trade practices. For example, when we talk about rice, Basmati rice was patented in India, but there is another patent of rice in US. So what is the source of origin of that particular rice? Do the governments have a treaty regarding how another form of rice, if got from any other GI, a geographical indication, will be patented and from which country? So this and much more will be talked about, but I take this opportunity to present my matter, my case in front of the panelists. I talk about this case comment about a matter between Mexico and Argentina, which will shed some light upon the international trade law practice. So the fact of the case is that a complaint was filed in August 2012 by Mexico with the WTO and requested consultations with Argentina with respect to the measures imposed by Argentina on the importation of the goods. It was not mentioned what the goods were. However, the measures with respect to importation of goods in Argentina, they were challenged by Mexico. Now, why it had to challenge? Because the requirement to present for the approval of non-automatic import license, DJAI, which everybody knows, in the form of a Certificados de Importación, or a certificate that they provide, CLCs, and that the importers must undertake certain trade restrictive commitments, was what they wanted. The systematic delay in granting the import licenses, or the refusal to grant such licenses on the grant of import licenses, certain trade restrictive commitments were there on the importers on part of Mexico. Now, Mexico alleged that the challenged measures applied on importation of goods were found to be inconsistent with the trade law practices in Mexico. So a request for the establishment of a panel was registered by Mexico in the year 2012, and later Mexico withdrew its request before the panel was established. So that gives us a context as to why they took their application back. Because there was no treaty signed initially between Mexico and Argentina. So that gives us a starter. So maybe the private international law, the law between the two economies furnished, but the government was not aware about it. Now that gives us another pick from here. What about Startup India and what about Stand Up India? Just before lunch, we all were talking about small businesses that have come up. For example, if my maid doesn't come home for the household chores, I order chai from Chayos. So you get that tea within 15 minutes. He gives that tea in a particular flask, and that is his copyright also. Okay, if the same company goes to US and in Argentina, would they be able to sell the tea like that? So what is the law governing small businesses in the other countries? Now here what happens was a procedural history between Mexico and Argentina. So the complainant, Mexico, it referred to the Argentina measures affecting the importation of the goods, cases, and understood that in the present dispute, certain restrictive measures applied by Argentina on the importation of goods will be a subject to challenge, and those measures will be inconsistent under the provisions of the GATT Treaty and TBT agreements and other safeguard agreements on agriculture and other aspects. So what does this show? So I think when I open up this point for discussion, I will ask my co-panelists to take it further. So my point is, private international law sometimes comes in conflict with the public international law. Over to my colleague Pranavji. I'm sure you can go ahead with the certain inputs from this, or you can have your own inputs.
Thank you for sharing your insights. I would like to say, when it comes to the dispute between two countries, if there is any kind of conflict with respect to WTO agreements and the obligations under those agreements, the countries generally undergo consultations, and mostly those consultations are closed door, and those consultations happen behind the doors. And I agree there are conflict between private international law and public international law. But when it comes to WTO agreements, only government-to-government interaction takes place, because although there are implications on private parties, and private parties have recourse to talk to the government officials and describe their concerns, because they will come to us, the lawyers who are representing government on these platforms, and they will describe their issues, and we'll make the representations accordingly. So, although the public international law and private international law are different areas of law, but they do interact in some other way.
There is an interface. So I now come directly to Amey. We are celebrating 75th year of the Constitution. We call it as Samvidhan Divas. Everybody has, big dreams. We have to live up to the expectations and the values enshrined in the Constitution. And having said so, with that, the path to Viksit Bharat is brightening in terms of businesses. Now, when Honorable Prime Minister talks about bringing foreign business to India and also trying to take up rural-based materials, say for example, the bamboo plantation in Meghalaya, do you think in countries like US and other parts of Europe, do you think something of trade can flourish between the rural handholdings of these handicrafts, and do you think it will require a new set of laws?
So thank you. It's quite an interesting question, actually. Since you spoke about treaties, now what happens is when you talk about international trade, most of the international trade at times, with the passage of time, ever since WTO came into effect, you have GATT, you have GATS, then countries also started getting into bilateral investment treaties, where any person of one country wants to do business in the other country, then there are certain set of safeguards that are implemented under the treaty. So under the general principles that govern a particular bilateral investment treaty, we call them as non-discriminatory principles. So they are something in the nature of a national treatment and a most favored nation principle. So if there is no breach of those non-discriminatory practices, you can safely say that business across borders can be done as long as those principles are not breached. Now, if you take the classic case of Vodafone or Kane Energy, which happened in 2012, I'm talking from a different perspective because from a different industry. You had a retrospective tax that was applied to Vodafone and Kane. Now, that was against the national treatment principle because you cannot apply the law separately to only one specific individual, violates your right to equality. Now, that is where the government fell flat because although they had the powers to reverse the judgment of Supreme Court in the case of Vodafone, the government still went ahead and said that no, we have the powers to apply a tax retrospectively. It went really badly against them. They lost in the Permanent Court of Arbitration where Vodafone's claim of close to 22,000 crores was approved. Then Care Energy also won its arbitration close to $1,500 million. And also there came a time where assets of India, Air India, that time it was government owned, was about to be seized in Paris by a Paris court order. So that is where these lessons basically have helped us as a nation also learn because in 2021 then we finally repealed this retrospective tax issue. So these instruments of bilateral investment treaties also have helped us to learn over the passage of time, and this will also aid us in achieving our dream of a Vikasit Bharat, achieving the 100 years of independence by 2047. So these experiences do play a very significant role in helping us achieve our objective of Vikasit Bharat.
Okay, thank you. I come back to Prateek now. So taking your introductory remarks on the international trade law and practices, I'm taking the simple example of McDonald's ka burger or vada pav that we have, or we have aloo tikki burger. So a similar stuff like this, which becomes very popular, having its origin in India, but made in a different style in other country. For example, jalebi, samosa, it's not originally from India. It came up from Sambuksa, right? And they used to make it from some non-vegetarian stuff. So provided that there is an entangling and cross admixture of cultures, that is the word. So Prateek, what is your initial remarks on how, as a globalized village, where is India's position in terms of international trade law, beginning with, at the grassroots level? Prateek.
So I would like to, first of all, thank INBA for having us here and providing us with this opportunity. Now, to answer your question, I always prefer stating an example to make it more interesting and to make people understand much easier. When we say that at the grassroots level or at the beginning where India stands in this globalized village, I think we fare pretty well. We have Indian diaspora almost in every country now. And India is on the way to become one of the leading, not just in terms of exporting services, but also from a manufacturing perspective. So we are seeing a lot of companies come to India under Make in India banner. They're setting up their shops here. They're setting up their manufacturing units here. So we are embracing the globalized world. At the same time, the world is also embracing India. So we are also being accepted all over, and we are also being given the most favored nation status by most of the countries. Now, having said that, there is one aspect that I would really like to highlight, that is of the cultural differences.
Yes.
Now, a recent example would be of one of our clients. They when they came to India, they invested a sizable amount in an Indian entity, and they were wanting to do business here. They were looking at India as their gateway to Asia Pacific region, and they wanted to expand starting from India. So they wanted to make India their base. With that intention, they came to India in about 2017, 2018. And for the first couple of years, as we say, it was the honeymoon phase, and everything went well with the Indian entity. However, as COVID hit, a lot of non-compliance issues came up, followed by a lot of miscommunication, a lot of mismanagement, and finally the investors, our clients, were fed up of this. So they decided to come down to India. They took stock of the situation, and then they realized that under the garb of COVID, the Indian entity has, or rather had siphoned off significant amount of funds from the entity rather than repatriating back as the return on investment, and most of the funds were squandered away here in India itself, and they were also taken to certain offshore entities. Now when they realized that, the first and the foremost thing my client told me was that when we came to India, we believed in India, we believed the Make in India principle, we believed the Prime Minister, we wanted to have India as our base. However, and we also believe in their culture, having a handshake deal is very common. So if you're at the negotiation table and if you have a handshake deal, that's about it. Then you don't go back to the negotiation table and you don't sit and redraw the terms and covenants. So they entered into this kind of a deal and they were trusting the Indian partners. However, unfortunately, for whatever reason, the Indian partner could not live up to their expectations, and then when they found out about the subsequent laundering of money and siphoning of funds, they were absolutely flabbergasted. Now, I mean, this was extremely embarrassing for me when I went to meet with them and their board of directors in their respective country. There was a map of, there was a world map hanging in the office of the MD and chairman of that particular company. And I'll kid you not, he had pasted a paper on top of India on that world map saying that this country is no longer favorable for me to invest.
Which country was that?
I am sorry, I will not be able to reveal the name of the country, but then that is something that really hurt me. That when we are wanting more and more countries to come to India and set up their shops, these are the kind of experiences investors are also facing, and this is the other side of the coin. Now here, I mean, this is something for the government to really look into seriously and consider enacting probably a legislation where such investments of foreign investors are safeguarded. Again, another example, a very recent example, a businessman is in news, a very prominent businessman is in news for all the wrong reasons, and he's being prosecuted in the States right now. We had a similar case about 6 months ago, wherein exactly the same set of facts, and we were acting on behalf of the complainant. So an offense was committed in India. It was discovered in the US. Then the SEC filed prosecution. There were indictments. And then they finally, as he was mentioning earlier, they entered into something called as DPA, Deferment of Prosecution Agreement. That basically gives you immunity. So that gives the company the immunity from prosecution, but the key managerial person, they all face prosecution. So the company is given certain conditions, stipulated certain conditions, they have to follow that for 10 years, 15 years, they have to pay a huge amount of fine. So the case in point that I'm talking about, in this particular case, that particular company had allegedly paid a bribe of few crores in India to obtain certain environmental clearances. And they admitted to that wrongdoing in the US. They've signed a DPA, and in that DPA, each and every, their modus operandi of their payments in India was highlighted, was narrated, and India was absolutely silent on that. And we only found out about this when the SEC order was made public. And then subsequently, public-spirited persons, individuals started taking up this matter, filed PILs in different parts of the country, and now this entire issue has come to light. But after 10 years of the original offense being committed, 5 years after SEC indictment and SEC fine and and entering of DPA agreement. Now, when we look at these issues, now these are some of the practical situations, practical experiences that we have encountered. Now, my question would be to my co-panelists as to how do you deal with this? When we talk about lofty ideas about entering into bilateral treaties, entering into investment agreements, providing, say, a similar treatment or equal treatment before the law. But here, in both cases, the clients have to run from pillar to post to get justice. In the first case, my client is still fighting it out in the Indian courts. And in the second case, the complainant is still trying to register his complaint against those entities who have committed offense in India. Now, how do you deal with such situations?
So do you, I believe that we filed the case in the home country. We filed the complaint in the home country only from where it started, and then we take it to the another country. Isn't it? No, not like that?
It was discovered in the US because their internal audit committee realized that there were certain discrepancies in the payments made in India. Then they started seeking explanation from the employees. There was one whistleblower who came forward and said, yes, there were certain payments made to the Indian officials for so and so reason, for so and so purposes. All of this happened in the US.
Okay, so Indians, wherever they go, they are governed by IPC now, BNS. I think, yeah, Pranav, I think you have a different take on this.
Like, I would say I'm not expert in private international law, but for a basic due diligence, like I think like there are contractual safeguards also. Like you can have a guarantee within the contract, like indemnity clause, where if there is any harm done to the international clients because of the misconduct of the Indian client, they can have those covered under indemnity clause. And I think like court system can be used to enforce those kind of court. So yeah, it's more about like when investors are coming into a country, they need to do their due diligence. There is an obligation on them to conduct their all due diligence, whether it is criminal due diligence, whether it is about background check of that client, whether it is about human right due diligence, and those are the standards which are there in private international law. And even OECD has ESG form like model agreements which can be used to safeguard their interests in different jurisdictions.
Amey, what's your take on this?
So when we talk of due diligence, everyone must have been aware of this very recent case of Amazon and the future dispute. It was quite open in the papers where Amazon sued the Future Group for selling its shares to an entity who was barred from their shareholders agreement to whom the shares are supposed to be sold. Now out here also, I may call it probably a lapse of judgment. It was clear as day that there was no requirement for Future to actually break away from a very fruitful relationship with Amazon. They were having a very good synergetic relationship with Amazon since they're in the same framework and the same space. But what happens is out here, this case luckily brought to the forefront that even in India, if there is any dispute now, in this case, they had referred any dispute to Singapore International Arbitration Center. Then they had the provision for an emergency arbitrator who would pass an emergency award. Then now Supreme Court luckily has recognized that emergency awards are enforceable as a decree passed by civil court. So these kind of measures which are coming up through cross-border trade deals are, I feel in a way, are cementing the belief of investors who are coming into India also that India is a safe place where your rights, your investment are protected as long as you are doing a proper due diligence, you are keeping check of where your investments are going, how they are being used. That is the only obligation that's being cast on investors who are coming in. But of course, these safeguards which are coming in, they are available. Judicial decisions are favoring those who are coming diligently and exercising their rights. So in a way, I don't think we are anywhere in the dark over there. To that extent, the only factor, like I said, is it's only you need to have proper due diligence of where you're putting the money, how you're putting the money. And for that, you have experts like for lawyers for giving you legal consultation. You have other professionals on the financial side and the employment side. You have to make use of those resources. That is the only thing expected.
Yeah, fine. Actually, today things have changed, you know. An Indian attorney can also practice at a bar in US, in different states, and also in different countries of the world, but they have to qualify the exam. However, I'm taking another case. So the first one was regarding Mexico and Argentina. Now this is regarding US. So the country with the biggest economy in the world sometimes thinks, you know, the country with the biggest economy in the world also sometimes thinks, कहीं ऐसा तो नहीं कि हमारे नियम कानून में बदलाव की ज़रूरत है. Actually, badlav, I think change is the only thing which is constant in the world. So this case number 2, it relates with the rules of origin. As my fellow panelists would also know, that it is expected that the rules of origin would decide the natural source of a product, as I gave you the example of basmati rice when I opened up the discussion. So this significance is got from the fact that there are obligations and limitations in few cases which rely totally upon the sources of imports. And here I take up the case related with USA. So the usage of rule of origin in US determines to execute measures and instruments of business strategy, like enemy of anti-dumping and shield measures. Another one to decide if imported products will get most favored nation, as Pranavji was also talking about, and also Prateek, whether they would get the preferential treatment or not. With the end goal of the trade measurements and for the use of labeling and marketing prerequisites, and also that is for the government obtainment. So let me just tell you what was the facts of the case. So under the US law, some retailers, they needed to give nation of origin labeling to specific products, including homegrown and foreign origin, and also pork. The word is pork. So the US received and executed these prerequisites to give the country an origin data, and for the beef to eliminate confusion in regard to the nation of origin resulting from the United States Department of Agriculture grade labeling. Albeit that US Congress didn't establish compulsory country of origin labeling cool measures for meat and other food products for retail until the year 2002, and the US has had the nation of beginning naming prerequisites that cover items at the retail level for more than 80 years. So why this question of beef and pork came in the year 2012? That is the question. And as for the meat, the obligatory origin labeling enactment has an early provenance, having first been considered by the US Congress for more than 40 years prior. So my esteemed co-panelists, what do you think? Was this because that is one country which relies more on meat than on vegetarian food? Primarily, this is the reason. And
yes, the labeling I think was necessary because the levels of consumption of meat by Americans at that point of time. Now I believe it's Argentina who surpasses even the United States in terms of carbon emissions due to meat consumption. So this aspect of labeling, I think at that point of time was relevant because to keep a check on how much, rather to create a statistical and empirical data of how much meat is being consumed and the quantity and the quality of the meats also that's being consumed. And also probably to help in locating which sources of meat are deriving from which location, territorial location per se.
So US has this provision. They brought out an act, rather it is still in the rule format, that they would concentrate more on the vegetarian aspects. Now, with 80% population being non-vegetarian, 20% being vegetarian, they say now we're going to turn vegetarian. So would that not bring us to this labeling factor? So now they would have different cans for beef, another for pork, saying that this pork is vegetarian, because they are saying that we are going to mix salads into it. So does that make it vegetarian? I'll give you an example of a restaurant in Singapore. They call it as Delhi Lahori restaurant. So when I went there, I was so happy that I'm going to have kind of an Indian meal, because Delhi wala khana, Delhi Lahori restaurant. So they offered keema curry, and then they mixed some salads, and they, ma'am, ye to vegetarian hi hai. So I was like, what? Aisa bhi hota hai? I mean, Pranav.
So when it comes to labeling, so any regulation that is promulgated by an state on labeling requirements, it comes under technical barriers to trade agreement. So under that, it needs to conform with the principles which are incorporated in these agreements. Like, so one would be, there needs to be scientific assessment of why such regulations need to be there. What is the cost of such regulation? And they needs to ensure that the most trade restrictive regulations are put in place. So these are the requirements which a state like United States of America will have to comply with. So which will require some data analysis from their aspect, like scientific data analysis.
So do you think there Do you think there should be an entire different dispute resolution regarding these things? Because we do not have such kind of a lobby. We do not have. Yes.
I don't know if you follow, but there's this social media influencer by the name of Food Farmer, who's quite prominent these days, where he talks a lot about processed food, canned food, where he compares the same product which is sold in India as against the same product which is probably sold in the European Union or in United States or UK, where he compares the ingredients. So where there are certain permissible limits that are only prescribed in the EU, they reach those permissible limits for the products that are sold in EU, whereas they exceed almost 1.5 to 2 times that particular ingredient, and they sell it over here in India. One classic example is your dairy milk chocolate. There will be more milk here as compared to more cocoa there. So that is where, now when I'm coming to the aspect of labeling. Now what even he had suggested was, for example in Singapore, you have, when it comes to sugar, so this is one example of sugar, they have a grading system, A, B, C, and D, depending on the variety, on the quantity of sugar per serving of 100 grams or 50 grams, that standard unit which they use. Now if there is, it's A and B category, I believe that's the lowest category, or safer categories, and C and D, if your sugar content falls under those categories, they are higher sugar content. Now they, in Singapore, in retail outlets where they are selling packaged food, and even in outlets such as Starbucks, McDonald's, if their particular drink or their eatable item is containing that sugar content and C and D, they have to specifically highlight it. In packaged foods, they need to highlight it on the front side so that people are aware. So in a way, I feel labeling will is actually beneficial also from a health perspective. And also, initially, like I said, also to identify the origin of the product when it comes to, when we're talking about meats in the US, where the particular product is originating, from which country is originating, what is the process used for processing that. So in a way, it has a bifactor benefit when we come to talk about labeling.
So I'm taking this discussion on another perspective now. Talking about medicines and health. So, different countries, different geographies have got different kinds of diseases. For example, in India, the kind of an environment we have a different kind of disease. In US, the temperature is quite different. There are different time zones, there are different temperatures. My brother is right now in Arizona, it's a desert. So he says, wahan to itni, matlab it's like a desert. And then there are places which are really cold. The temperature goes minus 10 degrees. So the climate determines the kind of disease, and some doctors there, they would say, we are in a profession where we don't want to touch the patient. So there are many such areas of medicine where the doctors don't want to touch the patient. Okay, in that matters, when it comes to international trade law for medicine, है तो हम इंसान ही ना, environment अलग बन गया तो ठीक है अलग अलग type की disease हो, but we are human beings, right? So when COVID struck, it was only one virus that hit everyone. All right, and the vaccine was 1, and then later it became 3. So do you think, esteemed panelists, so should there be an international trade law specifically relating to medicines and health? Do we have such a law? I don't think so. I don't think so. Can there be a law like that? It can be.
Absolutely, there should be one. A couple of days ago, I was reading an interesting article about copies of so there is an innovator drug or innovative drug. So when first R&D happens and a particular drug is produced, then subsequently after a number of years, the market is allowed to make copies of that. So they are known as generic drugs. So this article that I was reading about speaks about the bioavailability of that drug in human body. Now, the innovator's drug or the innovative drug, the first one, will have a potency of 90%. Now, I'm just trying to simplify because that involves a lot of technical terms. So that may have a potency of 100% because it is a lot of R&D has gone into preparing that particular drug. However, when you start making copies of that, different manufacturers start making those generic drugs, their bioavailability is different. So the way they react in the body, the way they are absorbed in the body because of various factors which are commonly not even discussed, not even known to people. Now, for example, the most common medicine that we have is probably for cold and fever, paracetamol. So paracetamol is the scientific name. Now, there are, if the original manufacturer, if he has a potency of say 100%, if generic copies, is there an...
How are you?
Hello.
You're enlightening us with your knowledge today.
Is there some acoustic problem? No, what? Please continue.
Yeah. So, now I was talking about paracetamol. Now, how that drug reacts in the body when a generic manufacturer makes that drug. Now, that has binding components into it, the way it is manufactured, the amount of pressing that goes into preparing that tablet, all of those factors affect the way it reacts in the body. Now, there is no standardization, unfortunately. And
I think,
you never know whether that particular drug is going to affect or help the body, or it could also result in certain amount of toxicity as well in the body. Now, there are a lot of aspects that has to be governed, that has to be decided, a certain standardization has to be brought in, because ultimately, as you just said, we are all humans, and if the preservation of life is of the highest importance.
So impact of technological advancements on e-discovery.
Actually, I think something is going online.
So points we have discussed, I have shared on you. On
it's in the next.
You may be aware that what we are going to discuss in this panel.
Oh, we will take another 5 minutes.
And we are getting 40 minutes time, so I think...
Pratik, you can continue.
Yeah, that's what I'm unable to.
Minutes.
So, as I was saying, now this is something that, to answer your question, there has to be a standardization, there has to be a law brought in at an international level in order to bring a certain amount of standardization, again at the cost of repetition I'm saying, so that we are all provided with similar kind of drugs. So, over to you.
Yes. So, would Pranav and Ame add to it, or should I take up something else and then we wind up?
Basically, it's the same points.
Yeah.
If you look at it from the perspective of, you give the example of COVID vaccine. Now, I think having an international standard would really help, because when we made Bharat Biotech's the BioShield, I believe it was. Yeah, BioShield. Covishield. And Serum's vaccine. There was certain resistance to Bharat Biotech's vaccine when it was sent for approval to the European countries and to the United States. Although the composition was almost similar, the only difference was the way it was being manufactured, produced, the way in which it was, the delivery rather of the vaccine was different from each other. The outcome was obviously going to be the same to protect anyone from COVID. So having that international standardization will really help in even in a case where, let's say, God forbid, there's another situation like COVID, and if some country has the ability or has made a vaccine or a drug to combat that particular disease, you should not be required to wait for approvals for each country's FDA. Rather, if it falls under the parameters of that international governing body, then that should... yeah.
I think when it comes to drug approval system, when it comes to generic drugs, the indication needs to be approved by submitting the data to the drug regulatory authority. And when it comes to standardization, there are difficulties in standardization of the drug approval system, because every region have, like, because of the genetic variation in different regions, those drugs need to be tested with different population. So that study, that standardization. Yeah, but
standardization would help you in setting out parameters in different regions. So in Asia, we have a different body composition.
I think we can, for that debate, we can go on for like forever. But let's not delve into that. But yeah, like we can talk about it later.
So finally, we would like to sum up. I'll just ask all my co-panelists to tell me internationally, because India's gospel has always been that of Vishwa Vasudha Ek Kutum. The entire world is a globalized village. But before giving up my remarks, I'll just tell one thing, that wherever there is a business, there is a merchandise. So there is a merchandise, there is a dispute. Wherever there are disputes, there has to be a resolution mechanism, both internally and externally across the globe, and that is why international arbitration came into play, right? And so now every country is having their own mechanisms of international arbitrations, and their arbitral award is binding. Their arbitral award is binding, right? So finally, I'll just a one-liner concluding remarks from everyone. Internationally, because this panel discussion was on international trade law, esteemed panelists, your one-liner on how can India develop internationally through business? Just one-liner.
From the perspective of disputes?
Any.
So one really good thing that's happened is, see, we as entering into any commercial or trade relationship, always there is a scope for a dispute. But luckily, with the passage of time, we've been recognizing concepts of foreign awards being enforced and executed and enforced rather over here. Again, now promoting or rather having harboring a culture of India being a arbitration-friendly center, which we can see it's coming up quite a lot. You have the Delhi Center for Arbitration. You have an Indian bar, the Arbitration Bar of India, which is constituted under the amended Arbitration and Conciliation Act.
Also in Mumbai, we have that center?
We have, that is an Mumbai Center for International Arbitration. We have other smaller setups, but again, promoting or rather fostering that you can also have or rather conduct arbitrations in India, providing that assurance that you have an infrastructure available at a low cost, affordable, yet without compromising on the value addition that comes with arbitration. So that is one.
Well said, yeah. Pratik, your concluding remarks.
I would say India has a bright future when it comes to international trade. We have a lot of opportunity, a lot of exciting opportunities in different parts of the globe. It's just that we have to embrace the globalized world, and at the same time, the globalized world will also need to embrace India. India, as I like to say, is a melting pot of different cultures. It's not just one homogeneous entity. We have every 100 kilometers different dialect, different people, different cultures. So that's something that the world is now able to understand, and now they're opening up their minds to India. And at the same time, we should also embrace the changes that are happening globally with open arms. We have to be a little more open about accepting various cultures, be it Western, be it Eastern, Oriental. And we should also have dialogue at every level. I mean, at the local level, at the local bodies, then at the state government, at the central government. If you're able to have more dialogue, if you're able to interact more, if you're able to give that opportunity to people to showcase their talent, their produces, as you were trying to mention about bamboo plantations being made available elsewhere in the globe. Of course, I mean, that is something that we should promote. Like Pashmina shawls are already very famous across the globe. Then there are a lot of paintings also. I mean, art and culture. India has a lot to offer to the entire world. So yes, we should embrace that. We should showcase our culture, our arts, our food to everyone, and welcome people from all over the globe. That would be my 2 cents on this.
Very nice, Pranav.
Yeah, just 2 sentences, I would say. Like, as a state, like India is already committed to various norms global norms under WTO agreement and other agreements, international agreements. So like we need to embrace it, like with when we are having multiple agreements with different countries, FTAs, like we need to choose our areas where we are able to liberalize and have a kind of a balanced approach where we, through liberalization, we gain capacity within the domestic industry because we have access to what do you say? I wouldn't say cheaper, goods at the input goods for the downstream industry at a decent price, so that we have better capacity to export value-added goods also. But these needs to be decided based on the domestic interest, the domestic industry interest, how our domestic industry is affected by such norms. Yeah.
So finally, as we end this panel, I take a pick from what China and US have done. China and US, both the strongest economies in the world, have done one thing, and that is they have led in technology, but one thing that they've not forgotten is their culture. So any country which follows its own culture will never be led behind. It's time that we take our culture across the borders. And as I had talked about bamboo, so anyone from Bihar over here? I'm also not from Bihar, but then I've decided to promote Mithila paintings. So I went to the ministry, and also I met so many people here, so they are helping us to promote Mithila paintings. And apart from that, what they are telling is that apart from the paintings that we put up on the wall, these paintings are also endorsed on the saris and the dupattas. So why not build a couture like that, wherein this can be exported internationally? Why can't we be the ambassadors of our own culture and lead our country on the path of Viksit Bharat? So let's together, चलिए मिलके बनाते हैं अपने देश को विकसित भारत बनाते हैं. कोई और आपके सपनों को पूरा नहीं करेगा. अपने देश को भी हमें विकसित बनाना है. So with that, internationally, what I believe is that what Prime Minister says, think global, but you have to act local, because it begins from here. So thank you, panelists. Let's have a round of applause for the esteemed panelists.
Thank you to the esteemed panelists. We are grateful for your contributions to this important conversation, and we hope that your insights will inspire us to all work together and be more vigilant towards international trade and compliance. Moving on, it is my pleasure to introduce a significant milestone in the collaboration between Indian National Bar Association and Kalinga University. This MOU represents a significant step forward in their shared commitment to promote and support learning that will advance human knowledge and develop and educate the leaders of tomorrow in research that tackle the most pressing problems that face our state, the country, and the global community. For this, I would like to call upon stage Ms. Vinakshi Kadan, Senior Advisor, INBA, and Professor Azim Khan Pathan, the Dean and Professor of Law of Kalinga University, marking the beginnings of this exciting new chapter and collaboration.
I am doing this honors in absence of Mr. Kaviraj Singh, so kindly. And I also head the student section, so makes all the more sense to just do this honors of the MOU. Thank you.
Yes. We shall now move on and start the next panel. The topic for this panel is managing multi-jurisdictional class actions in collective redress. I would first like to call upon the moderator, Ms. Pritika Kumar. Ms. Pritika Kumar is a lawyer specializing in diverse areas like estate planning, impact investment, regulatory matters across all sectors like communication, non-profit, and real estate. She co-founded No Grays AI, a legal tech company with a flagship product for creating wills and trusts. She is also the founder of Cornelia Chambers, a legal practice group since August 2016.
Thank you for having me here. Really looking forward to the discussion on this topic.
I would now like to call upon the panelists, starting with Mr. Nirmal Preet Singh Hira. Sir is a legal professional with extensive experience in corporate and general law. He's very well versed in litigation and including multiple appearances before the High Court of Punjab and Haryana as well as the High Court of Delhi. I would now like to call upon the next panelist, Dr. Shweta Thakur. Dr. Thakur has completed her PhD from Punjab University, Chandigarh, LLM and LLB from HP University, Shimla. She is a passionate learner of law and social sciences. She is specialized in the field of family law, international humanitarian law, and public laws. She is also a gold medalist during her LLB and was awarded the Radhakrishnan Punchi Memorial Gold Medal. Lastly, I would like to call upon Mr. Azim Khan Pathan, Dean and Professor of Law at Kalinga University. Sir has a solid foundation in legal practice and played a pivotal role in academia. He has evolved into becoming the Associate Dean at Kalinga University as well as GD Goenka University, where he led with a focus on climate change law and environmental jurisprudence.
Thank you so much. Thank you for being here, everyone. I'm going to dive right into the discussion because Dr. Azim here has to leave early. So we're here really to talk about managing multi-jurisdiction disputes and class action suits. I see that this is a very relevant topic for today with the way that the world is really becoming one place where all of the countries are really coming together, the people are coming together because we're seeing that there are various problems around the world when it comes to environment, when it comes to corporate governance, which is actually impacting all of us. So if a company is working in America, that same company is also working in India. And the people aggrieved by various corporate governance issues are not just the people in India, but also the people in America. So I see that the future of governance really lies in people coming together and filing these class action suits to make sure that the companies comply with the promises that they have made. This is really going to be the broad theme. And of course, the thoughts will become clearer as we go along, but very exciting times for lawyers. We're seeing that cases are going to become more and more multi-jurisdiction. You as a lawyer, when you're examining an issue, will not just be looking at filing a case in the country. I see there are lots of young students here, so this is really the future for you. So when there is a company that's not complying with the laws, you're going to see a future where you're not just going to look at what you can do in India to get the company to comply with the laws, but you'll also actually look at other jurisdictions where you can go and institute cases if you need to get the relevant results. So with that, I'll just open the discussion and request Dr. Azim to share his thoughts on this scheme of our panel.
Thank you. Indeed, let me first extend my warm greetings on this very auspicious occasion of this 75 Constitution Day. And indeed, it is the right time to discuss many important emerging areas, including this multinational and especially multi-jurisdictional issues in many important areas with which we are confronting with. But before that, let me extend my gratitude to the entire Indian National Bar Association for this wonderful seminar, conference, at the same time on this auspicious occasion of 75th Constitution Day. Indeed, rightly pointed out by the moderator, Ms. Pritika, that how exactly this jurisdictional and this multi-jurisdictional issues that has to be taken into account now, changing contemporary time, and how exactly we can also see in the backdrop of this Indian domestic legal system as well, how to tackle those kind of issues. Obviously, at the international level now, United Nations already they are working on many issues, including European organizations as well. European organizations, indeed, to tackle with these multi-jurisdictional issues, they have brought now in 2024, indeed, European Convention on Regulation of Artificial Intelligence. So in that context, I find now the entire world is growing with the backdrop of artificial intelligence and digital space. So a lot of issues are coming with reference to digital space. Data privacy one side, privacy related issues other side. Besides that, even most of the time we can find that IPR issues. One particular book which is published somewhere in the across other part of the world, it is being copied some or the other way in this particular part of the the world. So how to tackle with those kind of issues currently, and how this class suit, or more specifically this common suit, that can become one of the way or tool to address this kind of issues. Currently we don't have a very specific robust international agreement or international conventions where there is some or the other way one consensus based on that individual person can go and file a suit to other jurisdiction. That is not exactly the legal framework. It is up to the ultimately the state, because state can become only the part, they can only represent. We have seen that particular aspect in the backdrop of our Bhopal gas tragedy as well, how exactly we tackle that particular issue, and how exactly this class suit, it has come before the Supreme Court of India. But we were also trying to bring back to the Union Carbide company, and we were also thinking how exactly we can solve this particular issue, giving the more redress to the aggrieved people. So in that context, I find that the currently law is growing on this particular aspect. Class suit is obviously one of the important tool, but it is in the hand of individual or representative individual. But law is currently growing on this particular aspect.
Absolutely, and one example would also be the Lint case that has just happened. And what are your thoughts on the possibility of, if at all there is a verdict against Lint in that matter, do you think there would be a possibility of enforcing that judgment, or that judgment having an impact of having some kind of an impact in India as well? Do you think we can use that route to discipline as like the common people who are aggrieved? Do you think we can use that route and file a class action suit here using that judgment there?
Yeah, absolutely, because that's what I am saying, indeed, law is growing,
It's
and
really
wherever.
growing, yes.
It's growing, and
It's
then
becoming more and more interesting, and there are even more opportunities for us to collaborate with the lawyers around the world. What would be your thoughts on this, ma'am?
If we see for the data breach or the digital world, there are a lot of cases where your class action suit has been used, and the compensation claim has been given to all the victims who are there globally. So they have to show that they are the actually customers, or they are the actually consumers of that particular services. And by virtue of that, if they are coming in with that particular domain as a person for whom the representation has been done in the class suit, then they are able to get their claim as in compensation. So all the people who are there who are going to be aggrieved by those data breaches, so all those people, they are going to be collectively taken into consideration in the compensation claims. So this is one of the beauty of the class suit also, that one person on behalf of all the other people who are having the similar interest, they come forward and they address that issue on behalf of all the people, and the redressal is given to whole of the people who later on claim that we are actually aggrieved by that particular type of data breach, or that particular type of any cyber crime, or any other type of environmental degradation, or any other type of the suit in which the class actions can be done, such as the labor laws also. So for that, they can get the compensation, and those who are actually aggrieved in India also, by their data, their information has been leaked, all those people, they will get the claim, if they are going to claim it as a person, as a victim of that particular data breach.
Understood. So in your study, you found that such cases are mostly found in in say like the global environment, or you're also seeing such cases in India specifically for data protection?
When we see for the cyber crime or the data privacy or breach of data privacy cases, so for the cyber crimes, there always be the jurisdictional issue, and always there will be a difference of jurisdiction also. It can be national, coming within the national jurisdiction also, where the perpetrator as well as the victims, they are from the same nation and they have their own jurisdictional laws on it. For example, we are having the IT Protection Act, our law in India also. So the problem is where the perpetrator is of one country and the victim, they are belonging to the different countries throughout the globe. And for them also, there can be the class action, there can be the representative suit for that. When the claim it has been said to be distributed to the victims, then the victims, they can come forward that they are the actual people who have, whose information has been leaked, or who are using that services within that time period for which the information has been leaked, and they can get the claim of the compensation for that.
Let's just break this down for the audience here, and let's all just think together about this. Say if today there has been some kind of a breach, and that breach of privacy, since we're talking about data protection, and if that is affecting people around the world, for example. So what's that one way that comes to your mind that we can all get together and actually take, say, Meta to task? Say, because, you know, they're really holding all of our information. With all due respect to Meta, that's just an example. Dr. Azim has to leave early today, so we will thank you
so
sir.
much indeed, all of you. Indeed, I had to spend a lot of time here, but because of already planned, my flight is there. But I wish you, all of you, the 75 Constitution Day, and indeed very interesting, this entire Indian National Bar Association, this entire the function and this entire conference. A lot of deliberations has come on the floor, and a lot of important inputs has come on the floor. And thank you so much Ms. Pritika as well, and all my co-panelists, Dr. Shweta and Mr. NPS Hira as well. Thank you so much indeed, all of you.
Thank you
so
sir.
much.
Thank you sir. Okay. Very thoughtful. So coming right back to the case study that we were considering. So what could be one possible way for people around the world to come together and...
If we see the way you have asked, there are so many other cases which have already been deliberated and it has been decided. So let's take some example of them also. So there is one case of Netflix, where the class action, it was there over the Netflix, because there is a issue regarding the streaming during the Tyson and Paul fight. And all the consumers who are there, they're expecting that they will enjoy the fight, and it has been postponed and there is some technical issue. So this particular claim is regarding the Netflix. And Netflix, it is used not in a particular domain or in a particular territory. There are so many consumers which are there from throughout the world who are expecting to have or who are expecting to visualize that fight in order to enjoy it. Then the lawsuit, it has been filed, and when the representative suit it was filed and it was said that actually the Netflix has failed to deliver the promise, and it has breached the confidence and the service term which they have provided to their consumers. And these consumers, they are not the one which is from one particular country, or they are throughout the globe. And Netflix, it is said that they have violated the consumer rights, and the compensation claim, it is to be given to all the consumers. And for that, there will be the one setup that for the compensation, there will be one particular portal or one particular place will be there where the people, they have to enroll themselves and they have to come forward to tell that actually they are aggrieved by, their consumer right has been aggrieved, and then the compensation will be given to the particular individual person.
but how are these people brought together? How was the claim filed, and where
So
was
there
it
will
filed?
be some public spirited person, or say anyone on behalf of, it's not that there is some qualification to a person that you will be the person who will be the representative, or you will be the person who will be the plaintiff. Anyone who can come forward and who can file a class action, and there are certain requisites which is to be, which he has to show that it is a class suit, and I am filing on behalf of all the people who are aggrieved by a certain data breach, or who are aggrieved by any type of infringement of the consumer right, and that person will show that there is the generality of the people whose rights has been infringed, or the common people are there on the behalf of them. They want to file a class suit, and there will be the evidences, whole of the trial will go, and if it is proved that actually the class suit is there and the number of people, there are the numerous people whose rights has been infringed, then that class suit will be taken into consideration, and the compensation claim, it will be given.
Understood. So let's just break this down a step further for the people tuning into this conversation. So if there are a set of consumers in India, a set of consumers in Europe, a set of consumers in America, I would then imagine that there would be either public-spirited people who would talk to each other through some platform that's available for multi-jurisdiction class suits to be initiated together. I think that's the future. We are also building a platform like that, and it's you can have a look. It's people-india.com. It's been live since 2016. Some people, we've seen very few people are coming and using it organically. We don't spend any money on digitally marketing it. We're just seeing how it grows organically. So I would imagine that people from, or actually, you know, I would imagine that the most public-spirited people are lawyers mostly. That's why a lot of us originally choose to become lawyers. I would imagine that there would be lawyers in India, there would be lawyers in America, there would be lawyers in Europe who would come together, and they would actually look at all of the contracts that say, for example, in this case, we're considering a breach by Netflix of their terms and conditions. They would have a look at their terms and conditions, and then they would talk to each other and see where it is that the common grievance would get redressal the soonest, and then they would come together and file a claim in any country or any jurisdiction that they choose for that specific grievance to get redressed. I think this is how people will get their grievances redressed in the future. And some of this we are also seeing in the allegations that have been cast against Adani in the recent indictment in the United States of America. We are seeing that these international investment agreements have been used to invoke jurisdiction in courts in New York to question certain information that reached them regarding bribery. We are yet to see what the final findings would be, but here again I see the possibilities of the future for lawyers to actually use the multi-jurisdiction approach for class action suits. So if you feel that a class action suit will not get redressed in, say, Pakistan or Bangladesh or India, because frankly speaking, our courts are overburdened because of our population and we are still a developing country, I do see that, that the lawyers here could look at more fast-moving courts to actually get redressal for like these class action suits. Do you think that could be something that we could all look at?
If we see for the Indian point of view, we already have the representative suits or the class suits, which are, they are the provision in the CPC also.
Yes.
They are the provision in the Companies Act also. When we see the Competition Act for the anti-competitive agreements, there also the class action can be taken. So we can't say that it's not in India. We already have all the environmental. There are so many suits which has gone to the Supreme Court in the form of public interest litigation or the class actions. Yes. So already we have, since from 1908 when we are having CPC, it is already there. actually the reason why class action it was permitted, because it is that there should not be the multiplication of the litigation, as well as all the people, they can't come forward for themselves to have the individual claims. So in order to waste the time of the people and the resources of the people, and similarly the time and resources of the court also, there can be one particular representative suit or the class action for one particular type of the, you can say, redressal which is to be asked. So that's why it is there everywhere. But the problem comes when the transnational or the global aspects are there, but it is there, it is acknowledged in the different data breaches also. So we can't say that it is emerging, it is already emerged. And if we see the national laws, Indian law, it is already there in the Indian law also.
Yeah, so here I'd like to explain my thought a little bit, which is that of course we've had Order 1, Rule 8 since 1977 in our country. We've had public interest litigation which has been used. We also have class action suits where shareholders or depositors with about 5% interest in the company, if it's an unlisted company, or 2% if it's a listed company, can go to court and get their grievance redressed. If a company is not following the laws, shareholders can come together and use our governance mechanisms, our courts and institutions. But from a consumer standpoint, there is a problem I see with that. I wouldn't personally, if today someone is to come and ask me my advice on which forum do you think a community of consumers should go to if they are aggrieved by, say, for example, one of these global tech companies, which jurisdiction should we go to get damages, say if we are aggrieved by the data breach? I wouldn't personally recommend courts in India, because I'll tell you why. Not because I don't have faith in our judiciary, but because what I have seen in my experience this far, and I hope it changes, is that the kind of compensation that we are awarding to people coming through your consumer forums or in class action suits, that's really very small. And I'll give you an example. There was this one matter where a tree had fallen down and on a man, and the compensation that was awarded to him was about 50,000 rupees ultimately, even in appeal. And the courts there admitted, the judges there admitted that we are a developing country, we cannot be giving too much compensation. For a lost life, only 50,000 rupees was given. So I would think that if there are these class action suits where ultimately people are seeking redressal. Now, how is redressal given? It is given through compensation. And in that case, we have clearly seen that there are jurisdictions where the compensation that is awarded is far more. And it is given very, very quickly. So while we have those tools in place in our acts and in our regulations, what I'm seeing is that the outcome of that takes too long. And when we even get a judgment, the compensation we see there is very disappointing. I hope that changes. But until that doesn't change, I think we all need to shop for forums that will give our people better compensations. What are your thoughts, sir?
If we, as you talked about linked case.
Yeah.
So, linked chocolate case. In that case, multi-class cases can be filed here. But if we talked about the enforcement of foreign orders, so for that, the two facts has to be taken into consideration, that order has to be given by competent court and order has to be given on merits.
Yes.
Okay, as United as a imported company, they don't have a manufacturing in India. So in that case, their judgment can be applied in India on these two factors. But if we talked about Adani's matter, so in that allegations are that they have bribed the Indian government to get the details of the
To basically get the contract.
To get the contract, yeah. In that case, I would like to refer the Jet Airways matter, in which Dutch government has approached the Indian government to enforce the Dutch laws and to stop the Indian proceedings and enforce the Dutch
judgment in India. So which was totally denied on the ground that the Dutch laws cannot be enforced in India on the grounds that NCLT has, they said that IBC will be dealing with that, NCLT will be.
So I'd like to distinguish the present litigation, which is all over the newspapers. So here, there is an investment contract that has been signed. This is what I have read. This is from all of the news that's available. I've not read the papers. In that investment contract, there is a clause where the company that's in question and the promoter has actually signed, and these contracts have, I'm pretty sure the governing law is the governing law of some third party state, and most probably of America. If they're giving out billions of dollars, they're going to say that the applicable law is American law. He would have agreed to it to that extent. Now, he has agreed to it and he has subjected himself to the jurisdiction of American courts. He has agreed to it. He has subjected himself and he has said that there will be no bribery. There will be no bribes that will be given from the money that is given to me, which will now be invested in certain infrastructure projects or whatever was the purpose that was given for the investment of that money. Now in this case, in case the allegations of bribery are proven against him after the trial, there will be a judgment against him where he will be punished. Once he is punished, there will be some orders that will be issued and he will be asked to report in the United States of America, where if the punishment is imprisonment, he will have to follow through. And now India has signed these extradition treaties. So there is an international obligation to actually respect it.
If in that case, there is a reciprocal judgment of Hague Convention in which India can deny.
India can deny.
Yeah.
Deny what?
To enforce their order on Adani.
On Adani.
Yeah.
That's an interesting piece of information.
It's in 2019. Since 2019, it's under consideration. In 2019, they have ordered that unless and until we will be a signatory in a convention, we will not enforce such.
I'm going to go and read that. It's
Surely.
a very interesting twist. I'll take the name of the convention.
Surely.
Now, another twist to that matter would be someone has filed a case in the Supreme Court of India on the same grounds.
Justice Suryakant has rejected that petition that foreign law cannot be enforced in India. In that, there is a matter where father has asked for a daughter to be called to India as foreign judgment has been, or foreign judgment was in his favor. So Justice Suryakant, it's around 10-15 days ago, he has ordered that no, foreign judgment cannot be enforced in India if it is.
But don't you think, how is this for the growth of this country? Because right before this panel discussion, we had a panel talking about how if we want India to grow, we also need to collaborate with the world. We need very clear laws. We need rule of law to be in place. If we are going to, keep rejecting foreign judgments, how is that going to play out for us?
In that case, I'll explain it in a while. Till then, ma'am can ask.
So you are talking about when the extradition, they are not following for the extradition. You are saying that?
We were talking about the Adani matter and we were talking about the extradition treaty.
For the extradition treaty, you are saying that if globally the countries, they are not going to adhere to the requests which are made by the co-countries regarding the extradition, how we will grow further. For that, there are certain reasons. If there is a political issue, if the person is having some political charges against that person, then the person who is coming within the definition of the political criminal, for that there is apprehension that there can be any you can say, threat to his life, and there can be any other type of conspiracy against his life, then on those cases or those grounds, the extradition request can be set aside. But these are only certain listed reasons for that the extradition can be rejected. But for else, you have to go for the extradition if such things are not there in the particular case. So it's not that globally we are having some request from any country and all of a sudden any country will say we will not extradite the particular person. There is a set mechanism, there are the set grounds. On the basis of those only, the extradition request can be set aside. For the rest of the cases, the criminal has to be extradited. Yes.
Okay. Will really, in a commercial matter we're talking about here, in my opinion, it will really depend on whether or not that's a well-reasoned order. So if the contracting entity has agreed to subject itself to, say, English law, and on that basis it has agreed to do business, and there is certain aspects of that judgment, and that judgment could have been delivered even in Singapore, in, say, your Singapore commercial, something like a commercial court or a arbitration center, and naturally some aspects of that judgment will have to be enforced in India. I don't see why that judgment will not be enforced in India. So if property needs to be attached, naturally, like ultimately it will be some kind of damage or compensation, then there is no reason why one should not be able to enforce that judgment in the Indian courts. But in my experience this far, I haven't seen a judgment of that nature being enforced in Indian courts. So I can't say what really happens on ground. I'd like to, hopefully in the next 5 years, but the law is very clear. The law is very clear, and so coming back to.
I want to answer.
Please,
Yeah.
please.
For that, Ministry of Home Affairs has entered into a mutual legal assistance treaty, in which they have to enforce such orders in India. It is with 22 countries. Yeah.
So what do you think is the future of class action suits in India?
So class action suits are already there. The way we have pointed out, different legislations are there. And the class action suits, they are required, or they emerge only when there are the victims, there are the numerous victims. And those numerous victims are not going to file numerous suits in the court. And all the class actions which already have been taken by the Supreme Court of India, it has been redressed, as well as the compensation claims, they have already been settled out and given to all the victims also. So the class action suits are having a good future in India. We can't say that we are not having the, you can say, we are having a good mechanism. We are having the legislative, for the consumers also, in the Consumer Protection Act 2019, the class suit has been introduced. In the Competition Act also, for we can say in the environmental domain, whether it is for the labor laws pertaining to the employment, whether it is for your competition law also, we already have the class suits, and we have to rely on the judiciary also, that they will provide the redressal and good compensation claims, which is actually required to restitute all the victims. So it's already there, and
you're seeing a positive future, and we should use these tools more often, and we should ask and demand more compensation.
More compensation. And according to the, you can say, the gravity of the situation and the gravity of the sufferings and how much loss has been incurred, it will be counted and the compensation will be given.
Wonderful. That will be a great future. What about you, sir? What do you think? And with that, we will wind up the session.
In the last, I would like to say that as India has went into a Vienna Convention, ठीक है, under which it is listed that we are exempted from enforcement or execution of such few orders if we want.
Thank you, thank you. Does anyone have any questions? Thank you so much.
A very big thank you to you, ma'am, and the esteemed panelists. I'd like to quickly move into the the second last panel for today. And this is an international panel, and we have the panelists joining us here on video conferencing. I'd like to introduce them, starting with Dr. V.P. Tiwari, who is a professor and head of department in MNLU Nagpur. Professor Tiwari has been serving as a professor of law since 2018. His academic interests encompass a wide range of legal domains, including constitutional law, administrative law, comparative law, and social transformation. We also have Mr. Vasilius Triantaflou. He's an attorney at law at Zerolet. He's also an immigration consultant for Belgium and the United Kingdom and serves as a lawyer at Zerolet Law Firm, which is a Brussels-based firm specializing in a multitude of legal services. We then have Dr. Professor Tabrez Ahmed. Professor boasts an impressive career in academia and administration. Before leading the MANUU Law School, he served as G.D. Goenka University's Vice Chancellor. His prior roles include senior positions at Chandigarh University, Galgotia University, UPES Dehradun, Alliance University, University of Burman, and NUJS Kolkata. And finally, I'd like to introduce Ms. Garsa Bejdo, who is a barrister at Zerolet. She's a seasoned barrister with over a decade of experience and a strong track record for delivering expert legal counsel opinions and specializes in navigating complex legal issues. With this, we can commence the panel discussion.
So thank you very much. I'm audible to all of you. Are you getting me? Yes, so thank you very much for giving us chance to discuss a very important area for today, that is impact of technological advancements on e-discovery and digital forensics. We know very well this is very advanced area to explore and discuss because keeping in mind the fast changing scenario of the law and technology, and also we know very well that recently Government of India has passed 3 new laws amending the IPC, CRPC in evidence and making mandatory for those crimes where the liability is 7 years jail to capture video and also collect the electronic evidences, digital evidences, and also government has mandated at least 3 mobile forensic labs in each district. This shows that government's commitment, and also it requires a lot of capacity building in terms of the forensic science experts, regulations, and also about the training to the police officers to make it very important. I'm very happy to share that we have very important panel. We have Dr. V.V. Tiwari, Professor and HOD at NLU Nagpur, and also we have the attorney at law, Zerolet, Mr. Vasilius Triantaflou, and also we have Gersa Bejdo, barrister at Zerolet. So thank you very much, my fellow panelists, for joining and also agreeing to speak on a very important area to explore today. We know very well that the way the market is changing. If you see earlier days, we used to say that the person who is having a lot of ores, maybe iron ore or maybe oil and gas, maybe the kind of stone can be the market leader. Now the market is fast changing. Now today the market leader is considered the person who has a lot of data. We know how data is kind of flowing globally and how important is data analysis and also on the data security, data privacy, because everything is revolving around the data. And in terms of the success of the online business or the e-commerce, m-commerce, we know that we have the payment system in terms of the online payment, credit card, debit cards. So the moment we pay 1 rupees by GPay, it is going to have complete 7 processes. And it is happening in a few seconds and it is traveling several countries. Some country may not have very strong data protection laws. Some country may have very strong data protection laws. Some country don't know that who is actually the access to all the data. So in terms of the global regulation, the big challenge, because till now we have a very strong law by the European Union that about the data protection laws. India also the last year has made the DPDP, and also some of the foreign countries also they're coming forward to make the data protection. But still in terms of the eventuating of the AI in blockchain, because we are always lagging behind about the regulation and we are trying to catch up the regulation. The big challenge between the legal philosophers, the legal regulators, lawmakers. We know that since 2020, we are able to have the 5G technology. And we in 2010, we have the 4G technology. When we got the 4G technology, it has made possible about the kind of the online, and we can have the real time. We can see the online matches. We can see real time kind of the news. We can see real time events. It has given a lot of importance, lot of recognition, and because of this kind of the 4G technology, India has become one of the biggest data consumer in the world. And also the biggest thing happened in 2020 during the pandemic that we are able to have the 5G technology. So because the 5G technology in 4G, if you are going to download a movie, it may take 4 or 5 minutes of the 1 hour movie. But in the 5G technology, it is taking few seconds. And also the data speed is so fast because in the 5G technology, data is two-way process. Just like, you know, the two-way lanes are there. If one-way lane is there, there's a chance for the kind of the accident. But with the one-way lane, the chance of accident is very less and data can flow very fast. So this is the biggest kind of the benefits of the 5G technology. But also because of this, in the 4G, we have the at least the tower at 7 kilometers. In the 5G, we have 250 meters we require the tower to capture data and pass data. And because of this 5G, we are able to have autonomous cars. And we are able to have the kind of the data flowing throughout the world very fast. But the challenge is that who is going to have the data sovereignty, who is having the data localization, who is going to the kind of give the confidence and trust that data is very safe. So it is now by nature of the internet, the boundary is global. If you see earlier days, if you go to 100 years back, it was very challenging to get the kind of the, it was a totally licensed. Only those who are the foolish person, maybe MLAs, MPs, doctors, okay, the bureaucrats, they may get a telephone connection. And who will get the local phone, who will get the STD, SD was fully licensed. But right now, see the kinds of delicensing and now the power of communication shifting from the too much control to a too much open model. Even a rickshaw puller, even a sabzi wala, dhobi, he can easily go and buy a SIM card and within a few seconds he can activate, start calling, getting data, and he will be subject to crime globally and he may be doing crime globally. So this is the challenge right now we are facing. And because of this, we require truly a regulator globally. But sorry to say, we have at least, we have, you know very well that we had the Cyber Crime Convention 2001. It was led by the European Union, US, and all these the countries. And it is now signed by 68 countries. India has not signed. Again, we have seen 3-4 years back, this Russian-led the Convention on Cyber Crimes, supported by China, India, Brazil, is in the process. And now there's two groups in the world. They are trying to capture the market in terms of the regulation of the internet, in terms of the regulation of data, in terms of data sovereignty, because we know very well data will decide the fate and success. We have seen the Cambridge Analytica case of the last election of the American president. There was a kind of case that it was the social media was used to change the kind of the aspirations, to change the approach, to convert the people's mindset, to change the pattern of voting. And we know that how it was happened. So even social media is also politicized, manipulated in terms of the personal gains. It means that we require very strong regulation globally to understand that our data is safe, we are also safe, and also we are trying to see how it can be utilized in terms of e-discovery. But there is a lot of role is played about the electronic data, digital data, and then in terms of the cases, now how the clients, how the kind of the two lawyers, two parties will be going to share the electronic data, and also how we are going to use machine learning. Because we know very well, because of the machine learning, there's a lot of challenge. Machine can learn good things and go on providing the kind of the recommendations for good and better. Machine may also learn wrong things, may go on the suppressing or may recommending the innovative ways of doing the crimes. Now, who is liable for all those things? Because there is no human mind is there, but actually machine is learning and trying to recommend and do something very, very innovative in terms of AI. Also, we have blockchain technology coming in a big way, because only blockchain can save and also provide very strong support. We know very well that cryptocurrencies are there because of blockchain. And also, if you talk about the safety and security, we know that we have challenges about the people are selling some plots and flats 3 times, 4 times in a tehsil. If we can apply the blockchain at tehsil level in the land, the transfer cases, we can really control on the fake transfers of the land cases. Same we have challenge about the licensing of the IPRs, because somebody will get an IPR and ultimately business will be lying and that who are going to get the license providing the business. It has two challenges. You have a lot of IPRs and you don't know that who are aspiring to get the license. And also the license holder, sometimes they want a license, they don't know who is the real owner of the IPR to get the license. If we can apply the blockchain technology in terms of the licensing of the IPRs, we have 16 kind of licenses. We talk about the software, the company software business. And also we have the challenges about the getting IPR registered. We know very well in the country, if you have some innovations, you require 3 to 4 years time to get your patent registered. In terms of the kind of the timing is very long-term time is taken. If you can apply the blockchain technology in terms of the IPR offices, patent office, copyright office, trademark office, we can cut a lot of time. So I'm very happy to share that we have very big and a very renowned panel from all over the world. And also they are practicing lawyers, attorneys, we have professor in terms of the Dr. Tiwari. So let me then give the floor to my fellow the panelists. So first, I would like to ask from Jersa Bezdo, she's also an attorney, that let her the opening remarks about the topic that impact of technological advancements on e-discovery and digital forensics. Please share your views.
Hello, everyone. I hope you are well today. My name is Gersa Beichto, and today me and Vasilio, we are going to have a presentation about technology in forensic science, evaluation, and precision. I'm going to start first. I hope you enjoy that. So, the advancement of technology, these developments have provided the science with many cut-edge tools, devices and applications, allowing forensics a better and more accurate understanding of the crime scene, a better and optimal acquisition of data and information, and a faster processing, allowing more reliable conclusions to be obtained and substantially improving the scientific investigation of crime. The article describes the technological advances, their impacts, and the challenges faced by forensic specialists in using and implementing these technologies as tools to strengthen their field and laboratory investigations. The systematic review of the scientific literature used the PRISMA methodology, analyzing documents from databases such as Scopus, Web of Science, Taylor and Francis, PubMed, and ProQuest. Studies were selected using a Cohen-Kappa coefficient of 0.463. In total, 63 references articles were selected. The impact of technology on investigations by forensic science experts present great benefits, such as a great possibility of digitizing the crime scene, allowing remote analysis through extended reality technologies, improvement in the accuracy and identification of biometric characteristics, portable equipment of on-site analysis, and Internet of Things devices that use artificial intelligence and machine learning techniques. These alternatives improves forensic investigations without demonizing the investors, prominence and responsibility in the solution of cases. I'm going to pass now to Vasilios.
So thank you, Jersa Bejdo, for your actually remarks on the title. Now I would like to be very specific to the Mr. Vasilo Tranfilo that please let us know about that use of blockchain for data security. What is your view that how it can help us?
Many years ago, good afternoon, good morning, to everybody. Good afternoon to India. Thank you very much for the invitation. It's really an honor. Good afternoon, dear eminent colleagues. Let us know what it is, because in a dynamic space of digital forensics, the integration of artificial intelligence, R, and machine learning starts as a transformative technology, but also poisoned to amplify the efficiency and precision of digital forensics investigations. Here, if we go back in the 1990s and the brief synopsis of digital forensics, what became known as digital forensics was commonly termed computer forensics. The first computer forensics technicians were law enforcement officers, were also computer hobbyists. In the USA 1984, work began in the FBI computer analysis and reports and as a response team to CART. 1 year later, in the UK, the Metropolitan Police set up a computer crime unit until John Austin with what was then called the Fraud Squad. A major change took place at the beginning of the 1990s and onwards. Investigations technician support operative with the UK law enforcement agencies, along with outside specialists, realized that digital forensics, as well as with other fields, required standards, techniques, protocols, and procedures. Apart from the informal guidelines, these formal lists did not exist, but urgently, I can say, needed to be developed. A series of conferences initially convened by the Serious Fraud Office and the Inland Revenue took place at the Police Staff College and Bramshill in 1994 and 1995, during which the modern British digital forensic methodology was established. In the UK, in 1998, the Association of Chief Police Officers produced the first version of its good practice guide for digital evidence association of chief police officers in 2012. The ACPO guidelines detail the main principle applicable to all digital forensics for the law enforcement in the UK. But this does not apply only to the police. We have the role of the court, the leading decision, the contrary scientific conclusions with the court judgments, and so many things. And also, we also have what is the role and what is the scientific method of scientific laws. The aim of science is to make order out of chaos by producing explanations for what we see around us. These explanations come into the form of rules of law, or law, which we hope once described are universally true. For example, objects or whatever weight dropped from a tower or other high point will always fall at the same rate, assuming the same resistance, and that the rate can be described by a scientific formula. We can also say that this is a part of more general phenomenon known as gravity, and that we can produce broad explanations which, among other things, so why the Earth orbits the Sun in a particular way, and that the Sun in turn has position and relationship with other stellar bodies. Typically, we are able to derive a scientific law by making an initial observation, given a provisional hypothesis which explains what is being observed. providing a means of testing the hypothesis and actually testing the hypothesis, the experiment, for example, and examining and analyzing the result of the testing to see that they conformed with expectations or some revision thereof, saying that the hypothesis is now a scientific law that holds good for a given range of phenomenon and which can be published as such. So the process is known as the scientific method. The end result of the application of the scientific method is a scientific law. And then we have, the court proceedings, for example, a witness and a case, it may took, many, the legal, it was the legal decision making. This takes us neatly to the next issue to explore the relationship between a finding by forensic scientists and the decision of the court. Put bluntly, if a forensic scientist were to state in evidence that there is a probability of 1 in 1 million that a DNA sample found at the scene of a crime matches the DNA profile of an accused, then would be the court be bound to accept his finding. So many things. Thank you very much.
Thank you very much, Mr. Basilio, for putting the scientific methods and DNA profiling in terms of the evidences to prove the case. And also, we know very well these are very, very important area to explore, because if you get any parts of the kind of the culprit, maybe in terms of the blood sample or any hair fall, and you can also know very well that by analysis you can find out the DNA, and by DNA mapping you can find out the person who was the criminal. So thank you very much, Jersa, and also the Vasilio, for bringing your opinions and about your points about the e-discovery and the role of the evidences in terms of the forensics. Now we'll come back to Dr. V.P. Tiwari.
Thank you.
And I would like to hear from him that what is his view in terms of e-discovery and also the forensic science for evidences.
Thank you so much, sir. Thank you so much. Very good evening to all of you. I do not know whether it is evening or noon at your place, but whatever it is, greetings from my side. It's the 13th annual international conference and 75th Constitutional Day on Law and Policy Issues being organized by Indian National Bar Association. I must congratulate Indian Bar Association, National Bar Association, for organizing this conference and inviting me also for this conference. The topic is very important, as has been said by the chair, Professor Tabrez Sahab. But before I switch to this topic, I just wanted to tell that any Constitution Day celebration will not be complete unless we remember the architect of this Constitution, Dr. Ambedkar, Dr. B.R. Ambedkar. So with the kind permission of the chair, Professor Tabrez, I just wanted to give a little reflection on what Dr. Ambedkar felt when he was trying to speak in the Constituent Assembly in the last day. One of the worries of Dr. Ambedkar was that India is going to be free on 26th January. India is going to be the federal country, a republic, on 26th January 1950, and after attaining the freedom. However, he was much concerned whether this freedom is going to long last or not. For the fact that India was free earlier, India had a democracy earlier, but at a later point of time, it became a colony. It was being ruled earlier by the Mughals and later by the Britishers. So he says that the most important thing, India is already divided into caste and creeds, and now politicians are going to have their own political party, and they may divide the country in yet another manner of the party support basis. These days, we are able to see that politicians did not hesitate in spreading the false news, and this has become very easy with the advancement of technology. So this false news which is being spread in favor of their party and dividing the country, which goes towards even murder. day before yesterday, four innocent people were killed because of some political parties. So what I'm worried that it is the freedom. Dr. Ambedkar also worried that India is going to have the political equality, meaning thereby that one person, one vote, one value. But what about social equality? What about liberty, economic, political, and social? He wanted that everybody should be given this, otherwise we may lose our freedom. I just wanted to emphasize, sir, I'll take 4 minutes, not more than that. The Dr. Ambedkar said that in free India, there should not be any scope of dharna, pradarshan, protest, or whatever it is. He said that this could have been possible when there was no constitutional mechanism of solving the problem. Now, because we are having the constitutional mechanism to solve our problem, these should be abandoned. The protest, etc., should be. And he compared this type of protest, etc., to anarchy. And I appeal through this conference that in our country, we have well-established courts, we have the political system, and we should resolve to them and not go to such type of violences. We should also try to remember we have some social duty, social obligation, duty towards country. Our constitution preaches solidarity, it preaches fraternity, it preaches dignity to all of us, and we must respect. Sir, today, as you are given some topics, I thought that I'll little talk about impact of social media on Indian society with your kind permission. Of course, it has a very many positive impact, and due to shortage of time, I may not be able to emphasize much on the positive side of the social media for the fact that we all know how usually we have been benefiting because of the social media. 4 or 5 years before COVID came, I think this type of conferences were hardly organized. It was looking how our students would get education. But because of the advancement in technology, we have been able to very successfully cater to the needs of our students. We have been able to organize such conferences and share our views. So there have been huge benefits, but this benefit has not come for free. It has definitely brought certain problems. And there are so many negative impacts also. Say, for example, fake news. The whole world is suffering from the fake news, and there is no control on the fake news. There are people who are free to write whatever they feel to write, and that raises several concerns, especially in a country which is divided on very, very many things, reason, language, religion, many things. Then the social media is also being used as a propaganda tool, and this is required to be stopped for the betterment of the country. Then people start trolling. Something happens. I have been watching for quite some time. Aishwarya Rai and Abhishek Bachchan have become the trolling and bullying things. The most important thing that one thing has come, digital arrest is also there these days, as our Prime Minister has been speaking for quite some time. Then the social media is also being used by people who are involved in terrorism or some other fraud activities. Besides this, there are some impact on our own behavior also. And with the kind permission of the chair, I'll just emphasize on this and then finish in 2 minutes. See, our behavior is also greatly influenced by the social media these days. I have come to know, after a research it has been found, that those who spend more time on social media are more likely to experience anxiety and depression. They are falling the victim of depression. Then social media is also a new type of addiction. Now, if you don't see your WhatsApp, if you don't see your post, if you don't see your post, how many people have liked it, and if you don't reply, then we do not even sleep. I have seen people getting up in the morning, in the night at 2 o'clock, and then replying to their posts. That is really a very, very serious concern, because a good health, a good mind stays in a good body. And if our body is not good, if we are not able to take sound sleep, our performance next day is going to hamper very adversely, and country definitely cannot progress. Then, as has been said, it is breeding ground for misinformation also for very, very many people. I heard the former Chief Justice Chandrachud, 2 days back, he was telling that even I came today about myself through social media, some misinformation about me. Then people are isolated from this real world. We have only one friend, that is Facebook, and some other Twitter, etc. But we are totally isolated, which is very, very bad, because long back it has been said that man is a social animal. We need to stay in the society. And when we meet people, definitely we exchange so many pleasantries, so many good things, so many bad things, and learn a lot. So these are the bad things: cyber bullying, privacy, fake news, data privacy, and security breaches. The concern, and I'm very sure that we are looking forward to have a legal regulatory framework so that it is tightly controlling fake news and something which is spreading hatred in the society, which is bringing bad blood in the society, which is leading to the killing of the people on some flimsy grounds. Then fixing responsibility. If some bad thing is spread, who is responsible for that? We must be able to find out the person so that the law can, justice can take its own course. Then there should be transparency. And of course, the people awareness should be there that every good thing has some bad thing, and we must be aware of it so that we are able to control our interest. And of course, use of technology for dispensation of justice is a very, very important. I must tell that in India, the courts have been very generous in accepting the advances in the technology. Probably all of you know that Kasab was tried on the basis of CCTV footage. And there have been several cases where the criminal have been convicted on the basis of chat details, etc., etc., etc. Even in one of the cases I was reading, and the audience will be very happy to know, that some contract were accepted as they have been the final contract without proper signature on the basis of exchange of emails, etc. So that is very good. And I must remember that, as has been said by Jefferson, that the American jurist and great leader, great philosopher, great statesman, that we may consider each generation as a distinct nation with the right by the will of the majority to bind themselves, but none to bind the succeeding generations more than the inhabitants of another country. What he meant that dead should not rule the present. So if we have advanced in the technology area, we must accept this as the gift of this time, and we must use in all our areas, including dispensation of criminal justice and elsewhere. But we should be, at the same time, careful about its misuse and misimpact so that our nation can lead a very happy life. I'm very sorry, and as the Professor knows, that in Happy Index, we are behind even, I think, Afghanistan also. So bad of this. And this is because we have not been able to control the side effects of technology. I hope that in this area also, the government will be doing something, and India will be one of the happiest countries in our time itself. Thank you so much, the organizers. Thank you, Chair. Thank you to all participants. Have a nice time.
Thank you, Dr. Tiwari, for really putting very, very important points, and so especially remembering Dr. Ambedkar on the day of the Constitution Day, and also trying to provide the ideals of the Indian Constitution and correlating with social media, and putting very, very important points in terms of the challenges we are facing right now about fake news, propaganda tools on this social media, digital arrest. So there are a lot of points are required actually to be properly reviewed, and also in terms of regulation is very, very important. We know that everything has plus and minuses, and that's why these programs like this is very important, because unless we are aware about the plus and minuses, we cannot leverage the benefits, we cannot become safe. And the real challenge is actually about the impact on the new generation, that children and young generation, because they are just very, very inspired about social media, about all the new gadgets, without understanding the side effects, without the missing the real life, the pleasure what we enjoyed in our time, that physically playing, what kind of the enjoyment you have, then just simply on the social media. we rightly mentioned that people are really suffering from the depression because those people who cannot do anything, they simply see their friends are having a lot of achievements and parties and all, and they feel, my God, I'm not doing anything. So they will see and then always feel the depression. So it has also plus minuses about all the aspect, but you are very clear that about that. You know very well, India being welfare state, and India must try that how to leverage the benefits in terms of Indian constitution, welfare state concept, and also how the social media, e-discovery, maybe AI, blockchain, social media, how it can really provide the ideas and interests of the Indian constitution, and then we can really extract real benefits. As I mentioned in the initial the speech that the boundary is really global, and that's why we must have global solution. But till today, on regulatory aspect, there is no common consensus globally, and the boundary is global, and we are very fond of applications. We are just rushing ahead without understanding the consequences, because as per the rule, anything goes on social media, it always remain on social media. You may go on deleting, but you don't know that how many people have shared and already actually consumed and saved and printed. You're not aware. So that's why the one strong message for all the participants is that please be careful while sharing anything on social media. Please be careful calling somebody. Please be careful giving data to anybody. And that's why it requires a lot of awareness in terms of the participants. So let me congratulate Mr. Kaviraj Singh and Dr. Meenakshi for really having the great events every year, and also trying to always cover very the emerging areas and inviting people who are really globally well known, maybe lawyers, judges, and all the speakers, and also recognizing all the people who are contributing in the legal world in terms of the awards and all. So let me thank all my fellow the panelists. Because of the paucity of time, we cannot go second round. Otherwise, it will take another 30 minutes. So let me thank the fellow speakers, Dr. V.P. Tiwari, this attorney Vasilio and attorney Jersa, for giving very actually innovative and strong ideas, and also suggesting us that how we can go to next level. With these few words, I thank my fellow panelists. Please give a big round of applause to all my fellow speakers, and also big applause to especially Dr. Kaviraj, Mr. Kaviraj, and Meenakshi for always having the great events. And also let me recognize the efforts of Babita. She was really following us from few weeks to that we must be here and speaking. So thank you, Babita, also. And let me thank all the organizing team, all of you, and wish you all the best. Thank you, all of you. Back to Babita.
Thank you, esteemed panelists, for taking the time out to join us today. I'd like to invite you to stay logged in and enjoy the award ceremony, which will commence shortly after the last panel discussion. With that being said, I'd like to quickly call upon the participants and the moderator for the last panel discussion, starting with the moderator, Mr. Gauhar Mirza.
We can leave now.
Yes, we can leave. We have the.
Thank you so much.
No problem.
Yeah, thank you. We can leave.
Hi, good evening, everyone. As I understand that we have less time, but we'll try our level best to kind of, do the justice to this panel. So we have witness determination of damages in arbitration. For that, I would request Mr. Gauhar Mirza, who's currently the partner at Cyril Amarchand Mangaldas, to come on stage, please. So he is an experienced advocate with history of working in arbitration, mediation, IT, and criminal law. And he's done a lot of arbitrations, domestic and internationally. I would also request Mr. Avnish Mishra, who's currently the Assistant General Manager Legal with Kirloskar Oil Engines Limited. He's a company secretary and a lawyer by profession, and he's worked with various companies in the past. And he's been recognized as one of the best legal counsels at various forums in India. Welcome, Avnish. And I would also request Mr. Namit Suri, who's currently the associate partner at Lex in this law office's AOR Supreme Court of India, to come on stage. Namit heads the litigation wing of the firm and brings loads of experience with respect to arbitration and various fields. He's been actively at Supreme Court and High Court of Delhi. So welcome, Namit. Thank you so much. Very basic question to all of you, but I'll start with Namit. You can just take the mic. Just wanted to understand that what's your thought process and take on the arbitration of 1996 versus 2019? What basic transformation you have seen from 1996 to 2019? Over to you, Namit.
Yeah, so I understand also the paucity of time which we are facing. So I'll quickly wrap it up in about 6-7 sentences. So the landscape of concept of damages has changed over the last 50 years. And I would, for the benefit of my audience, Hello? Yeah. Hello? Am I audible? Yeah. So for the benefit of my audience, I'll just quickly refer to 2-3 judgments which I think throw light as to how the concept of damages has changed, starting from Fateh Chand, Maula Bakhsh, and the latest, I would say, the Supreme Court on the issue is Kailashnath versus DDA. And as far as the concept of damages is concerned, today the sum named in the contract is not automatically payable, except as much as an individual who is alleging breach has to demonstrate before the courts or before the arbitrator that he has suffered loss. So this is how the law has changed, and earlier as to how people and how general population as to the fact used to understand loss has changed. Now each and every rupee which one claims towards recovery has to be demonstrated in the form of loss, except as much there are 2 circumstances and 2 exceptions. A, that you are able to demonstrate that the sum named in the contract is a genuine pre-estimate of damage, and for that also the burden is upon the person alleging breach. And second is that if you can demonstrate and plead to the effect that the nature of the contract is such that that damages cannot be proved in a given circumstance, that the court does come to your rescue. So these are the 2 exceptions. Thank you.
Yeah. So thank you, Namit. I would just bring the dice to Gauhar. So Gauhar, in your experience, and you've been a practicing advocate from inception when you did your law. So what is your take as a private practitioner from 1996 to 2019?
So I think, thank you for the question first. A lot has changed. In 1996, of course, it was at a very nascent stage. The biggest amendment that had come was in 2015, where the concept of automatic stay was removed. Prior to that, we had seen the judgments of Bhatia, Balco, etc., etc. So all those problems that had happened earlier, prior application of Part 1, Part 2, that was trying to be, in the legislature tried to take care of it in 2015. But 15 also, okay. And after 15, the major amendment came in 2019, where Part 1, Part 2 again was considered, and the distinguishing factor that whether a Section 9 can be filed with respect to international arbitration, etc., was introduced into the 19 Act. But as we all know that it's an ever-evolving space, ever-evolving law, we are still seeing a lot of changes to it. Recently, we have seen the latest bill that has come in, which is trying to bring in a lot of changes and adopt a lot of things from outside of India into the Indian system. So I think that is something to be seen. But yes, from 1996, where as a practitioner, I started my practice in 2010. But when we saw arbitrations in 2010 and what we see today, I think the numbers have increased. In 2010, we used to have 1 arbitration in a month, and today we have at least 2 arbitrations a day. So I think a lot has changed, and a lot has to be given to the law the changes that has been brought have been brought in. In the field of arbitration, at least what we see is that everybody is a stakeholder. The litigant is a stakeholder, government is a stakeholder, the practitioner is a stakeholder, the judiciary is a stakeholder. So I think everyone is just trying to contribute to it. That's, I think, what change I have seen.
Sure. Thank you so much. So Avnish, over to you. Just wanted to understand your thought process from the 1996 to 2019.
Thank you, Love. Good evening, everyone. So while my co-panelist talked about the evolution since inception of the Act and then how the things gets added to it and the way economies worldwide are evolving, I would like to throw some light on the best practices, what I have experienced, that how the technologies are being leveraged to address to these kind of challenges. More and more usage of technologies are coming into the play, using virtual forums for attending and having the meetings and setups are also being implemented. And what I've also seen that standardization of process and focus on improving efficiency has been increased. As you rightly pointed out, Gauhar, that now the cases are also coming because people are relying that, okay, this is the forum through which we could get the justice in real quick time rather than getting into the expensive litigation. So focus on process improvement and standardization also what I have seen. And one important and particular point is also that the greater reliance on the independent expert is also coming into the play, wherein the court arbitrators are relying on the independent expert to comment upon the subject matter. And also what I would like to say that like standard statistical modeling approach is also helping now the courts to conclude the quantum of the damages. It becomes very easy for them to apply a few of the statistical models which will give them proven result in terms of determining the quantum. So these are the few best practices I would say I have observed as and when we are evolving with this law. Thank you.
Thank you, Avnish. So Namit and Gauhar, I think you people are currently practicing professionals, and I want to understand specifically on the topic that whenever an award is being proceeded basis the hearings between the parties, how do you see determination of damages takes place, and what is the best practice you would actually inform your clients, because it has to be watertight, and if it's not watertight or it's not very concrete, then you can actually face a lot of challenges through appeals and everything. So what is your thought process on determining of the damages in an arbitration award, and what are the best practices which you can suggest as a practitioner?
So thank you for the question, Love. So I'll give an example of a real case which continues to be sub judice before the court, and how, as I indicated in my initial response, the concept of proving damages as understood by the common man has undergone a change. And there was this matter in which a very successful doctor working at a hospital was, as per him allegedly, illegally terminated, and he understood the fact that, and there was a lock-in clause in his contract, and he filed his claim and claimed the balance of the lock-in period as the amount of damages which he quantified that he would have suffered and has rather suffered on account of the illegal premature termination. And ultimately before the arbitrator, because as to how his counsels had understood laws, he just filed the claim on the basis of the balance lock-in to be the damages which he had suffered, without taking the pains and without actually leading evidence for the alternate employment which he would have actually tried to obtain, without leading evidence to mitigate loss, and simply understanding that the balance lock-in is the amount of damages which he would suffer. Unfortunately, the claim was turned down, declined, and he has challenges in a 34. So I would taking this as an example, would guide the audience sitting here that the best way to quantify damage today is to identify the loss, try and prove the loss through whatever evidence you can try and obtain, and ensure that you can come as close to proving the loss through the evidence as you have claimed in an arbitration through alternate employments, as in, for example, I'm referring to this case is concerned, or for in case where you say losses have suffered, you try and lead evidence to demonstrate as to the loss which you have suffered on account of the illegal termination, premature termination, so that the arbitrator has some basis, he has some cogent material, he has some evidence before him to grant you loss.
Would you just like to add on to what Namit has stated?
So I'll just pick on your question that what are the best practices that one should tell to the client. First is that an expert has to be taken very seriously and very, very efficiently. Expert is not somebody who is going to escalate your claim from 10 crores to 100 crores. That is the first mistake every client will do, that you first tell the expert that I want a 100 crore claim. That is the worst mistake that somebody does. That is one. Two is always try and get the tribunal to appoint an expert to get into the aspects of delay, quantum, etc., etc. So that's helpful, because then the concept of neutrality or impartiality comes in. Because when I lead an expert evidence and the other side leads an expert evidence, we will obviously cross-examine and try to break the expert's testimony. And that is again the process. It's like a fact witness. You bring in a fact witness, try to break his testimony and try to prove your own case. That entails loss of time, loss of money. Experts are very expensive. And ultimately the award, then again, it is to the same, you've gone back to the same place where you started. But if the tribunal, if the parties actually want an expert and a proper analysis of the claims and the counterclaims, which we are now seeing a small shift from days when parties used to just throw counterclaims at each other just because somebody has raised a claim of 10 crores, throw a claim of 20 crores just to counterbalance it. So I think that concept is also going away with the advent of the concept of experts being appointed by the tribunal. So I think the answer to your question is that if I am suggesting to my client about experts, I would say try and get it appointed by the tribunal itself.
Thanks for that. And just a follow-up question that, how typically damages are determined in a particular award? Let's say, for example, when you typically go to courts, you have to kind of, give a lot of evidence with respect to direct damages, a lot of cost, expenses which you have occurred. What about this thing in an arbitration, and what is the role of an expert over there?
So, Love, thank you for the follow-up. Firstly, there are few formulas that are applied. There is an Emden formula. There are various other formulas that experts use to apply to delays that have taken place. It is no one's case that if actually a matter has, a contract has taken, was going to take 1 year and has taken 3 years, 2 years have actually gone by. The machinery the contractor has taken there. The manpower is staying at the site. So the idling cost is there. The actual cost of idling is there. Now, how damages are seen is that the expert appoints a formula that from day 1 to day 365, this was the expense per day, and now the manpower and machinery is lying vacant. Can it be the same? Because it is not working. Suppose we have all seen the times of COVID where some projects were halted. Can we say that the machine was working and was the manpower working? The answer is no. But should the contractor not be compensated for the time that has gone into it, or the ownership cost that has gone into it? Every machine today, you see, Love, you are more aware. Big machines require a mechanism, requires maintenance, requires keep up, etc., etc. All that cost has to be calculated, and the damages expert gets into all of it. They take the universal formula and try to match it to the best possible extent in terms of your project. So I think that is how they calculate.
Sure, but specifically the Contract Act per se does not allow consequential damages, like you just mentioned about the timings and the cost and the loss of profit. Still, that would be a part of the determination in damages, or it will be as good as we are going in a court?
See, I think the arbitrator has to apply a very neutral formula to it. And as Arbitration Act provides for a mechanism where you can actually appoint the way the breaches, etc., have to be calculated. So first the liability has to be established, and then it comes to quantum and damages. Whether damages have to be established in terms of the Contract Act or not is something within the domain of the arbitrator.
And just to add to the point what he has mentioned while he talked about the application of the methodologies, I would say. So here the role of financial experts comes into the play. The experts from the field of economics, finance, and accounting, they plays a very vital role in terms of applying the various methodologies on the basis of documentations that they have, the parties have. And few of the procedures and few of the practices what I have seen across industries that loss of profit method also can be applied, wherein they would evaluate the profit what claimant would have had made if.
I think there's a problem with the teams because of the net.
Yeah, sorry.
No, please.
So loss of profit method wherein they will evaluate the profit what the claimant would have had made had there not been a breach. So that method can be adopted, and then at the same time a discounted cash flow method can also be evaluated and considered to consider the current position of future loss, whatever the claimant will occur in future, and that the independent expertise with the help of their objectivity and the analysis will add value to the arbitrators in taking the informed decision on the basis of factual data with the statistical modeling that definitely helps the arbitrator to decide upon a subject matter.
Sure. So one question to Namit. I'm sure you might have seen a lot of damages determination in an arbitration. And just to follow up Avnish and Gohar, KPMGs and ENYs and PwCs and all the big 6 or 4 of the world, I think many a times, they give you a different valuation, and one person's valuation would be something else, somebody else would be something else. And many a times this valuation is dependent upon the relationship between the parties. Correct. Right? So, as Gohar rightly said कि मुझे 100 करोड़ का claim चाहिए, आप मुझे बना के दो. So, I completely understand that it can be reasonable, but there's a lot of difference in the valuation. So, as an arbitrator, in case if you have acted as an arbitrator, or in case if you are an arbitrator typically appointed by a client, and you are representing to the client, how do you really come up to a conclusion that this is fair?
So, good question, thanks Love. I think one as a lawyer needs to stand away from the client, reasonably assess as to what is the evidence which the client has actually handed over to you in order to demonstrate that claim. And that's why, and I started with that the concept of being able to prove each and every penny which you claim is becoming realistic. People are realizing that the law is shifting towards being in a position to lead evidence, to claim whatever you seek to recover as loss, and that is where the role of a lawyer becomes critical, for him to step away from what the client is wanting to do, see what evidence he is handing over to you in order to demonstrate his loss, and then try and restrict him to and counsel him to and convince him that this is the only evidence which you have been able to procure and hand over to me, and this is the realistic amount which the court will be inclined to grant in your favor if you are to succeed. So therefore, there is no point in seeking to recover more than what you can demonstrate. And there's a recent judgment of Justice Kohli as a sitting Supreme Court judge that merely by averring a particular fact, you will not be able to demonstrate it. And even 104 of the Sakshi Adhiniyam, which was earlier the Indian Evidence Act, supports that fact that a person is required to demonstrate whatever he asserts before the court. So that's how your role as a lawyer becomes very critical in able to counsel your client that in the absence of evidence, you will be unable to succeed in a claim.
Thank you. Avnish, as you are an in-house counsel with Kirloskars in Pune, when you have to typically tell your organization institutional arbitration versus ad hoc, there are a lot of institutional, like you have MCI, ICC, and so on, and you have Indian arbitration institution as well, and the ad hoc arbitration, it would be done by some senior counsel or retired judge. So what, as a legal counsel, would you suggest them, and what measures you will take to ensure that this is cost effective?
No, thanks, Love. This is a really important question. Being an in-house counsel, we have to deal with these situations as and when it comes. So as rightly pointed out by you, if the item size of the contract under dispute, or if we are entering into a contract with foreign parties, then we tend to prefer a neutral jurisdiction wherein the international institutions comes into play, because they have standard set of norms, and the best part is there they acquire, I would say, the decision-making power from both the parties. Those are set norms. Of course, they are expensive, but the precedences are there. So we tend to get into the international arbitration when if the opportunity given for local players, we tend to evaluate the exposure, and on the basis of that, we determine that whether an ad hoc arbitrator, bench of arbitrator having 3 or 5, or one single arbitrator could serve the purpose. So on a case-to-case basis, we tend to evaluate, but with overseas parties and having big ticket agreements, we tend to prefer a neutral place for jurisdiction and having the arbitration with a renowned institutional partner.
So you're preferring institution over ad hoc. Gauhar and Namit, your take on institutional versus ad hoc?
I think the shift these days is towards institutional arbitration. There are 2-3 reasons to it. One is that you get the necessary administrative support that is required to conduct an arbitration. Second is, yes, the arbitrator is only then focusing on what he's supposed to do, that is decide, judge between the parties. So I think the rest of the job is taken care of by somebody else. Third is, what I have seen in my practical experience is that it gives some sort of systematic approach towards things. Because today, if I have to ask for an adjournment, I'm just telling you while we are discussing, and I've gotten a request for adjournment because it's an ad hoc arbitration. They've just sent an email, matter is tomorrow. They said, we can't come tomorrow, let's have it some other day. But if this is SIAC, or if this is ICC or any other institution, we get jitters these days to send a genuine request for adjournments. So I think that is very important. The general mentality of us litigators in India is that no difficulty, we'll get it pushed. But in institutional arbitration, there are costs involved, there are repercussions involved. So I think that is one.
Do they charge you in case if you postpone it?
It's not about that. It's not about that. But the arbitrators who've taken out 3 arbitrators, suppose it's a tribunal, and they have taken out specific time to do it, they have missed out an opportunity of doing some other matter or some other work. So they have lost it. I have I've seen, at least not faced, that an adjournment was made in a SIAC arbitration by the other side, and they had to pay the cost of the arbitration or that hearing. So I think those are the only essential elements that one sees as an advantage towards institutional arbitration. But it, of course, let's not discuss cons of it, but I think there are more pros than cons.
Namit, your take?
So absolutely, I think Gaur put it very well. And if I have to put it, I think the checks and balances which get added through an institutional arbitration far outweigh an ad hoc arbitration, and these checks and balances are the need of the hour, because there are examples, and there are plenty, that through the ad hoc mechanism the arbitrators have gone array, and there have been issues of costs, there have been issues of administrative expenses which have at times been charged more than the fee for carrying out the arbitration. So checks and balances are put in place through an institutional mechanism, and that also is reflected in a recent judgment of the Supreme Court in AFCONs. So I think this is a need of the hour, and
this is the way forward as far as India is concerned to ensure that it becomes an arbitration hub.
Absolutely. Thank you, Namit, Gauhar, and Avnish. I've been told that we have less time, but I would really open it for question and answers. I think we only have 5 minutes. And yes, please, please. Can you give mic to her, please? Sure. Yeah.
Because that's not clear to me, like how are consequential damages viewed in arbitrations? Because I would think that contracts get disputed in arbitrations, and if the Contract Act does not provide for consequential losses, then that would also extend to an arbitration proceeding. So if I'm going as a company and claiming damages, then can I also ask for consequential damages?
So the answer your question has a direct answer, which is that if you can demonstrate that it's a proximate consequential damages and it was a consequence of breach. So there is a proximate damage which I'm likely to suffer, and I'll explain it through an example. If let's say that I illegally terminate a contract and there's a value of sum which is required to be recovered as a loss. Now there is some part which is towards salary, which obviously you have suffered and is direct and consequential.
Correct.
You don't need to sort of lead an extensive evidence to demonstrate that your past pay slips will form as the foundation to claim the future amount towards damages. So that's consequential upon a breach. But let's say if you are to seek some benefits as an employee which you were promised or which you were getting, now those are not consequential. Those you were enjoying as an employee in the organization. Now if you are to seek that also towards damages, those may be inconsequential and may be indirect. So your burden of proof will rise to demonstrate that amount towards damages.
So can we say that to some extent it depends on the discretion of the arbitrators?
Absolutely.
Of the view they'll take of whether it's consequential or direct?
So I would say it depends on both. The kind of evidence you have led to demonstrate whether that damage is consequential or not, and also the arbitrator to have accepted your claim as a consequential damage. So it depends on both your ability to prove that fact and the ability of the arbitrator to appreciate that this particular loss is directly proportional to the breach having been occurred.
Understood. Great question.
However, when the arbitration suit is filed or the proceeding is started, I'm claiming consequential loss. Does the arbitrator have the authority to set the contractual understanding aside? There's evidence that I've suffered consequential loss.
So unfortunately, the answer is no, for the only reason that he is the creature of the contract. He can't go beyond it.
If the question is, can somebody raise such a claim? Answer is yes. Will the arbitrator give it? The answer is yes and no. And to respond to your earlier question, consequences, I'll give you a slightly different example. For example, I bid for a contract and I got a tender for 1 year. And that contract got terminated within 2 months. And I missed out on an opportunity to bid for another tender. And I mobilized all my resources towards one. Now the arbitrator will then have to see that the termination that has been caused by the other side has actually caused so much loss to me that I have missed an opportunity to have worked instead of on this project, another project, and earn that amount. That is something the arbitrator can go into. So it's not a bar that consequences cannot be claimed, but circumstances also have to be seen.
Got it, helps. So still needs to be seen at our end. What does the Contract Act really like? What are the kind of examples that it's talking
Correct. But it cannot be that I say that you terminated my contract and I was to get a contract on Mars.
Yeah,
so that
yeah.
is hypothetical.
Absurd. So something really absurd.
Correct.
And my next question to you all is, how many of your arbitration awards do you see getting challenged? Because
Honest answer you want?
Yes.
Every award.
So then, what is the advantage of it?
Advantage is that we as practitioners, we are at a very advantageous position, to be very candid.
Yeah.
But see, we have to also see the quality of awards that we are getting. Some awards are so perverse that on the look of it, you will advise your client that you have to go and challenge it. I have faced it personally that I have asked my client not to challenge it, and they went to another law firm. So that's what happens. The client wants to challenge it. It's more of a human tendency that a loss cannot be absorbed properly.
Understood.
I'll put you to another example. For example, a PSU or a government agency, if somebody says, okay, let's accept the award, somebody will lose their job. Even after 5-10 years, there will be a CVC inquiry or a auditor's inquiry. That person will be held that how did you allow this award to be? So it's a very practical problem. It is not as if the law doesn't provide for it. Law is trying to curtail it as much as possible. The judiciary is trying to curtail it as much as possible. 34 scope has been reduced to the most minimalistic thing. Today, when a client comes to me, I am really at pains to tell them what all they have to go through to get even a notice issued in an arbitration, in a challenge petition. But since we are in business, and suppose you are a startup, I recently am doing a matter for a startup, their entire cap value is 100 crores. Award came against them for 125 crores. How will they pay it? So you have to challenge it, right? It's a practical issue.
Yes,
so
I am not putting arbitration in any of my startup agreements. So
that's up to you. Then you'll have to suffer court fee in case you have a case. But
well,
I think
that is a consideration.
Litigations are also not easy. If you think that litigations are easy, they are more worst. So many a times I'll tell you specifically from a multinational perspective that if you have arbitration, you have a lot of confidentiality maintained. Yes. You actually sit in the room, the arbitration happens and it closes. So many a times, you have to see a different side of it, because in case if you're a listed company, or in case if you are a company which is, trying to start up, or, if people get to know about your cases, you'll be exposed. And I'm not very sure that how you'll be able to cope up with the things which you've already done with a lot of efforts, hard efforts and everything. So arbitration can be very, very helpful. The only thing is that you need the right counsels, you need the right advisors, and specifically this, this session was about, determination of claim, how you put up your claim. Like, they were talking about that, I want 100 crore claim. Let's be realistic. And when you talk about consequential, I think both of them very categorically mentioned that you should be able to prove and you should be able to substantiate and show cause that much real damages you have suffered. Otherwise, typically it will keep on challenging, and it's a problem for both the parties. But let me tell you, if you have an award which is very considerate and the other party understands that, he does not have a good case, I'm sure that person will not challenge, neither you will challenge. So there are pros and cons, but, it depends upon how you take it.
And the last question, if I can, because it's a great panel. How many of these arbitrations that you're doing are really happening in front of SEAC? If you're to determine a percentage, arbitrations in India to arbitrations in SEAC or say London or...
So every institution is loaded. SEAC is overloaded because they started a little earlier. Today, if you see Indian institutions like DIAC, Delhi International Arbitration Center, it's overloaded. And we have so many arbitrators, so many matters going on. So if you want to talk about statistics or numbers,
I'm saying how many of how active are we as lawyers in India in these international arbitration?
Very active. You see, I'll give you an example that earlier in few years ago, you must not have seen so much of interest towards India. Now, if there is a conference in India, like we have the Delhi Arbitration Week in Delhi,
Yeah.
You see so many international arbitration firms coming in. I work at a law firm and we get a lot of meeting requests. The amount of meeting requests we are getting from foreign law firms to come to meet us and try to collaborate, work together, it's immense. And I have seen it personally in the last 14 years. It is only increasing. So it shows that yes, we are involved. As Indian practitioners, as firms, we have a lot of work in SIAC, ICC, etc.
So you have directors of SIAC sitting in India, Delhi and Mumbai, and they are representing, so you can call them up. But the only thing is that, you know, there's that, I understand what you're, where you're coming from. See, you also need to understand the value of your contract. If the value is too low, I don't think so SIAC, LCI would be actually, LCI is very expensive.
No, I am asking because I'm interested in...
No, so that's what I'm trying to say, that, you know, if you talk about a startup or the value of the contract is low, then it really is not feasible. You have Indian institutions who can do a lot of good job. But if you talk about ICC, SIAC, LCI, they are expensive and, you know, the quality also differ. But they're very active. They're very active.
When the investors come in, they almost always ask for, as a neutral forum, a SIAC or an SICC. So even if you're a startup and even if you're taking a deposit through the convertible note route, you don't have a choice. You need that money to stay alive for another year.
True.
You will say, I will sign up to litigation in America also.
True.
You don't think that much. You sign the paper.
America is more expensive. It's better. SIAC and LCI is far more better. They'll charge you $400. They'll charge you $400 an hour. So, so thank you. If we don't have, I think the time's up, right? Yes, sir. Yeah. So thank you all the panelists. Thank you Avnish, Gauhar, and Amit for your insightful conversation. I'm sorry we had less time, but you did all your job well. Thank you.
A big thanks to all our panelists. As we celebrate this momentous occasion of 75th Constitution Day, we also take this opportunity to recognize the outstanding contributions of individuals who have dedicated their lives to legal profession. These individuals have demonstrated exceptional commitment, expertise, and passion for upholding the principles of justice and equality. Our awardees today are shining examples of excellence in the legal profession. They have made significant contributions to the development of our legal system, and their work has had a profound impact on the lives of countless individuals and communities. Let's give a warm welcome to Honorable Ms. Justice Rekha Palli ma'am and Dr. Retired Justice Sangeeta Rigra Sehgal ma'am, who will be presenting the awards to our outstanding awardees. They will be joining us shortly.